Ah, I'd be nice to you, Sarah P. Just saying how wonderful you were, but I can't repeat it. I can't repeat it. So I was just saying, I'm trying to do some commands, and they don't seem to work. I have done commands so that well, you guys can try it. Try if you guys try the exclamation mark and then hello. Somebody could try that. It should work, but it doesn't. Or exclamation mark hey. But for whatever reason, it's not working anyway. We'll try and fix that as and when. How are you all doing? How is everybody? My laptop's struggling this morning. Your laptop sounds like you, Sarah P. Nah, it doesn't work, Katie, does it? It's bullshit. I don't know why it's not working. It's complete BS. I really don't understand it. I've spent all morning doing it. Not all morning, but I've spent a long time doing stuff. Hello, Rhonda. How are you doing, my darling? Sorry I didn't respond to you last night, Rhonda. But once you start saying hello to people in chat, you're done. So, but I did see you. I hope you're doing well, my darling. We were over in Erica's stream. We got questions. What if I try another command? Thank you, Sarah. Please welcome everybody. Welcome in. What if I try another command then? Can I do commands? Yeah, they're all here, so I don't really get it. Everyone can do them, yes. Let me copy it. Let's see if that works. That way. No, it doesn't do it. I'm going to try and work on this again then, people. It doesn't work. Dave. Oh, here we go. It works. It works, people. It works. There you go. You see? It worked. I got, yes, let's frigging go. More than three-eyed fish. Oh, I don't see three-eyed catfish. Where's three-eyed catfish? I don't see them. Hang on, maybe, I'm not on live. There you go. It's just a bit slow. Hello. No worries, three-eyed catfish. I've seen, you weren't on live with me, so hope you're doing well, three-eyed. You've got your grandbabies today, but we'll keep you spinning. Thank you very much, my darling. Right, no, that I don't think that one does. Hang on, let's have a look to see what the other ones are. I think there are some that tag you back. No, I don't think they do. So hang on, you can do that. We can do this. This is exciting. I like this. I already like this. Where's it gone? I've lost it already. Hang on. It's here. Sorry, I'm having that. So if I put welcome in, there you go. Welcome to the stream. Please like the stream on the way in, and now join your fellow weirdos and nosy bitches in the chat. So that works. Sarah P, if I put in this, right? So this is for the mods more than anybody. If you put in if you put in exclamation mark tip, it should bring up the wait for it. It brings up the that brings up PayPal, Sarah P. And if you do Sarah P, if you do this saves you so much time, Sarah P. I've just done your work for you. If you put in hashtag donate Sarah P, that takes you to buy me coffee links. Well, when it does come up. There you go, that works. I was just trying to help you out, Sarah P. because I know you're a lazy bitch. So, Lady Di, good morning to you. Don't worry at all, my darling. I got to actually, I have a phone call with my doctor at, I believe, 3 o'clock as well. So I'll have to dart off a little bit as well. But I hope your husband has good news today. And yeah, be nice to him, be gentle to him, obviously, as always. Looks like AI is not taking my YouTube job. No, you still got the links, but if you take a note of these, therapy, it just means you could put these in. So sparingly, you know, if you feel like it anytime, you just put in tip or donate, and it'll come up throughout the stream. And every 15 minutes, I think Streamlabs bot will say subscribe, remind people to subscribe and like the video as well. So I'm just playing about with it. But yeah, if anyone ever wants the links for Buy Me Coffee or PayPal, it's there. I haven't done one for Amazon. So you still got that job, Sarah P. Still got that job going for you. Yeah, everything's okay. Yeah. Oh yeah, I'm just because I have to see my doctor because I think it's a nurse because of my surgery. They want to meet with me because of my surgery. I'm having a endoscope sinus surgery, and because you have to go under anaesthetic or whatever you call it, local anaesthetic, whatever they pull you out. They have to have a meeting with you to discuss everything to make sure you're healthy enough and stuff. He likes listening to you because you make him feel better, like me. You see, so Mr. Lady Di, just so you know, the shit that you get from your wife is the same shit that I get off her as well every day. So I will always be team you, and I will always abuse her, because she gives me plenty of shit. So I am sympathetic to you. So. Yes, RP. I'll let you know all the links for these, but they're good, aren't they? They're good. Right. The stream. No, the stream's not started yet. So, they've not started yet. He's laughing. Good. He knows the truth. We speak the truth, Lady Di. So yeah, we are. I can't see any. I'm starting to get into this Streamlabs thing now. I'm starting to get into it. I was literally here for a few hours, and I was so pissed off when it wouldn't work this morning. But now it's working, so it's good. So, and also, you guys can do the same commands as well. I've set it up so everyone can do the same commands. So, commands, KD, sorry. In some chats is command like nosy, then he will say KD is 100% nosy or something like that. I'm not sure if someone can explain that. No, I know there's some. I've got some here that hang on, let me get it here. If I do this is one of them. Hang on, KD. Oh shit, I just pressed the wrong button. Get the right button. Where's it gone? I also just remember I'm still getting used to this. Lurk. So that's one of them. I don't know what this is. So whenever you're going for a break, you can just put in lurk. If you go in somewhere, that looks like it says me pussy, Lady Di is now lurking. They will be missed. And the hug one, I don't know what the hug one does. Unless you have to tag somebody, I have no idea. And this one as well, I've only just started it, so, you know, I will do more and more, you know. These streamers nicer and says, I will be missed. I need to change that, actually, yeah. That cannot be the truth. I cannot do that for you. Uptime. The stream has been live for offline. Okay. Okay. Katie's now lurking. They will be missed. I mean, we need to stop this. They will be missed business. That's a lie. Stop it. Stop lying to the people. Streamlabs. Sarah P's pissed right now. She's pissed. She's like, they do taking over my job. Sarah, you'll never lose your job, my darling. Oh, I can change it. Hang on. Me, okay, the stream's on, but they're not in court yet. Okay, I'll stop messing about with it because they're about to go live. I can change the meanings of stuff as well, so that's good. Fucking bot. No, you still got your job, but it's supposed to help you, Sarah P. I just always try to help you as well. Right, hang on. Court. It's still. Okay, we can't hear anything yet, but let me set it up then. Ready. A is taking over everyone's jobs. We should take over my job, it'd be quite cool. Right. I'll move myself up here. I'll play about with it. There's so much more I can do with it. It's just I don't understand it, if that makes sense. So I need to do some bits on it. Put that down there. But we'll get there. Oh, Rhonda's lurking. Rhonda will be missed. You still got some bits. Sarah P's got a lot of bits. But also, it's just a matter of Sarah P doing hashtag tip, hashtag donate. It's easier for her, but she's still got to give everyone a welcome. So. Lurk means, say you're going to go somewhere, Rhonda, and you want people to know, just put in lurk, and it comes up as Rhonda is now lurking, they will be missed. So say you have to go or take a phone call, you can just put lurk instead of saying I'll be back later or something like that. That's all there is. That's all there is. Anyway, that excitement. I will do more of them. I just need time to do everything. That's a bit of excitement for today. We're back to this trial now. We are live on day 2. I didn't see any of the first 2 witnesses. I don't know what happened there. But the defense attorney was fined, contempt in court was fined $1,000 yesterday. So he had until 9 a.m. this morning to pay that $1,000. So there is that. There is that. It was quite testy yesterday with the openings. There's a lot of objections in the openings. And the judge does not wear a robe, we found out. She's a bit of a lazy bitch, we found out. I think they're in court because we can hear whispering, but they're not live as of yet. But they will be in a little bit. I will be, as I say, I will be lurking myself at around 3 p.m. or just before then. So, but I'll be around. Streamlabs bot will be in charge, obviously, because they do all the work now instead of Sarah P. So now Lady Di is going into lurk mode because Mr. Lady Di needs to do some stuff in the hospital. I will change that. I don't like it when it says they will be missed. I will change that. I might say they will be you will be missed unless this is KD and Lady Di or Bex or something like that. So come on, court, let's go. Some courts are really good starting on time and others are not so good. It seems this court is not very good so far. The jury were asked to be back by 9 this morning. She aims to have lunch between 12 and 12:30, and it doesn't seem to be any limits on when she will finish at night. They finished earlier last night, she said, because somebody had an appointment, but that was like 4:45. So it deems that she will probably go on a little bit later. Morning, Yaya. Hello, Yaya. How are you? Hope you're doing well, Yaya Trucker. Excuse me. So just remember, this is a, 25-year cold case. The defense are going after the ex-boyfriend. The prosecution are obviously going after the defendants. So this is going to be interesting. We did not watch any of the pre-trial hearings, so we don't know what's been allowed in, what hasn't. There's been a lot of arguments already about some statements that the defense have made and also the prosecution have made. So I don't know. Trying to stay warm. I'm sorry if it's cold there. Not good. So, well, let's do a singing song once we wait. Everybody, let's put your hands up in the air so we keep warm. Everybody, yeah, rock your body, yeah. Everybody, rock your body right. Back streets back, alright. Bow, 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 bow. Sherry Berry! Sherry Berry is here. Hello, Sherry. I miss Sherry. I've not seen Sherry for a while. I caught a glimpse of you as well in Erica's chat, but we did chat on live, and yeah, I saw you afterwards. You were watching Erica. We got questions last night. -3, jeepers. My nips would be all hard if it was -3 here. My nips are fairly hard, but they're not like -3 hard. Hope you're doing well, Sherry. Hope everything's good with you, my darling. I love the fact I'm wearing a Patriots hat at the minute. Sherry likes my hats, but I wear a Patriots one because we got a Super Bowl build up on Sunday. So go Pats. That's what we're doing. That's what we're watching, and then I'll mix in my other hats then, my Scally hats after that. So yeah, just a reminder, we have got some, new commands in the chat as well. So it's called Quiet in Court now. I'm not sure if you guys could hear them. I could hear a little bit of whispering, but they've gone quiet. Oh, they're back. So I'm not sure if they're a sidebar or if they're just like talking at their desks or not. I don't know. But this is interesting because obviously a cold case. Now also, obviously, trigger warning because some people get offended very easy. They do talk about anal sex and things of sexual nature. So if you're a prude and don't like stuff like that, then this probably won't be the stream for you because apparently that is some of the key components of this trial, allegedly. Go Pats, let's go, Rhonda. Yeah, if you do an exclamation mark and type in LURK and press enter, it'll tell us all that you're lurking. Enjoying the stream, everyone? Hit the subscribe and like button to help me out, please. That is an automated one that comes up every 15 minutes. So basically, it's just doing what Sarah P does. But obviously better, that's all, you know. Sarah P is raging right now. This house is divided for the fame. I'll be interested. It'll be interesting. It will be interesting. Hello, Christine. How are you doing, my darling? Nice to see you, as always. Hope you do well, Fortunato. I don't know what the delay is. Oh, for the game, yeah. Fine. So, where are you? Are you Pat, Sherry, or what are you? Because are you originally from Illinois? Or is it... There you go, Yaya. Yaya truckers now lurking. They will be missed. So, when you lurk, you just put that in. And we know that you've gone to do something. So, that's good. I like it. Also, just a reminder, we've only had 2 witnesses, by the way, and I don't know what any of them said because I did not watch it. But only 2 witnesses so far. Dave said something that who did he say? That the defense attorney was regarded as one of the best in the state or something? You were the youngest on the part. Happy days, Sherry. Happy days. How many children have you got, Sherry? I don't think I know that. So yeah, I don't know how many children you have. Sarah P's happy. San Francisco Bang Bang. They got some new coaches now as well. Oh, can you all
good morning,
hear
Mr.
that?
Cruz.
Oh, here we go.
Counsel for the state. Good morning. Y'all ready?
You all ready for this?
Okay.
I think this will speed up our process this morning.
All right.
Just a couple of things. Our first witness this morning is going to be the medical examiner.
Oh, fuck.
And so part of his presentation, I intend to elicit testimony about his opinion as to how some of the injuries to Ms. Baker may have been inflicted. And in so doing, I have what is very clearly not a real knife. So I just didn't want the court to freak out that I was, so just putting that out there. Second of all, we also would tend to introduce the autopsy report. I have 2 copies of it. The reason I bring this up is that it does list 2 names as suspects on that report, neither of which are either Mr. Melton or Mr. Faust. Since this trial has very clearly zeroed in on those 2 individuals, I've prepared a redacted version because I think otherwise we get into issues that might confuse or mislead the jury, and so it would be the state's preference to tender the redacted version. But I would.
All right. Mr. Cruz, any comment on the state's proposal?
In regards to the fake knife, no. I think the most appropriate thing is wait till they attempt to introduce. If I have any objections, I'll make the objection at that time, Your Honor.
All right. Thank you. All right. I'll allow you to introduce the redacted portion since there's been no objection. All right. Anything else from the state before we bring the jury in?
No, I reserved my objection. I didn't say I didn't have any objection. Once they attempt to introduce, if I have an objection, I'll make the objection at that time.
You're certainly entitled to do that, but for now, in terms of allowing the redacted version in, you haven't made an objection, so I'm going to allow it in. If you want to object when it comes in, you certainly have the right to do that. All right. Thank you. Anything from the defense before we bring the jury in?
No, ma'am.
All right. Thank you. You may bring the jury in.
Okay. It's just weird the judge is not wearing... She does look nice. It's just weird that she's not wearing a robe, you know? I've seen a couple of judges not wear robes, but I don't know. You just expect the judge to wear a robe. Do you know what I mean? Anyway, I'll shut up. We're going for it.
All right, thank you, everyone. You may be seated. All right, ladies and gentlemen, good morning. Thank you for being here on time. As instructed, we're ready to begin again with regard to the State of Georgia versus Edrick Lamont Faust, SU 24 CR 0547. Is the state ready to proceed?
Your Honor.
Is the defense ready to proceed?
Yes, ma'am.
All right, thank you. Mr. Bolden, you may call your next witness.
Dr. Andrew Falzon.
Could you get Andrew Falzon, please?
What I love about this channel is that we've only been live for like 20 minutes or whatever. We've already lost a subscriber. Morning, Robin G. Hello to you, my darling. Hope you're well. Let's get
Sir,
ready
if you
to
could raise your right hand, please. Do you swear or affirm your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God? You can have a seat. Sir, if you could state and spell your name for the record, please.
Sure. My name is Andrew. Last name is Falzon. Falzon.
And, sir, where are you currently employed?
I am currently employed as a consultant pathologist with Mater Dei Hospital in Malta, Europe.
And what are your role, or what do you do as a consultant forensic pathologist there?
I oversee a pathology lab, one of the satellite labs on a separate island, and I also provide forensic services to the hospital.
Can you tell the jury a little bit about your prior employment before working at the hospital in Malta?
So I started as a associate medical examiner with the state of Georgia, with the GBI in Decatur, Georgia. That was from 1999 to 2001. After that, I was the assistant medical examiner for Middlesex County, New Jersey. And then when my chief retired, I became the chief medical examiner for the county. And I then took over the chief state medical examiner position for the state of New Jersey.
Throughout your career, has it been part of your job to conduct autopsies
Sure.
when requested by law enforcement or otherwise?
Yes.
Approximately, if you know, over the course of your career, how many autopsies have you performed?
Over 3,500 post-mortem examinations.
Can you speak a little bit to your professional experience?
I graduated as a doctor of medicine and surgery from the University of Malta. I did a rotating internship there. I then started a master's degree program at the University of Mississippi Medical Center, and I graduated with a master's degree in anatomy in '92. I then enrolled in a pathology, anatomic and clinical pathology residency program at the University of Mississippi, and following that I did a one-year fellowship in forensic pathology at the University of Alabama, Birmingham.
Have you also had an occasion to teach in the area of pathology and forensic pathology?
Yes, it did.
Can you speak just briefly to that, sir?
I usually, whichever locality I'm working at, I teach forensic pathology to various classes, usually undergrad classes.
Do you serve on any boards, sir?
As the chief state med examiner, I served on the domestic violence fatality near fatality review board, and also the Child Fatality Review Board, both the State Board and the Suicide Subcommittee. I still serve on the Suicide Subcommittee of the Child Fatality Review Board.
Again, briefly, do you have trainings and certifications in the area of forensic pathology?
Once I completed my training in pathology, I took the American Board of Pathology certifying exams. I am board certified in anatomic, clinical, and forensic pathology.
Have you spoken at conferences related to the area of forensic pathology?
I've presented at mainly at the National Association of Medical Examiners meeting, on any research that myself or the office was conducting.
And have you previously testified in court before as an expert in the area of forensic pathology?
Yes, I have.
Do you know how many times?
Over 100 times, mainly in the state of New Jersey, but also in the state of Georgia.
Your Honor, at this time, the state would tender Dr. Falzon as an expert in the area of forensic pathology.
All right, any objection by the defense, or would you like to voir dire the witness?
No objection, Your Honor.
All right, thank you. This witness is declared an expert in the area of forensic pathology. You may continue.
Thank you, Your Honor. Dr. Falzon, I'd like to turn your attention back to January the 20th of 2001. Just to be clear, where were you working at that time, sir?
At that time, I was working with the Georgia Bureau of Investigation in Decatur, Georgia.
And on that date, did you have the occasion to perform an autopsy on the body of Tara Baker?
Yes, I did.
Can you describe briefly the condition in which the body was received?
The body was received enclosed in a black body bag, and the body, to my recollection, was that she was unclad, she didn't have any clothes on her, and it was extremely charred.
Do you take steps to ensure that the person you are performing the autopsy on matches the, I guess, submission from law enforcement, I guess?
Yes, I do.
Okay. At the time, do you recall, or would you have noted receiving any historical or case information related to the request for the autopsy?
Typically we would receive that. I haven't seen any copies of those recently, so I don't recall exactly.
Okay. Can you tell us briefly what an autopsy consists of?
An autopsy is a post-mortem examination, typically performed to establish the cause and manner of death. We would start by reviewing the history surrounding the case. Then we'd move on to the examination of the body. Certain cases, we would do x-rays prior to actually starting the examination. Then you describe the clothing, remove the clothing, collect any trace evidence if indicated, and then you start the external examination, the examination of the body from head to toe, front and back. Once that is documented and you look for any injuries, document those, take the necessary photographs, then you move on to an internal examination whereby we do an incision across the chest and abdomen, remove the organs of the chest and the abdomen. We'll make an incision across the top of the scalp, remove the skull cap, examine the brain, and then finally we'd examine the neck organs. During the course of the autopsy, we'll also collect specimens for toxicology and DNA as indicated.
You also take photographs while the autopsy is being conducted?
Correct.
And is it common practice to reduce the findings of your autopsy in the form of a written report?
Yes.
Dr. Falzon, I'm going to hand you what's been marked as State's Exhibit 1. Do you recognize that, sir?
Yes, I do.
What is State's Exhibit 1?
It is a copy of the autopsy report drafted and signed by myself.
And is that the autopsy related to the case involving Tara Baker?
Correct.
I'd move to tender State's 1 at this time, Your Honor.
Any objection, Mr. Cruz?
No, ma'am.
It is admitted.
Dr. Falzon, I'm going to go through your report kind of sequentially as it's outlined in State's Exhibit 1. Let's talk a little bit about the receipt of the body. I think I kind of just touched on this earlier, but if you could speak to what your report reflects as to how the body was received.
Correct. The body bag was, there were tags affixed to the body bag zipper that had the case information relevant to this case.
Can you speak generally to, you mentioned an external examination. We're going to try and take it in order. What was the first thing that you did with Ms. Baker as it relates to that external examination?
Photographs would have been taken, and then overall assessment of the body, the charring, the degree of rigor mortis, and the stiffening of the muscles that happened post-mortem, any lividity, the settling of blood in the dependent areas, general observations.
Let's talk a little bit about the injuries that you noted to Ms. Baker's body, starting with those on the head and neck, sir. Can you describe those in general?
The injuries on the head and neck were mainly in the form of blunt force injuries. When we describe injuries, there's three main categories: blunt force injuries that are caused by a blunt instrument, whether that be a fist, a piece of wood, a hammer. Those are all blunt force injuries. There's sharp force injuries that are caused by objects with a cutting edge. Could be a knife, could be a shard of glass. And then there's gunshot wounds. In the case of Ms. Baker, she had multiple blunt force injuries, mainly in the form of bruises around the eyes, the right and left sides of the head, and on the neck. She also had, on the neck, she also had a stab wound on the right lower front of the neck, and she had a ligature mark that surrounded the neck.
Okay. Specifically as it relates to the stab wound, can you describe in a little bit more detail what you observed?
The stab wound, like I said, was on the right lower front. When I describe a stab wound, typically I will imagine the face of a clock overlying the wound. And in this case, the wound was oriented between the 10 o'clock and the 4 o'clock on the lower front of the neck.
Okay. You also mentioned a ligature mark encircling Ms. Baker's neck. Can you speak a little bit more to that, please?
Yes. The ligature mark completely encircled the neck. It had one mark on the back of the neck and two marks on the front, which indicated that the ligature had been wrapped around the neck, crossed over in the front, and the ligature held on the sides.
Did you note any other injuries to Ms. Baker's neck?
She had some blunt force injuries to the neck. Not sure if there was something specific here. If I may look at the report. She had contusions, bruises below on the left ear, below the left ear, and behind the left ear.
Moving, and we'll come back to that momentarily, Dr. Falzon. Did your external examination of Ms. Baker also include injuries to her torso?
It did, yes.
And again, I'm going to ask you to briefly summarize the extent of those injuries that you observed.
The injuries to the torso were mainly in the genital and anal areas.
Can you go into a little bit more detail about those injuries, sir?
Again, there were in the form of blunt force injuries, bruising, bruising on the right side of her vulva down to the posterior aspect of the vulva, and she also had a bruise that completely encircled the anal region.
And lastly, Dr. Falzon, did you note any injuries to Ms. Baker's extremities?
Yes, I did.
And what were those?
Those were mainly in the form of sharp force injuries, injuries caused by a cutting instrument, and they were limited to the back of her hand, which could be classified as defensive type injuries, the injuries that a person would sustain trying to ward off an attack.
Did part of your internal examination of Ms. Baker include examination of the organs of the neck?
Yes, I did.
And particularly, what, if anything, did you observe in that part of the internal examination of Ms. Baker?
As part of the examination of the neck structures, we look at the bones and the cartilages that make up the neck. One of the bones that we have in the neck is called the hyoid bone. It's a C-shaped bone that sits above the larynx. With cases of strangulation, we often see fractures in the hyoid bone. In the case of Ms. Baker, there were fractures on both the right and left sides of the hyoid bone.
And based on your training and experience, sir, what, if any, significance did you attribute to your observation as it related to Ms. Baker's broken hyoid bone?
That was part of the strangulation process.
Dr. Falzon, you mentioned that as part of the autopsy, you do take photographs.
Correct.
Bear with me just a second, Dr. Falzon.
May?
Dr. Falzon, I'm going to show you what's been labeled Exhibits 2 through 7. We're going to finish labeling them the rest of the photos here in just a moment. But if you could take a look at, again, states 2 through 7. Do you recognize those, sir?
I do.
Are those states exhibits 2 through 7 fair and accurate representations of the autopsy that you described of Ms. Baker back on January 20th, 2001?
Yes, they are.
Move to tender states 2 through 7.
Any objection, Mr. Cruz?
No, ma'am.
They are admitted.
And again, I realize this is a little cumbersome. If I can approach again.
You may.
This, Dr. Falzon, is states 8 through 14. Same question. Take your time. Take your time. See if you recognize those. And then one last group.
You may.
This is states 15 through 22. Last time. States, I believe, 8 through 22, are those also all true and accurate depictions of your observations of Ms. Baker's body as you observed her at the autopsy on January 20th, 2001?
They are.
Move to tender states 8 through, well, let me just start back, 22 through 22.
All right. Well, 2 through 7 have been admitted, so we're now on 8 through 22.
8 through 22.
All right. Mr. Cruz, any objection?
No, ma'am.
They are admitted.
If I can publish those to the jury at this time.
And how are you planning on doing that? Just handing them to them? Okay. So that's what I'm asking. So we've had a prior ruling. Thank you. So just for any red and black persons who may be here under Rule 22 with a photo opportunity that the court granted, the Rule 22 has been amended to prohibit the media from taking any photographs or videos, of course, of these particular photos that the state is going to introduce to the jury. So if you can turn, thank you for doing that. I saw you turn your camera off. If anyone is here from the red and black pursuant to Rule 22, if you would please not photograph. Go ahead, Mr. Baldwin.
Your Honor, and I think the court may have
That's
to
right.
switch. So, Dr. Falzon, you should have a monitor down there to your right. Okay. Dr. Falzon, we're going to start with State's Exhibit 2. What is State's Exhibit 2, sir?
It's a photograph of the body of Miss Baker as received, and it depicts the face, the torso from the chest down to the hip area, and the upper extremities.
State's Exhibit 3, same question.
This would depict the lower aspect of Ms. Baker from the upper chest, including the lower extremities, and you can see the charring of the body in this photograph.
State's Exhibit 4. we see here, sir?
This is a photograph of the face of Ms. Baker, showing a degree of charring and also the blunt force injuries that I alluded to prior, notably the bruising around the eyes.
State's Exhibit 5. Is that just a slightly different angle of her face?
Correct. It's a slightly closer up view of the face.
Same question as it relates to State's Exhibit 6.
Again, closer up view, focusing mainly on the right eye.
State's Exhibit 7.
This depicts the left side of the face, and there's again charring, and you can see there's a braided laceration, kind of like a U-shaped, inverted U-shaped lesion on the left side of the chin.
State's Exhibit 8.
Okay. This is a photograph depicting the left side of the face, neck, and the left shoulder, and you can see the ligature mark on the posterior aspect of the neck.
State's Exhibit 9, is that just kind of a closer up photograph of what you just described?
Correct, and you can see the single linear mark that extends over the posterior neck, and you can also see the bruising behind the left ear.
This is State's Exhibit 10. What do we see here, Dr. Falzon?
It's a photograph of the neck aspect. You could see the ligature mark on the top, which is an electric cord, and you can see the plug aspect, the prongs on the left-hand side of the photograph.
And Dr. Falzon, I think you can actually, if it would be helpful, the screen in front of you, you can touch and circle things. Just to clarify what you just described as it relates to the ligature, and I think Your Honor might have to, Mr. Dickey explained that there's a yes. All right. So you've made some drawings on
the U-shaped, I need to erase that. Okay. But so I'm marking here the cord, and that's the prong aspect and the plug attached to the cord there.
in this photograph, is the stab wound that you previously described also identifiable in this photograph?
That would be...
Right. Thank you, sir. State's Exhibit 11. What do we see here, sir?
Again, you see the cord here. Difficult to see because it's...
And the circle at the end, is that the
That's the end of the
plug to the
plug, yeah.
It's Exhibit 12. What is What are we seeing here, Dr. Falzon?
It's the front of the neck. Again, there was extensive charring, and there was a lot of smeared, dried blood on the skin. But you could see the stab wound, and the stab wound had what we refer to as the blunt edge and the sharp edge. When you have a knife, obviously you have a cutting edge of the knife, and the back, the non-cutting part of the blade, and they both leave kind of distinct characteristics. But this would be the blunt end there at the back. So you see the blunt end on the, I guess, on the right-hand side of the body, with the sharp edge more directed towards the middle of the body.
We'll come back to that later, Dr. Falzon, but I'm going to move on for now. This is State's Exhibit 13. Is that just a slightly different angle of the stab wound that you just described?
Correct.
State's Exhibit 14, particularly on Ms. Baker's left shoulder. Did you reach any conclusions about that area where there's no charring, sir, if that question makes sense?
Right. It looks like an area of what we'd call sparing. There's no soot and charring on that area, and most likely that was where the plug was resting, kind of like protecting the skin from the soot deposition.
State's Exhibit 15. Is that just a slightly different picture of different angle of
Correct. Closer up view.
what we just described? Okay. Okay. These are where it gets even tougher. State's Exhibit 16, Dr. Falzon, what is this photograph?
That's a photograph depicting Ms. Baker's genital area. You can see the bruising. The above, this would be kind of like an area of charring, heat damage. So this is not part of the injury she sustained while she was alive. But you can also see the bruising around the introitus, the entryway to the vagina.
And we're going to follow up on that with State's Exhibit 17. And again, I apologize. State's Exhibit 17, what is this a photograph of, Dr. Falzon?
This is a slightly different angle of the anal-vaginal area. You could see a bruising that completely surrounds the anus, which would be this area here. And then you see the bruising on the right-hand side and the posterior aspect of the introitus, the entrance into the vagina.
State's Exhibit 18, is that just a slightly different angle of the last photograph, sir?
Correct.
We're almost done. State's Exhibit 19, shifting gears. What are we looking at here, sir?
This is a photograph of the back of Miss Baker's left hand.
State's Exhibit 20, is that just a slightly different viewpoint of that left hand?
Correct, and it's showing what we refer to as an incised wound. With sharp force injuries, you can have stab wounds where the knife is actually penetrates, the blade penetrates into the body, or you can have an incised wound where the cutting edge is dragged along the surface of the skin. This here is an incised wound that we see, that area there.
State's Exhibit 21. Again, are we just kind of looking at that same left hand, sir?
Correct, and you can also see there's another incised wound, another cut in the web space between the fourth and fifth fingers. So that would be that area there.
And then finally, State's Exhibit 22. Is that just a picture of the ligature that you previously described after it had been removed from Ms. Baker's body?
Correct.
Dr. Falzon, I want to first talk about the injuries that you've described and the photos that we've seen in Ms. Baker's genital area. And you've described those, and we've seen the photographs. Based on your training and experience, coupled with your observations of that area of Ms. Baker's body, what, if any, significance can you attribute to the causation of those injuries?
Those would be caused by sexual intercourse with force used. As it relates, and then I realize I'm jumping around a little bit, as it relates to your observations with regards to the ligature and Ms. Baker's, the fact that her hyoid bone had been broken, and again, based on your training and experience, what, if any, significance do you attribute to the causation of those injuries? So the injuries on the neck that we saw from the cord and the fractures of the hyoid bone would be the result of strangulation, ligature strangulation.
And then Dr. Falzon, as it relates to your observations of the stab wound that you've previously described on Ms. Baker's neck and the wounds, which I believe you previously referred to as defensive type wounds to her left hand, do you have, and again, based on your training and experience, do you have an opinion as to the mechanism by which those injuries may have occurred?
Those would be sharp force injuries inflicted by a knife. Just to expand on the stab wound, because we described the injury on the skin, but once the internal examination is performed, there was actually injury to the internal jugular vein on the right side, which is the main vein that drains blood from the right side of the brain, which would explain the amount of hemorrhage, the blood on Ms. Baker's skin. And that would have been caused by a knife.
Okay. And did you, were you able to form an opinion as to how that stab wound may have been inflicted?
Given the orientation, the location, and the orientation of the wound, as part of the assessment of the stab wound, I also try to ascertain the direction in which the stab wound was penetrated into the body. So in case of the stab wound that we saw on Ms. Baker's right neck, the knife entered through the skin and it went from front to back, downwards and to the left. In my experience, that has often been due to somebody being stabbed with the perpetrator standing behind the victim and forcing the knife into the body cavity like that. And
again, referring to your observations as to the incised wounds on Ms. Baker's left hand, what, if anything, do those wounds tell you about what you just referenced?
Those would indicate that Ms. Baker would have been in the process of trying to protect herself from the stabbing while it was being performed.
Would it be helpful to the jury to kind of demonstrate what you've just described, sir?
Yes.
Well, Your Honor, is it okay if I ask Dr. Falzon to step down into the welcome?
That's fine.
Dr. Falzon, I'm going to hand you what is very clearly a rubber knife. And I'm going to be Ms. Baker. And so what you just described on the stand, sir, if you could kind of describe or show exactly what you just said.
So the entry wound would have been somewhere here. So with holding the knife like this, the blunt end would be at the 10 o'clock position, and the sharp end would be at the 4 o'clock position like that.
And again, as it relates to the injuries to the hand, how would that, in your estimation, have occurred?
So if she was trying to hold on, that would explain the cut on the space between the fourth and the fifth finger. Again, the direction would be front to back, downwards, and to the left.
Thank you, sir. You guys back in. Dr. Falzon, based on everything that we've talked about, well, actually, I want to back up just a little bit. Did your autopsy of Ms. Baker reveal anything as it related to her larynx?
She did, yes, I did examine the larynx, the voice box where the vocal cords sit, and she did have a slight amount of soot present below the vocal cords.
And did you also, as part of this autopsy, request or refer Ms. Baker's blood be tested for the presence of carboxyhemoglobin?
Yes, I did.
And are you familiar with the results of that report?
Yes, I am.
And what was that?
I believe it was between 6 and 14%. I may have to jog my memory. I gave you back the report, but.
Now, let's talk a little bit about carboxyhemoglobin.
Okay.
What is that, sir?
Hemoglobin is a molecule that transports oxygen. It picks up oxygen in the lungs, takes it and deposits it in the periphery of the body, and it picks up carbon dioxide and releases that back in the lungs during respiration. Now, when as part of the fire, carbon monoxide is formed. So carbon dioxide is carbon with 2 oxygens. Carbon monoxide is carbon with 1 oxygen. Carbon monoxide tends to attach somewhat more strongly to the hemoglobin molecule, and it actually prevents hemoglobin from transporting oxygen. So when somebody is exposed to a fire, we test the blood for carboxyhemoglobin, which is essentially hemoglobin attached to a carbon monoxide molecule.
And so based on your observations of soot being deposited below Ms. Baker's voice box and the results of the carboxyhemoglobin test that you just described and testified to, is that significant in any way to you, in your opinion, doctor?
The level of carboxyhemoglobin was not high enough to be considered a cause of death. Typically, we expect carboxyhemoglobin to be more than 50%. People who smoke tend to have, elevated carboxyhemoglobin levels. But in the case of Ms. Baker, the presence of the soot below the vocal cords and the slightly elevated carboxyhemoglobin level would indicate that she was still alive when the fire was set.
Thank you, Dr. Falzon. So again, just to summarize everything that you've testified to thus far, were you able to form an opinion as to the cause of death of Ms. Baker?
Yes, I did.
What was that opinion?
So she died of a ligature strangulation and a stab wound of the neck. I also described the bruising on the head, the blunt force trauma of the head. As part of the internal examination, I did examine the brain, and there was some subarachnoid hemorrhage on the surface of the brain. So the other contributory factor would be blunt force trauma of the head.
Did you rule the manner of death, Ms. Baker's death, a homicide?
Yes, I did.
Overruled.
Dr. Falzon, you mentioned that part of a autopsy may include taking an X-ray or radiograph if there is evidence of a stab wound. Did I understand that correctly?
Correct.
Why do you do that?
When somebody is stabbed, the
Yes, sir.
Relevance. It's undisputed that Ms. Baker was stabbed.
All right, Mr. Bolden, do you care to respond to the objection?
Trying to allow Dr. Falzon to testify to everything that was done as part of Ms. Baker's autopsy.
I'm going to overrule the objection. You may continue.
That's for the same courtesy during our examination, Your Honor.
I'm sorry, Mr. Cruz. What do you mean by that?
We just asked for the same courtesy that the Honorable State has received.
When there is an objection made, I will rule on it. Mr. Bolden, you may continue.
Thank you, Your Honor. Do you also obtain a sample of Ms. Baker's blood?
yes, I do.
What is the purpose of that?
That would be performed to collect the specimens to submit for testing for toxicology.
And is a blood spot filter card also submitted?
Yes.
And
All right. I'm going to sustain that objection, Mr. Bolden, if you'll rephrase.
okay, I will rephrase it, Your Honor. What other physical evidence is, I guess, obtained or submitted as part of an autopsy?
To establish a reference point for DNA testing, a blood spot filter card is prepared whereby we take a filter paper card and we put drops of the victim's blood that is air dried and then submitted for analysis.
Was a sexual assault kit obtained in this case?
Yes, it was.
Can you explain briefly what we mean by a sexual assault kit?
A sexual assault kit has various components to it which help in collecting evidence in cases where sexual assault is suspected. It would have swabs to collect DNA. It would have slides whereby we smear the swabs and prepare smears to look at on a microscope. It would have nail clippers to clip nails and envelopes, put those nail clippings in. And it would also have envelopes for head samples of head hair, pubic hair, and pubic hair combings.
And I apologize if you mentioned this already, but when you're talking about swabs, from where on Ms. Baker's body were those swabs obtained?
Swabs are taken from the mouth, oral swabs, from the vagina, and from the anus.
And again, I apologize if I just misheard. You mentioned smears as well. How are those smears created?
The smears are created from the swabs. So we put a Q-tip with a cotton tipped end, and that would be inserted in the cavity, the oral cavity, the vagina, the anus. Once fluid is absorbed onto the cotton tip, while it is still wet, we would take the glass slide and smear the tip of the Q-tip on that slide to prepare the smear.
Your Honor, we have a motion.
All right. Ladies and gentlemen, I'm going to ask that you go into the jury room. Don't discuss the case. This is a good time for a bathroom break. We will be with you shortly. Y'all may be seated. Thank you. Mr. Cruz, your motion, sir?
Well, I want to do the simple thing first. We have an objection to the known pubic hair of a victim. Exhibit 31 is empty. So that's empty.
Your objection is to Exhibit 31.
Correct. But I do
Okay.
have a motion.
No, but I want to hear your objection, and then you can make your other motion. Go ahead.
I believe the purpose of showing this to Dr. Falzone is for the purposes of identifying items that he collected ever here tonight. So to object to the state is simply giving Dr. Falzone back as a
Okay.
all the other items from the ones that we observed from the inside, they had items. They had items that we don't object to those. But we do have a motion.
All right, well, let Mr. Bolden respond to your objection on Exhibit 31. Go ahead, sir.
Well, Your Honor, I mean, I can show Dr. Falzone we can open it. And, I mean, I guess the objection is the fact that it's empty and somehow that makes it inadmissible. I don't know that that's the case. I don't know that I know how to respond to that particular objection.
I can make it clear. It's confusing. The pubic hair, relevant for his testimony. An empty bag that just says pubic hair is irrelevant in this case. That's what we're objecting to, the ground that we are objecting on.
All right, Mr. Bolden, do you care to respond to the objection about relevancy?
Again, I think the fact that Dr. Falzone has testified that pubic hairs were taken, why don't we let him look at it? Because Mr. Cruz is assertion that it's empty. I honestly have not opened the bag, so let's allow him to do it. We can do that momentarily. I'd like to hear the motion. Sure.
All right, that's fine. We'll hold off on Exhibit 31's objection. Go ahead, sir.
We're moving to suppress the oral swabs due to chain of custody. In this case, it has been stated that oral swabs, vaginal swabs, and anal swabs were taken. We have the chain of custody report. The chain of custody report says that only 2 oral swabs were taken. I assumed that was pretty much an error on the chain of on the custodian, because Ms. Bigham, 2024, conducted a test on these swabs, and it was determined. They went to a company in California to do this test, and that's something we'll address on cross-examination instead of using the company here in Georgia. But that company came back and said, you know what? We did this presumptive test. These are actually vaginal swabs. However, now that I'm seeing the original packaging that Dr. Falzone put these items in, and please correct me if I am mistaken, a vaginal swab wasn't taken. Ma'am? Where's the brown boxes? Madam President, I'd like to show the report, State Exhibit 28. State Exhibit 29.
I don't know that I need to see the exhibits at this moment. I want to hear your objection about you're asking the court to suppress certain
I would
things.
ask
Tell me
the
that.
court to suppress the, I'm asking for 2 things.
Okay.
I'm asking the court to suppress, I believe it's oral swab B. Let me confirm which swab it is, Your Honor. Course indulgence. So one of these are labeled as item 2I. Court, give me a second to identify item 2I. swabbing B is labeled as item 2I, as in igloo. Oral swabbing A is labeled as item 2J, as in joy. So, Your Honor, on November 4th, 2024, and mind you, this wasn't a discovery, by the way. But on November 4th, 2024, Pure Gold Forensics.
Okay, hang on just a minute, Mr. Cruz. Let me ask you this question. Are you making a motion to suppress?
I am.
Okay.
But this is based on knowledge I just learned just now going over these exhibits. So this isn't a motion that was untimely because I knew about it 10 days from around. I just learned this here today.
All right, let me stop you right there just for a moment. Is there any response to the motion to suppress as opposed to a motion in limine or an objection based on something else? Go ahead.
Yes, I would object to this being characterized as a motion to suppress. Mr. Cruz, we've had hearings going back for months. We've discussed making any physical evidence available to him to inspect, and we would have done so at any time. He never asked. He asked in court, but never followed up with that. This evidence we would have gladly shared with Mr. Cruz at any point had he actually asked, which he did not. I don't think what he's asking for this morning, well, again, I don't know a motion to suppress at this point. I don't know what legal grounds he's asking that it be suppressed. He mentioned chain of custody. I think that argument is more of a weight versus admissibility issue. It's very hard to respond when I don't understand exactly what is being asked of the court.
All right, thank you. Mr. Cruz, let me ask you this question. With regard to this motion you're making now, is it, as you stated earlier, about the issue of the chain of custody?
Correct.
All right. I'm making a ruling right now that that is not a motion to suppress issue. You are entitled to cross-examine this witness or any witnesses with regard to the chain of custody, and I'm not going to allow it.
Judge,
If you have an objection to something else about the admission of this evidence, I will hear it.
Judge, motion to suppress, motion in limine, the phrasing is irrelevant.
No, it is not, Mr. Cruz.
Well, forgive me, Your Honor. The state, when the chain of custody issue is raised, the state has the burden to show that that this evidence is the same evidence that was collected and that it wasn't tampered with. The issue we have is that both of these items from Dr. Falzone, both of these items were collected by him and labeled by him. There's going to be testimony in this trial 24 years later that, actually, one of these is a vaginal swab. Dr. Falzone, as you've heard from his testimony, is very careful. He's very diligent. It sounds like he takes his time and does his work the right way. So we're moving for the state to either show a chain of custody for these items, meet their burden to show a chain of custody for these items, and that they were not tampered with, or we ask the Honorable Court to exclude any mention that oral swabbing B is a vaginal swab, because from what I'm seeing for the first time today in court, it is not. Your Honor.
All right, Mr. Cruz, I'm going to overrule your objection, and I'm going to deny your motion, and I'm going to make the statement that the complaint that you're making in the form of an objection and the request to make a motion is certainly appropriately addressed by cross-examination. You have every right to cross-examine any witness with regard to chain of custody, with regard to the issues of tampering, anything that is relevant to the evidence that's being offered. You have every right to cross-examine with regard to those issues. And so that's the reason I'm denying your objection. And if there are any other objections to the admission of that evidence, I want to hear it now. I want to address one more thing before we bring the jury back. Any other objections to the admission of that? I mean, I haven't ruled that admissible yet. We haven't made there hasn't been a proffer. But if you have something that you'd like to object to now that you know about, so you can do that.
We will stand by our chain of custody motion.
All right, thank you. I do want to make a comment, Mr. Cruz, and this is really for all parties, but it's related to the comment that you made a little bit earlier. You did not make an objection, but you stated something to the effect of we're asking the court to extend us the same courtesy. My comment to all parties, but particularly to you with regard to that comment, is this. That comment about the court's behavior is not appropriate in the manner in which you said it. The court makes rulings of law, not courtesies. The court extended, Mr. Cruz, you a courtesy this morning when you were 20 minutes late. I knew why you were late, and I extended you that courtesy. That's a courtesy. But in terms of this trial and in terms of making comments in front of the jury, the only appropriate comments to be made are not comments. They are objections. They are proper examination questions, cross-examination questions, things of that nature. And the court will respond to proper objections. Any comment on the courtesies of the court or fairness or things of that nature that are not in the form of objections need to be made outside the presence of the jury. And that's my statement.
Yes, ma'am.
Thank you. Anything else before we bring the jury back in?
Your Honor, if we could have just maybe a minute for us to take a restroom break.
All right. Why don't we be off the record until 11:15? That's about 12 minutes. All right. We'll be in recess until then. Thank you.
fucking piece of shit. Oh, fuck. Right. Right. I was just saying hello to Erin Hack. Hello, everybody. I've only just done the commands, Erin Hack, so I will let you know what the commands are in chat later. There's only a few we've done so far. They are uptime, lurk, hug, hello, welcome, tip, donate, and you have to put a thing in front of them. So you have to put a that thing exclamation mark. So I just tried them today, but Katie just done one, and she says, "Hello, KDD, you nosy bitch. Welcome to the stream, and please join the other weirdos in the chat." So there you go. So yeah, there's only a few. It's just if anybody wants to, obviously put some stuff in, but that's the Streamlabs mod thing does not restrict anybody, doesn't time anyone out, doesn't do anything, just commands, and every 15 minutes we'll say, please remember to like and subscribe. That's it. Hello, Erin Hack, you nosy bitch. Welcome to the stream, and please join the other weirdos in the chat. There you go. This stream has been live or offline. I don't know what that means. I might take that one off then. And he says, welcome to the stream. Please like the stream on the way in, and now join your fellow weirdos and nosy bitches in the chat. Donate. So donate takes you to buy me a coffee, and tip takes you to PayPal. So there you go. That's where that takes you to, and everything should come up on the screen. So if you buy a coffee, it comes up on the screen. If you buy a PayPal, it comes up on the screen. Everything. My chat about Rocky. No, sorry, I'll go back up. I did see that you're here. Rocky be good. Hang on, where's Rocky here? Hang on, let me do two things at once, which is always a bad thing for me. Right, hang on, I'm here now. Also, I just found out that, the stream we were doing in North Carolina, the 15-year-old that killed 5 people in a shootout. They told me that they weren't going to do the sentencing live, but they are doing it live today, bastards. So I might try and play that at some point as well, because that'll be quite interesting to see. But he did plead guilty already, so I decided to make banana bread for my mum. That's nice. Made the batter, went to the bathroom, came back, Rocky pulled it off the kitchen island, and I was fucking full of batter everywhere on him and the kitchen. That's funny though. You can't be nasty to Rocky. Rocky's a legend. I love Rocky. Rocky be good. Rocky's too cute. Too cute. So there you go, and the tip, yes. So I will put the list for you mods as well, so you're aware of them as well. Hey, Mark Cunningham, sorry, I saw your chat yesterday about hate Mel. She's not been in touch with me, so I've not been able to get hold of her yet. So, yeah. I hope she's okay. Yeah, so I'll do more commands as well for you guys. But hey Keith, how you doing, fella? The Streamlab mod will not do anything in terms of the chat, as in it will not time anyone out. The only person who will time out is Sarah P. And it will not restrict people's language or anything like that. It's just these commands. So, and it should help if people want the link. It should help. Yep, thanks, Marky. I don't know what, Yeah, I don't want to push you with her, but if she doesn't want to, that's fine. But I'd love to be able to get in touch with her. I've not seen her for ages now, and I'd love to be able to say hello to her. So yeah, so we have that. So I'm not sure what I'm going to do. I'm losing the plot right now. This trial is what BK's trial would have been like. So I've missed every witness so far. I've missed every single witness. So I don't know what's going on in this trial. So I need to I need the chat to catch me up. What's going on? Why is Badazza and Dave not in here? Is he not saucy enough for them or something? So I don't know. We're back, right? Shut up, Dylan.
thank you. You may bring the jury in.
Oh, the jury coming in. She is a very smart judge, but I just wish she wore a robe. Like Keith, I know you're. This is Keith's judge. This is.
All right.
It's Gina DNA. That's it. Too many flaws in that. Judge has scolded the defense attorney again. Oh, again? Why? Did he get another fine? Right, I'm going to shut up anyway. As they come in. Mexi. Purple. Mexi, we commands.
Did you issue a ruling on our objection to the empty pubic hair package, or no?
Hang on 1 second. I thought that I had said it. I was overruling your objection. Maybe I didn't make that clear. I'm sorry, Mr. Cruz. I'm overruling the objection. All right. If you have any other objections to the introduction of evidence, you may make them. I haven't ruled them admissible at this point. The state hasn't proffered them in that way. So if you have any other objections, you certainly can offer them.
Yes, ma'am. But on that ground,
Yes, sir. Yes, sir. All right. Thank you. You may bring the jury. Please be seated. Mr. Bolden?
Thank you, Your Honor. Excuse me, Dr. Falzon. I think we were talking about the collection of the sexual assault kit. Is that right?
correct.
Okay. I am going to, if I may approach the witness, Your Honor. I think, Dr. Falzon, this is State's Exhibits 23 through 33. That's all right. You want the loves, Dr. Falzon?
Sure.
Dr. Falzon, let's start with State's Exhibit 23.
Yes.
What is that, sir?
It's a clear plastic box with a label marked with the case information, and it's marked fingernails left hand.
And would that be the fingernail clippings that you took from Ms. Baker's body on January the 20th, 2001?
Correct.
Move to tender States 23, Your Honor.
Any objection?
No, ma'am.
It is admitted.
States Exhibit 24, Doctor, what is that?
It's a clear plastic bag sealed with evidence tape. There's two clear plastic boxes, each one with a label with the case information. One is marked toenails right and the other one toenails left.
Again, same question as before. Are those related to the autopsy that you've been describing this morning?
Correct.
How do you know that, sir?
Each one has a label on them. with the decedent's name, Clark County, the age, race, and sex, and the unique case identifying number assigned to this case.
Move to tender States 24, Your Honor.
Any objection?
No, ma'am. I won't have any objections to any of those outside of the objection I already put on the record.
All right, thank you. Number 24 is admitted, and you may proceed, Mr. Bolden.
States 25, Dr. Falzon, what is that?
25, it's a white paper envelope sealed with evidence tape, and the label with the case information, and this one is marked oral swabbings B.
And again, same question. Is that related to the autopsy that you performed on Ms. Baker on January 20th, 2001?
It is.
Move to tender States 25, Your Honor.
All right, and based on Mr. Cruz's assertion, is that right, sir, that there's no objection?
Outside of my prior objection.
All right. Then it is admitted. Thank you. And that's number 26?
25.
25.
All right, 25. Thank you. Go ahead.
States Exhibit 26. What is that, Doctor?
Same white envelope with evidence tape and the unique case identification information, and this one is marked oral swabbings A.
Move to tender States 20. Now I've forgotten. 26, Your Honor.
26. Mr. Cruz, any objections, sir? All right, it is admitted.
States Exhibit 27, Dr. Falzon. What is that?
White envelope, red evidence tape, label with the unique case information, and this one is marked rectal swabbings.
Move to tender States 27.
Mr. Cruz, any objections, sir?
No, ma'am.
It is admitted.
States 28. What is that, Dr. Falzon?
State Exhibit 28 is a brown cardboard folder, has a label marked with the unique case identification information, and this one is labeled anorectal swab.
Move to tender States 28.
Any objections, sir?
No, ma'am.
It is admitted.
States 29, Dr. Falzon. What is that?
29, again, is a cardboard folder with the unique identification label, and this is marked oral swab.
Move to tender States 29.
Any objection, Mr. Cruz?
No, ma'am.
It is admitted.
That was 29, yes.
29, is that right, Dr.
Yeah,
Falzon?
yeah.
Okay, good. States 30, what is that?
30 is a white cardboard box, again marked with the label with the unique case information, and this one is marked vaginal smear.
Move to tender States 30.
Any objection, Mr. Cruz?
No, ma'am.
It is admitted.
States 31. What is that, Doctor?
A clear plastic envelope with the label with the case information, and this one is marked known pubic hair of victim.
Move to tender States 31.
Any objection, Mr. Cruz?
Yes, ma'am. The same objection I put on the record.
All right, and thank you. Any further comment by the state? All right, I'm going to overrule your objection. Your objection is noted. It is admitted over objection.
States 33. Dr. Falzon, what is that?
33 is a clear plastic envelope marked with the case information, and this is the pubic combings of victim.
Move to tender States 33, Your Honor.
Mr. Cruz, any objection?
No, ma'am.
It is admitted.
Is that everything that I handed you?
Did we do 32?
Oh, 32? Did I skip that? I apologize. States 32. I got ahead of myself. What is States 32?
Clear plastic bag marked with case information, and this is marked known head hair of victim.
Move to tender States 32, Your Honor.
Any objection, Mr. Cruz?
No, ma'am.
It is admitted.
Thank you, sir. I'm going to not go through all of those pieces of evidence, Dr. Falzon, but I want to start. This is States 30. There's the sticker. I think I can zoom in. States 30. Again, what is that, sir?
This is a cardboard folder and marked with the case information, and this would contain the glass slides with the smears of the vaginal, taken by the vaginal swab.
How would or was States Exhibit 30 created?
The first we do the swab. So, like I mentioned, you have the Q-tip swab, that we insert into the orifice, in this case the vagina, to collect the fluids on the swab. Once that is removed, we take the glass slide and we rub the cotton tip across the glass slide to transfer cells from the Q-tip onto the smear, onto the slide, and thus creating a smear.
Thank you, sir. Then this is State 28. Again, I'm just going to show you the back. That has the sticker, then I'm going to flip it over. What is States 28?
That again would be the anorectal swab. Actually, this would be a glass slide, so that would be the smear.
And would that have been created in the same manner that you just described for the vaginal smears?
Correct. So the swab would be inserted into the anorectal orifice, collect the fluid from that area, and then transfer it onto the smear, onto the glass slides.
And last, same question for States 29. I'm just showing the sticker there. What is States 29, just to be clear?
That would be the oral swab. Again, this would be the smear made from the oral swab.
So let's talk a little bit about the swabs. I'm going to start with States 25, which has been admitted into evidence. States 25, what is that?
It's marked oral swabbings B.
Okay. And then just for clarification, States 26, what are we looking at there?
This is marked oral swabbings A.
Dr. Falzon, I realize it's been a long time since this. I guess let me ask the question this way. Would you have collected two different sets of oral swabs back in 2001?
No.
What, if anything, can you attribute to the fact that two of those are labeled oral swabs and there is not one labeled vaginal swabs?
The swabs are collected during the course of the autopsy. As indicated in the report, I collected oral, anal, and vaginal swabs. Once the swabs are collected, as soon as they are removed, we take the swab tip and create the smear. So the swab is prepared, the smear is prepared, the smear is packaged. Because the swab is moist, if it is packaged right away, because of the moisture, mold grows on the tips of the cotton tips of the swabs. So the swabs have to be air dried prior to packaging. Every autopsy, the doctor has an assistant to help with the case. So the swabs would be placed in a small cabinet marked with the name, and it would be marked oral, anal, and vaginal. And the technician would package those swabs once they have air dried and package and label those.
Was that common policy and procedure at the crime lab back in 2001?
It was.
Bear with me, Dr. Falzon. I did want to go back and ask a few more questions about the fact that Ms. Baker had a broken hyoid bone, and you described what that bone is. Can you talk just a little bit more about the hyoid bone in general in a young person like Ms. Baker?
The hyoid bone, like I said, is a C-shaped bone that sits just above the voice box. Initially, the bone is a little bit pliable. Young people have softer bones. As we grow older, that bone starts to get more calcified and become more brittle. So in younger people, you're less likely to see fractures of the hyoid bone as opposed to older people. But again, in this case, there were fractures both on the right and the left-hand side of the hyoid bone.
And based on that observation and your knowledge of that part of the human anatomy, do you have an opinion as to the amount of force that would have been necessary to break that bone?
It was a significant amount of force.
And to follow up on that a little bit more, Dr. Falzon, you've described the ligature previously and the ligature marks on Ms. Baker. Now, with the hyoid bone as well, do you have an opinion as to, and again, taking into account all of your observations from Ms. Baker's autopsy, do you have an opinion as to the manner in which that strangulation with the ligature occurred?
Like I said earlier, the ligature encircled the entire neck, so it passed from behind, looped in the front, and then the ends of the ligature held on each side.
And anything about the existence of those defensive wounds on Ms. Baker's left hand that we previously described, is that significant in any way as to your findings related to the ligature?
I wouldn't say to the ligature. It's more in relationship to the
stabbing.
wound.
I understand. Dr. Falzon, those are all the questions I have for now. Mr. Cruz will have some questions, sir.
Mr. Cruz, cross-examination.
Thank you, Your Honor. May I move the podium, please?
You may, absolutely.
Thank you. Good morning, Dr. Falzone.
Morning.
My name is Attorney Ahmad Cruz. I have the privilege and honor of representing Mr. Edrick Faust. Do you recall you and I speaking previously?
I do.
Okay. Would you agree with the statement that Ms. Baker had a height of approximately 69 inches and weighed 113 pounds?
Correct.
Is it fair to state that Ms. Baker's earlobes were each pierced with a stud-type earring with a clear stone in each earlobe?
Correct.
Is it fair to say that Ms. Baker had blunt force trauma to the head?
Correct.
And you previously admitted that you took photographs of Ms. Baker's condition. Is that fair?
Correct.
Okay. I'd like to show you what would be marked as Defense Exhibit 5. May I approach?
Your Honor, I would ask that Mr. Cruz show me the exhibit before he...
That's correct.
May I approach him?
Okay.
Is that photograph a fair and accurate depiction of Ms. Baker as you saw her?
Yes, it is.
Okay. Does that photograph, does that photograph appear to be altered in any way?
Not to my recollection. I can't say that I think it's an alter. No.
That is fair. Are those injuries consistent with the injuries that you witnessed on Ms. Baker?
They are.
Okay. Your Honor, I would move to admit Defense Exhibit 5 into evidence.
Any objection?
No, Your Honor.
It is admitted.
May I approach Dr. Falzone? Dr. Falzone, you stated in your autopsy report that contusions also surround the anal region. Is that correct?
Correct.
And you identified the contusion as a 4.5 by 7 centimeter contusion that surrounds the anus. Is that accurate?
Correct.
I'd like to show you what would be marked as Defense Exhibit 6. Let the record reflect that I am showing the state what has been marked as Defense Exhibit 6. May I approach the witness, Your Honor? Let the record reflect that I've provided Dr. Falzone with Defense Exhibit 6. Dr. Falzone, do you recognize those photographs?
Yes, you do.
Okay. Is it fair to describe that there are 2 photographs of Ms. Baker's anus and 1 photograph of Ms. Baker's upper body, chest to head?
Correct.
Would you agree that the contusions that surround the anus support that Ms. Baker was sexually assaulted anally?
Yes.
May I approach? Okay. Oh, here. Your Honor, I move to admit Defense Exhibit 6 into evidence.
Any objection?
No, Your Honor.
It is admitted.
And I would like to publish Defense Exhibit 6 to the jury. And just to make sure sure we're clear. These are photos of her anus and her upper body. Is that right?
Correct.
The state spoke with you about the packaging on state's exhibit. May I see those exhibits? Are those the exhibits that were introduced? On State's Exhibit 25 and State's Exhibit 26. And may I approach the witness, Your Honor?
May.
Just to refresh you on what those are. And you recognize these from direct examination, correct?
Correct.
Okay. You stated that the way that these are packaged, and please stop me at any time if I say it wrong, I just want to confirm that I heard you correctly, that you get a vaginal swab, you then make a smear out of it, but because mold may get on the swab if you leave it out, mold may get on the swab because it's wet, you leave it out to air dry, and then a technician would package it up later. Is that correct? Did I understand it correctly?
That's correct.
Okay. The question I have for you, does no one check the technician when he labels or she labels the items to ensure accuracy?
Not to my knowledge, no.
Okay. So, Dr. Falzone, is it possible I'll ask you this way. If no one checks, how do we ensure what's in either package?
It should have O, A, and V in front of each and every swab, the respective swab.
If it's checked.
Obviously, it wasn't done correctly in this case.
Correct. Are you aware that it is extremely important to collect and store swabs a certain way if DNA is involved?
Correct.
Okay. And is it fair to say that if it's done incorrectly, it could affect the results of any subsequent DNA testing of those items?
Absolutely.
Okay. In regards to the way that the swabbing takes place, for oral swabs, if you remember, did you do swabbing of the lips, the cheeks together, or is that something you would do individually?
It would be done individually. So we would put the swabs in the space between the cheek and the teeth, and then insert it into the mouth, or into the oral cavity.
So one swab would start with teeth. Say that again one more time. I'm sorry.
In the space between the cheek and the teeth, and then insert it into the oral cavity itself.
Okay, but we don't do the area in front of the teeth and the lip.
No.
Okay. So teeth and cheek and oral cavity, I'm assuming, is just
inside the mouth.
Excellent. Thank you. In regards to the stabbing, I believe the state. Can I use your knife? I believe the state asked you to do a demonstration of your opinion of the way the stabbing took place.
Correct.
Is that the only way Ms. Baker's stabbing could have occurred?
Given the direction of the wound, that is the most plausible explanation for that. I don't know if you had any other, explanations that I could assess as to whether they're plausible or not.
Well, I may have one.
Okay.
But the question that I'm asking now is the demonstration that that was performed on direct. Is that the only way that the stabbing could have happened?
I mean, there could be other ways. I mean, if you had a left-handed individual,
So I'm left-handed, face to face, and if I was to do it this way, we would get the same result.
Essentially, yes.
Right. Court's indulgence, Your Honor.
I forgot. I really didn't unmute myself again. Dave did tell me about the stream. He did tell me about the stream yesterday. So thank you to Dave. However, as I say, the North Carolina one is being streamed. The sentence isn't being streamed.
Exhibit 7? Yes. Okay, thank you. Dr. Falzone, I'd like to show you Defense Exhibit 7 and Defense Exhibit 8. May I approach the witness, Your Honor? Let the record reflect that I'm showing Dr. Falzone what has been marked as Defense Exhibit 7 and Defense Exhibit 8. Dr. Falzone, do you recognize Defense Exhibit 7 and Defense Exhibit 8 as additional photographs of Ms. Baker's anus?
Yes.
Are those fair and accurate depictions of Ms. Baker's anus as you remember?
Yes, but it also has the vulva with the burn injuries that I mentioned earlier on the direct.
Can I approach?
Sure. The burn across the upper.
Where's the vulva?
That would be here.
What is this here?
That would be the anal region down there.
May I publish these photos?
Well, you need to tender them. That's right.
I move to admit Defense Exhibit 7.
Any objection about Exhibit 7 or 8? They are admitted, and you may publish, Mr. Cruz.
Well, that would be the vulva again, different orientation. Mm-hmm.
Okay, all right. If the media would just turn their cameras off, we're going to post these pictures. Thank you. We're going to continue on as scheduled. So the document camera is on, Mr. Cruz. You may use it.
Okay.
Okay, so what? That's good though. I don't really want to see the autopsy pictures and stuff like that. It's not very nice. That is a blessing.
This is going to be Defense Exhibit 7. It's over there, Your Honor.
Is it already on the screen?
No, ma'am. I like to use my laptop.
I see. I'm sorry. I had the wrong one on. I thought you were going to use the... I thought you were using that machine. Hang on just a minute. Now.
So I have added some new ones. David, I did a, you block stream.
Dr. Falzone, I'd like to direct your attention to the screen, okay? I believe when you were on direct examination with the state, and can you look over here, Doctor, just so I can point to it for you? Justin, bring the resolution down. Just make it just a tad bit smaller. A little bit bigger. A little bit bigger. A little bit more. All right, about right there. You mentioned that this area was her vagina. Is that right?
Correct. Her introitus, yeah, the vulva.
Okay. And you said this area here is her
Anus. And this would be above her pubic area where the purple area is. That's a post-mortem burn artifact.
Okay, so the question I have for you, and I may need to use another exhibit if you don't see it, is it possible that she would have pubic hair around her anus but no hair around her vagina? Okay. I have no other questions for this witness, Your Honor.
All right. Any redirect, Mr. Bolden?
Briefly, Your Honor.
Go ahead.
Dr. Falzon, I think in connection with Defense Exhibit 6.
Thank you.
When you were asked questions about Defense Exhibit 6, I believe you were asked a question as something to the effect of, with the injuries to Ms. Baker's anus being consistent with sexual assault.
Correct.
You recall that question? And just to be clear, would that also apply to the injuries that you observed to her vagina?
Could you repeat the question?
Yes. Would the injuries that you observed to her vagina also be consistent with sexual assault?
Correct.
Okay. And as it relates to either of those, does a sexual assault necessarily indicate that there's going to be the presence of any physical evidence recovered on that sexual assault kit?
Not necessarily.
What could be some reasons why that might be, sir?
I mean, one would expect to find DNA related to semen, but there may not be semen present there. I mean, the individual may not have ejaculated, a condom may have been used, a foreign object may have been used, so there's multiple explanations as to why DNA may not be recovered.
And are you familiar with the idea of, or the, I guess the phenomenon of drainage, sir?
Fluids travel by gravity.
Okay.
So, yeah.
That's all I was asking. Thank you. And then also on cross-examination, you were asked if the labeling of the items, the question that I heard was that the labeling affects the results of the DNA testing. My question to you, sir, is could the fact, let me think of the best way to ask this. Does the labeling itself, what is marked on a certain exhibit, have anything to do with the results of any testing of what is inside?
It would impact the interpretation of it.
Thank you, sir. That's all I have.
Any requests, Mr. Cruz?
Yes, ma'am. Just
Go ahead.
one thing with Defense Exhibit 6. May I publish Defense Exhibit 6 to the jury, Your Honor?
Yes. How did you want to do that? On your computer?
No, I was just going to hand them.
That's fine.
May I approach you, Dr. Falzon? And for the record, Your Honor, Defense Exhibit 6 was identified as Ms. Baker's anus and the upper area of her body. But otherwise, Your Honor, I thank you. I have no other questions for Dr. Falzone. Thank you so much for your service, sir.
Thank you, Mr. Cruz. Mr. Bolden, any other questions of this witness? May this witness be excused. Any objection from the defense?
No objection, Your Honor.
You are free to go, sir. You may call your next witness.
State calls Katie Lonstein.
Who'd you get? Katie Longstein.
Katie Longstein. Okay. I've missed a lot of these, so I've not seen everything, obviously. Also, Dave, you blocked the Streamlabs, but you've got your own little. So you put exclamation mark Dave. You got your own saying in there. No, I didn't see that either. I need to watch this again, I think.
Ma'am, if you would please raise your right hand and take an oath. Do you swear or affirm the testimony you'll give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. If you would, please speak towards the microphone, and if you would state and spell your name for the record.
Yes, my full name is Catherine Lonstein, Katherine but everybody calls me Katie.
All right. Ms. Lonstein, what professional field are you involved in?
I'm an attorney
Okay. And where did you attend law school?
here at the University of Georgia.
And what years did you attend school at the University of Georgia?
2000 to 2003.
Before you got to UGA, where did you complete your undergraduate degree?
At the University of Virginia in Charlottesville.
All right. And in law school, can you describe the way during the first year of law school that the student body is divided?
Yes, so we're divided into 3 sections, X, Y, and Z. And you have all of your classes with the folks that are in your section for your entire first year.
And while you were in law school, did you ever meet an individual named Tara Louise Baker?
Yes, I did.
Okay. And when did you meet Tara?
Very first day of law school. We were in orientation, and that was the moment.
And so when you say that was the moment, it seems like it was a quick friendship. Can you talk to us about that?
Yes. Literally from that moment, Tara and I and another woman named Jenya became very good friends. I don't remember many moments of law school after that we weren't together, studying, walking, anything.
All right. So can you explain to the jury kind of the academic rigor involved in that first year of law school?
Yes, exhausting. You are in class 5 to 8 hours a day, then you are studying another 5 to 6 hours a day. If you're lucky, you sleep some, eat some, but it is one of the hardest things I've ever done in my entire life.
That experience, and in particular, sharing it with the same people in every class, did you find that to increase or impact the way relationships were forged at all?
Yes. You form these bonds through the stress that you're going through. You're all learning the same thing, you're all studying the same things, and you're all exhausted in the same way. People would form friendships that would turn into marriages. People would form friendships that turned into lifelong friendships. It's just unlike anything I've been through before. It's like being in the trenches, I suppose, although, I don't know other way to describe it.
All right. And so would you say that would you characterize your relationship with Ms. Baker as falling into that category of relationships?
Yes, I would say from early on, I have called her one of my best friends. And I know it feels too short, but I don't know how to describe it other than if you don't go through that sort of very difficult thing with someone and it bonds you in this really particular way.
And as it relates, I think you've already testified to this, but there are 3 sections. You take all your classes with that section that you're in. Is that right?
Yes, first and second semester, your whole first year.
Okay. I'm going to show Your Honor, Mr. Cruz, what's marked as State's Exhibit 34. And Your Honor, I ask for permission to approach the witness and then continue to move freely through the well of the court as I question her. Ms. Lonstein, I'm going to hand you State's Exhibit 34. I'm going to ask you to take a look at that. Once you've had a chance to review it, let me know.
Yes, I have seen it.
Okay.
I've looked at it.
Do you recognize it?
Yes, this is the schedule from our second semester, so in beginning of January 2001 here at law school. Mm-hmm.
Does that appear to be a fair and accurate depiction of what your schedule was for that semester of law school beginning in January of 2001?
It does.
Judge, I move to tender State's 34 at this time.
Any objection, Mr. Cruz? It is admitted.
And, Your Honor, I'm not going to necessarily ask to publish this to the jury at this point, but I'm going to hand it back to Ms. Lonstein. As it relates to Fridays for y'all, did y'all have classes on Fridays?
Yes.
All right. And what classes did you have?
We had property property, tort, and civil procedure.
Okay. And property, was that the first class of the day?
Yes.
All right. And what time did that property class start?
9:30 in the morning.
Okay. And I don't think we covered this, but are you still practicing law?
Yes, I am.
All right. Where do you practice law?
I live in Washington, D.C., and I work for an agency called the U.S. International Development Finance Corporation.
And so backing up now, back to January of 2001.
Clip is because I
want to ask you about a Thursday evening, which would have been January 18th of 2001. Would you and Miss Baker ever study together?
Frequently, if not every day.
Okay. And so where would y'all study when you studied?
So the law library always, but there are different parts of the law library. There's this sort of first room you come into that has these big windows and it's very sun-filled, but it's a more casual part where people sometimes have conversations. So sometimes you would study there if you were doing a study group or if you were just reading and it wasn't too intense. And then there's this walkway you can go through and you go into the quiet part of the library. And that's where you would go if you were studying for an exam, trying to write a paper, trying to focus.
Okay. And so that evening on that Thursday, were you and Miss Baker studying together?
Yes, we were in the quiet part of the library.
Okay. And as best you recall, I recognize as we sit here, it's been over 25 years since that night. Do you recall about when Miss Baker may have arrived at the law library to study with you?
Yes, I think she got there around 7:30.
Okay. And do you recall what y'all may have been working on?
I believe it was a paper. It was definitely more than just like marking our law books because we both had our computers. So I believe we were writing something. And I know it sounds early because it was early in the semester, but that's just law school for you.
And as it relates to kind of that semester and Miss Baker's plans, was she approaching that semester with any kind of renewed or, I guess, elevated level of commitment to her grades?
Yes, absolutely. In fact, we all were, but she was the most organized, so she had a definite plan, whereas people like me were like, I'll try harder. But the end of our first semester was probably a bit of a shock to all of us, or, grades are hard. So her plan was to be more rigorous about her time in the library and to sort of make it into a job, like ending time, definite stay for the whole period.
And is there any particular ending time that you recall that Ms. Baker was committed to?
Yes, it was 10 p.m.
Okay. So that evening, did you stay till 10 p.m.?
I did not. I had been at the library before. She had joined me there. So at that point, I was ready earlier than she was to go home. So I probably left around, I want to say around 9. Could have been a little bit later, but probably around 9.
Okay. And so was Miss Baker the type of person who had a lot of concern for the people around her?
Yes. I had to walk to school from based on where I lived. I lived just over the railroad tracks, above where the Blind Pig Tavern used to be. And so, not the safest of routes. So anytime I had left the library or school or anywhere before her, she would insist that I call her when I got home.
And so the area that you're describing, please correct me if I'm incorrect, but if you come down East Campus Road going from North Campus to South Campus and you turn left onto Research Drive, I believe it is, it goes by that area that you're talking about?
I think that's right.
Yeah, sorry.
No, sorry.
Go ahead, but I think I misnamed that street, but if you turn left underneath where the railroad tracks go over, is that what you're talking about?
It's in that direction, yes. It's actually been torn down and is a parking lot now, but that's the right direction, yes.
Okay. And so did she had that concern, did she ask you to do anything? Well, and that's going to call for hearsay. So I'm going to withdraw that question, Your Honor. Were you supposed to do anything when you got home?
Yes, I was supposed to call her when I got home, and I did not.
All right. And so did you receive a phone call that evening?
Yes, she called me about 9:30, maybe 9:45, and then she admonished me, scolded me because I had failed to call her, but I just didn't mean anything by it. I just forgot.
Okay. Do you need a cup of water or a moment?
I have some. Thank you so much.
There's some tissues over there beside you if you see them and need them. Is that the last time you ever talked to Tara?
Yeah. I think the last thing she ever said to me was I said, hello, and she said, you did not call me. And I said, I know, I'm so sorry. And she said, but you're okay? I said, I am. And she said, all right, I'll talk to you tomorrow. And that was kind of it.
So when you say I'll talk to you tomorrow, this is Thursday night.
Yes.
So tomorrow would be Friday, January 19th, 2001. Is that right?
Yes.
I would just object to leading questions. I've given counsel leeway. I didn't want to just make.
All right.
I would ask the court to instruct them to ask appropriate questions.
All right, I'm going to sustain that objection. If you will rephrase your questions to be non-leading.
Yes, Your Honor. What day would the next day have been?
January 19th, 2001.
And what day of the week would that have been?
Friday.
Okay. And so on Friday, what would y'all's first class of the day have been?
I believe it was property.
All right. And I think we already talked about this, but about what time did that start?
At 9:30 in the morning.
Was Tara in class?
No, she was not.
Was that something that was unusual for Tara?
It was. And we did, I recall my friends and I discussing it, but we thought, well, it's her birthday weekend. Maybe she slipped in,
Okay. Did she show up for any of her classes after that?
No.
I'll make the same objection. We've had three leading questions. That the state asks questions appropriately.
All right, so the prior two questions were leading. I'm going to sustain your objection with regard to that and ask the state to make sure that you rephrase and you don't lead your witness. The last question was actually not a leading question, so I'll overrule your objection with regard to the last question. You may continue.
Thank you, Your Honor. So I think the last question I ask you is, did Tara show up for any of your classes that day?
She did not show up for any of our classes. No.
Okay. Were there any plans that y'all had for that evening?
Yes. As I said, it was her birthday weekend. So we had all planned to meet at a bar called The Winery just after class. And we did go. Her friends and I went, and she was not there.
Okay. When did you find out what had happened to Tara?
The next morning on January 20th.
Okay. How is it that you learned about Tara's murder?
A friend of mine from law school named Jim Davis called me, and he said, Katie, I'm so sorry, but Tara's died. And I yelled at him, and I was very mean. I told him he was not funny, and then I hung up on him. And then I called our friends. We called them the Ericks because they lived in the same house. So I called the Ericks, and one of them answered. And I said, Eric, Jim has said the most insane thing to me. And he said that Tara died. So I need you to go get your paper and tell me he's wrong. And he did. He went out, and when he came back onto the line, he was just very and he said, Katie, I'm sorry. She died. I don't remember her.
Any response, Mr. Yellowman-Shilley, with regard to the hearsay objection?
Ms. Lonstein, I think the court's instruction to you would be, and my instruction is that please don't talk about in your answer anything anyone else said to you.
Fair enough.
Any objection? Continue.
I apologize. After that, I asked the friend that I was with to get me a newspaper. So that person did purchase me a newspaper. And then I saw the headline, Student Slain, and then the next thing I remember is I fell down, and then I started crying, and I don't know when I stopped, but that's how I found out.
I want to ask you a little more about your relationship with Tara. And I think, Jenya also seems to have been part of this group. Is that right?
Yes.
Okay. Would Tara share things with y'all that she didn't share with kind of the rest of the law school section and class?
That is my perception, yes.
Okay. Was there anything related to her last name that she shared with you that she didn't share with the rest of the law school section and class, to your knowledge?
Yes. To my knowledge, this was something she kept a little more private. Her name had been Barker. It was the name of the man who was her biological father, and she had changed it pretty close to law school, from my understanding, to Baker, which is the man she calls her daddy, his last name.
Okay. Were you aware of whether or not Tara was dating anyone?
Yes.
Okay. And who is that person, if you know?
His name was Chris. I'm sorry, I don't remember his last name, but yes, she was dating Chris, and she'd been dating him for a while, as far as I knew.
Did Tara, and I'm not asking you to get into anything Tara said to you, okay, but did she ever talk to you about Chris?
Yes, in a very normal way. We talked about our friends, we talked about our families, we talked about our relationships. I myself was in a relationship with at a time, so we shared stories like that.
What was, based on those conversations with Tara, what was your impression of their relationship?
That it was good. She was positive. She would smile when she talked about him. No, nothing except for happy.
I don't have any other questions. Thank you very much, Ms. Lonstein.
Cross-examination, Mr. Cruz.
Sorry for your loss, Ms. Lonstein. Your Honor, I do not have any questions, but I would ask if we could approach.
All right, may approach.
Okay. Lady Di says she has a threesome 3 times a week. Okay, Lady Di, thanks for publicly sharing that. Thank you, Lady Di. So yeah, there's a Lahak symbol, there's a Rose symbol, there's a Dave symbol, there's a Hack symbol. Hello, Nancy. How are you doing, my darling? Nancy, just for you, my darling, because you're in the chat. I'm gonna send you a rose. Well, Streamlabs is gonna send you a rose, Nancy. Hang on. There you go, Nancy. Hope you're doing well, my darling. Very emotive testimony right there, obviously. So at today's lunch break, I will be playing the Charlie Adelson hearing from today. So I'll play that from today. There's nothing about Nancy there. Lady Di trying to be fancy. Nothing there for you, Lady Di. Lady Di, this one's yours. Street, that one's yours. I was just looking for a Jugs one, but I couldn't find one. I hope, Nancy, you're getting ready for the Sunday, for the weekend. I'm trying to look out for all of you. Dave Hamburger. Right, she did want to stop for lunch at 12, so I can't put those pictures on there, Hippie Chick, unfortunately. For whatever reason, it won't let me. It won't let me have emojis either. There's no bitches in there yet. I did try to do a cunt one, but it wouldn't let me. Oh! As I say that, she comes in. Hello, Bex. I literally tried to do a command saying exclamation mark, saying cunt for Bex, but it wouldn't let me because I think it's a swear word. No, I don't think the Bex one works, Lady Di. There was one for Bex, but I don't think it works. It doesn't. It's in a different box, Dave, so it doesn't work. It works, but so for Streamlabs, it just doesn't let you do it. Just symbols and that's it. Getting my gear ready and snack list. I know, I'm so jealous because I know you guys. Wings, buffalo cheese, dips, I'm sure. I'm so jealous, Nancy. So jealous. I hope your husband's wearing his lucky jumper. Dang it. I'm still working on it. I'll spend a few more hours on it as well. It's just difficult, you know. I'll do a few more. Yeah, as I say, I was trying to do a Jugs one, but there's no...
All right. Ladies and gentlemen, I'm going to excuse you for right now. If you'll go into the jury room, don't talk about the case. We'll be with you shortly. There are some things I need to take up outside your presence. Thank you.
You might as well send to lunch, Judge, if that's the case, because is Georgia on Eastern? It is Eastern, so yeah, we'll send him to lunch then. Early lunch, mofo.
All right, Mr. Cruz, do you want to clarify your question and see if I understand what you're asking?
Yes, ma'am.
Go ahead.
Before our trial, I filed residual hearsay motions. The Honorable Court entered an order stating that I could not ask any witness anything about what Ms. Baker told them until, I believe you prefaced it on, depending on what Chris Melton's testimony was. You said you would make a ruling after, I'm going to paraphrase, you would make a ruling once Chris Melton testified. You instructed me that in opening, I could not mention anything that Ms. Baker may have said to anyone. And as you know, in opening yesterday, I was held in contempt for making a statement that Chris Melton made that the Honorable Courts, that Mr. Yalamachili asked for, and the Honorable Court granted, saying that I violated Rule 412 based on me stating that Mr. Melton stated she must have been with someone else when he was told that somebody else's DNA was found after he knew for 25 years somebody else's DNA was, or at least he was told DNA was present. Based on yesterday, I said, well, look, I need to be conservative. I don't want to offend the court in any way. I don't want the court to think I'm doing anything intentional when I'm not. So I assumed that Ahmad don't speak on anything regarding Tara Baker's statements until the Honorable Court makes a ruling. However, Mr. Yalamachili just asked Ms. Lunstein, based on what Tara Baker told you, what is your impression of the relationship? And I looked at the Honorable Court to see if the Honorable Court was going to say anything. Nothing was said. So that's why I came to the bench, to just get clarity. And the only thing I want to do, Your Honor, I just don't want to offend you. I don't want to offend you. Yesterday, I got held in contempt, and I didn't even realize that I was doing something that was improper. So I'm trying to make sure I'm walking on eggshells for Your Honor. I'm trying to make sure I do everything right for Your Honor. So I just want clarity that if that question is okay based on the court's order. That's the only thing I want clarity on. Can I ask witnesses, based on what Ms. Baker told them, what is their impression of the relationship with Chris Melton and Ms. Baker?
All right, Mr. Cruz, you are mischaracterizing the court's order completely. Yesterday's moments were based on a ruling that the court made on January 21st with regard to the state's appropriate filing of a 412 motion. And we've said this, we've discussed this over and over again. And the court has noted over and over again that the defense did not file a 412 motion. The defense only acknowledged in open court to the state, with regard to their motion, that the only person that they would introduce or attempt to introduce evidence for with regard to any exception for 412 was Mr. Melton. And we've discussed over and over again the fact that should the defense wish to attempt to introduce evidence other than Mr. Melton, that a proper motion had to be filed. We've talked about that over and over again. Yesterday, I made a finding that you first attempted to circumnavigate that policy, that procedure, by insinuating certain things in your opening. The state made an objection. I sustained it. And I had a pretty lengthy discussion with counsel outside the presence of the jury, warning counsel not to do that. When you did it again, the state made an objection. I sent the jury out, and that's when I made a finding of contempt after allowing you certainly to explain yourself. And I found that that was a violation of the court's order with regard to 412. And so your characterization for the court about what you're allowed to say and what you're not allowed to say is not, does not comport with what happened yesterday. The motion that you filed, notice of intention to introduce residual hearsay testimony, is in relation to certain statements that you are asking the court to admit. They are pending. And they are pending because I made, and you appropriately said this, it will depend on how the evidence unfolds. And we will take up these motions again if necessary as the case proceeds. But there is nothing improper in the way that Mr. Yellowman-Chili asked that question. And it has nothing to do with 412. It doesn't have anything to do with my prohibition that I gave the defense. I think the insinuation that the court is being unfair and allowing one side to do something and the other side not to do something is absolutely mischaracterizing my order. And so I'm responding to your comments, Mr. Cruz. If you have an objection to the state's questions, you certainly may present it right now, and I will make a ruling.
This is the situation the defense is in. I am handcuffed. Being held in contempt is a very severe sanction against an attorney. It is very severe. So what I have to navigate is being respectful to the court, also following the law, but most importantly, following the court's orders. The state, they have no prohibitions on him. I can't argue consent. The court has said, well, you can't say anything about consent in regards to the DNA. Mr. Yellowman-Chili, who got up yesterday and said, oh, Mr. Cruz is so disingenuous. This prosecution is disingenuous. This guy is innocent. The evidence will show he's clearly innocent. So, but I won't go there. But we have restrictions on us that the state does not have. So what I have to do, because I've been held in contempt, is I have to make sure I don't do anything that'll surprise me like it did yesterday.
Okay.
So
Mr. Cruz, I would like to respond this way. Your characterization of being handcuffed, so you speak, is very unfortunate. And I think that is an unfortunate way to address the fact that the only reason that we're having this discussion is because you have not filed the appropriate motions for the court to take up. And the ruling that the court made about whether the defense can introduce a defense of consent and other things that you mentioned are because, and we have talked about this many times, that you have failed to file the proper motions. Because when you file the proper motions, the court will hear argument as to whether your motions are appropriate, as to whether the evidence you are seeking to admit is admissible. And if that is not done, then what you're seeking to admit is not allowed. And that is just the law. And so to characterize the court's allowing one party to do things and the other side being, in your words, handcuffed is not accurate. It is misleading. That is not why the court made a finding of contempt yesterday. I'm not going to go back over my finding, but suffice it to say, I think I was pretty thorough on the record twice about whether the defense was allowed to say certain things. The rulings that I have made that supported the court's comments yesterday are in the record. They are on the record. And Mr. Cruz, you are very well aware of the reasons that the court made those rulings. And so unless and until the defense files the proper motion, which would then provide the atmosphere for both sides to argue as to whether the evidence you're asking to admit is admissible, it is prohibited. And that is the law. And so I'm not going to argue with you about that. I think your characterization of what is allowed and is not allowed is mischaracterized. I can't think of another way to say it.
Your Honor, we gave 5 cases that 412 did not apply to a defendant, saying that to a rape allegation, he's raising the defense.
I'm not going to revisit that moment, Mr. Cruz. I've already made my ruling.
Yes, ma'am.
And so it is not appropriate to re-argue that you're right and the court is wrong. There is another venue for that.
Yes, ma'am.
I've made a ruling, and you certainly can take it up if necessary in another venue. But for now, I'm not going to revisit that ruling.
Yes, ma'am.
I've made that ruling. And until you are filing the appropriate motions to be heard, and I've told you yesterday that if you do file those motions, even though they are not timely, I will consider them. But until then, my ruling does stand. And so I just need to ask you your objection right now so that I know that I've finally finished making whatever ruling it is with regard to what Mr. Yellowman-Chili was talking about.
So I didn't have an objection. That's why I approached the bench. The question that I was asking, because maybe I'm misinterpreting maybe I'm misinterpreting what the Honorable Court instructed me to do and to stay away from. I just want to know, because what I'm scared of is I ask the question, Mr. Yalamachili hops up, Judge, he's done this on purpose, hold him in contempt again. I'm just asking, Judge, is it okay? And we could have kept it at the bench. Is it okay? I just want to be clear. Is it okay if I ask witnesses the exact question? Based on what Ms. Baker told you and what she discussed in her relationship, what was your impression about Ms. Baker's and Chris Melton's relationship? Is that an okay question for me to ask?
Yes, it is, sir.
Yes,
That's
ma'am.
what the state just asked.
Yes, ma'am.
Yes, sir.
Thank you, Your Honor.
And that was one of the moments with regard to that particular witness, Mr. Melton, that was basically properly noticed by the defense to the state, because we had a hearing where we had that discussion. And so even though that notice was an oral notice as opposed to a written motion, we had that discussion in court. My ruling on the 21st was based on that acknowledgement by the defense to the state in proper form. So yes, sir. The answer to your question is yes. Mr. Yalamachili, did you want to respond at all? I've been talking with Mr. Cruz. You're the other party. If you'd like to make a response, you may. And then, Mr. Cruz, you'll have the last word. Go ahead.
Thank you, Your Honor. As the court said, the issue Mr. Cruz actually raised at the bench where the discussion started had nothing to do with 412. The court's already said we're not revisiting the long discussions. The court's reviewed all the cases, made its ruling in accordance with the laws of the state of Georgia. I just want to, I guess, establish for purposes of the record that Mr. Cruz filed a notice of intent to introduce residual hearsay statements. So asking to actually elicit hearsay from witnesses. The court withheld its ruling. I do want to say that at least, and I don't have the transcript in front of me, but I think Mr. Cruz has misconstrued the court's order as it related to that, which was we are going to hold rulings on this notice until such time as there has been testimony from the witness and some of the predicate requirements may be met about truthfulness, and then the court, obviously it will be in your discretion even to admit or deny the introduction of those statements. But I just want to establish for the record, the state did not elicit any hearsay statement regarding Ms. Baker saying what it was about the relationship. We established foundation that this is a person who had discussions with Ms. Baker about her relationship, and we laid a foundation that they had a close and trusted friendship, and then just asked her about her impressions of their relationship. So I just want to make that clear for the record.
And I think that's an important distinction. So, Mr. Cruz, with regard to your question, let's go back to your question. Your question about eliciting information about the witness's impression of any status of relationship between Ms. Baker and Mr. Melton is certainly permissible. The state just asked it. The defense can ask the same thing. What neither party can do right now is elicit hearsay testimony. And let me just rephrase so we're on the same page. Because sometimes these things can get very technical, and I want to make sure that all parties are on the same page, and that is this. For example, asking a question of this witness or any witness, based on what Ms. Baker told you, do you have an opinion on X, Y, and Z? At the moment, that's not a permissible question, right? Because it is eliciting hearsay. The way that Mr. Yalamachili has just phrased what he asked this witness is permissible based on your relation. I'm not going to tell you how to make your question, but something to the effect of how he just phrased it, based on your relationship with a certain person, the hours you spent together, the things that you discussed, do you have an impression of the relationship? That kind of a question is permissible. The state just asked something like that. The defense has every right to respond and ask the same kind of a question. But eliciting actual hearsay testimony is not permissible at this point. Does that make sense?
I agree with the Honorable Court's ruling. I just wanted to make sure that I'm within the proper parameters, and just let Honorable Court know, exactly where we're coming from as the defense. It's new ground when a prosecutor stands up and says, Judge, this attorney has said something and he should be held in contempt, and he's held in contempt. When the statement, again, that Chris Melton said she must have been with someone else when confronted with DNA has nothing to do with 412. I am very familiar with the 412 statute. That has nothing to do with 412.
We're not.
Go ahead, Your Honor.
I'm sorry, Judge, just because Mr. Cruz has directly referenced statements that I've made, I would just like to say I've never in my career as a prosecutor or a defense attorney, thankfully, until this trial, been put in a situation where I had to make that request, but we were put in a situation where we had to make that request.
For both parties, I'm not going to relitigate the moment where I've held you in contempt, Mr. Cruz.
Yes, ma'am.
I am going to tell you that the comments that you have made, in my opinion, are mischaracterizing what happened yesterday. I'm not relitigating that moment.
Yes, ma'am.
I'm going to ask that all parties move on.
Yes, ma'am.
It is 5 after 12. I'm instructing both parties not to violate my ruling on 412. If there is a motion filed, even though it is untimely, I will consider it. But other than that, we need to move along. So is there anything else, Mr. Cruz, you would like to ask the court?
No, ma'am.
All right. Thank you.
Your Honor.
Yes.
Just to let you know, I am walking on eggshells, so if I have concerns about something, I'll just ask to approach the bench. It doesn't even have to be on the record. I just want to make sure I don't violate anything that the Honorable Court puts in place.
Well, Mr. Cruz, I'm sorry to hear that.
Yes, ma'am.
I don't know that walking on eggshells is a fair representation of what happened yesterday. I think the appropriate response should be to review the court's rulings and just recognize what they are and not violate them.
Yes, ma'am.
All right, thank you. If you'll bring the jury up, please. Thank you.
Stand up for the jury.
Jeepers, that was just way too long. That was unnecessary, all of that. I mean, from everybody there, you know. I don't know, what the fuck? Why couldn't they just, you know, just everyone shut the fuck up? If I had a meme now, I'd say, shut the fuck up. Oh, fuck's sakes. Right. I'll try and do a shut the fuck up one.
Thank you. Everyone may be seated. Mr. Yalamichili, you have the floor.
Thank you, Your Honor. I believe Mr. Cruz indicated that he didn't have any cross-examination questions for Ms. Lunstein, and I don't have any.
I'm not sure I heard that. Okay, so you were finished. Mr. Cruz, do you have any questions for this witness?
I do not, Your Honor.
All right. Mr. Yalamichili, anything else from this witness?
No, Judge.
May she be excused?
We'd ask that she is.
Any objection from the defense?
No, ma'am.
All right. You may be excused. Thank you. May I see counsel at the bench now that we are excusing that witness?
This is a complete fucking shit show. This is why the jury could have gone for lunch. Oh yeah, you can do the shut fuck up there, fine. The jury just wasted like 10 minutes there, or 20 minutes. We could have been having lunch. Oh.
All right, Mr. Yalamichili, you may call your next witness.
State calls Miss Athena Gray.
Okay, there you go.
Get Miss Adina Gray, please. Thank you.
Okay. No, the defense lawyer is not fired. No, just he was held in contempt of court yesterday and fined $1,000, but he's back now. He's doing a lot of it for play acting, ready for appeals and stuff like that. You know, I just think he's over egging it. I think he's making it worse for himself. This is just remember, this is Beck's, his country, county, state. It says a lot about Beck's, I think. Oh shit, here we go.
Ma'am, if you would, please raise your right hand and take an oath. Do you swear or affirm testimony you'll give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. If you would, please state and spell your name for the record.
Athena Gray, Athena, last name Gray, Gray.
And ma'am, where are you currently employed?
Athens Clarke County Police Department in the Communications Division.
And is that sometimes referred to as the 911 center?
It is.
Okay. And what does the 911 center do in Athens Clarke County?
We process incoming calls for service.
And how long have you been working there?
About 11 years.
What type of training have you received for your current position?
I am post-certified as a communications officer with the state of Georgia. I have received training for communications training officer, communications officer, senior communications officer, and several supervisory skills management courses.
And what is your current title?
I'm the 911 training coordinator.
Okay. And when someone calls 911, is there a document produced?
That's correct. When someone calls 911, we get anti-alley information. That means automated number information and automated location information. What that means is if someone calls in from a cell phone, then we get the latitude and longitude of the GPS coordinates that the cell phone tower is bouncing off of. We also get the phone number and we get the provider. So whether it's AT&T or Sprint, if it's calling from a landline, then we get the subscriber information, whether it's a business or a residence. We also get the phone number and the address that it's registered to. Now, in order to create a call for service, we need to know two things. We need to know what the address is, and we need to know what the problem is. Once we get that information, then we can create a call for service in something called CAD. CAD is an acronym for Computer Aided Dispatch. It's a system that we use to create the calls for services. As the call taker is gathering the information, they can enter that into the CAD system, and another person in the room will dispatch it out for service.
You hit on the next couple of questions I was going to ask, so you gave me a chance to skip down a little bit. Is information entered by the call taker and logged into CAD?
Objection. Leading.
Sustained. If you'll rephrase, Mr. Yellowman, don't leave you waiting.
Well, Judge, I was going to ask a question that was about the testimony that she just gave. She just testified that the call taker enters information into CAD. And so my question was about that answer.
All right.
Well, that wasn't a question at all.
Okay. All right. So I'm just going to sustain the objection in the manner in which you asked it. I certainly will allow both parties to provide context to their direct examination questions or their cross if they choose to, but just make sure you don't lead your witness.
Thank you, Judge. Is the time that information is entered recorded in the CAD?
It is.
Okay. And is the CAD maintained?
Objection, Your Honor. Leading.
Right. I'm going to overrule that objection.
Is the CAD maintained in the normal course of regularly conducted activity by the 911 center?
It is.
Okay. And is that part of the regular practice of the center?
It is.
Are you familiar with the system that is used to record and maintain information for 911 calls?
I am.
And Judge, I'm going to show Mr. Cruz what's been marked as State's Exhibit 35.
Your Honor, I would object to the statements that are in this document on confrontation ground clause, on the grounds of the confrontation clause. And that's to State's Exhibit 35. As far as the computer-generated information, I have no objection.
Your Honor, and I think defense counsel has actually filed a motion to this effect, but if we could limit speaking objections, please.
All right. May I see counsel at the bench for a moment, please? Thank you. I think let's just get through this witness. The proper way to do it
What's going on now? Why are they at another sidebar? Why are we at a sidebar again? Did you notice that they now have mics to put on themselves as well? Because yesterday was really hard. The trial's going to take a year at this rate. James is supposed to be one of the best defensive lawyers in Atlanta. James does not like this attorney. Oof. I know, I should pay attention.
Mr. Ray, I'm going to hand you what's been marked as State's Exhibit 35. If you could review that and let me know when you had a chance to review it.
Okay.
And what is that document?
It's a CAD fire report.
Okay. And is there any aggregate as far as when the call was made?
Yes, it is.
Okay. And what is that date?
January 19th, 2001.
Okay. And does that appear to be a fair and accurate depiction of that fire CAD?
That's correct.
All right. Judge, I move to tender 35 at this time.
All right, Mr. Cruz, any objections, sir?
No objection, Your Honor.
All right, it is admitted.
And, Your Honor, I'd move to publish the CAD at this time.
You may do so. You want to do it on the computer? I mean, on the screen?
Yes, Judge.
Give it a second.
I have the blue light on over here, which...
That's one over here, too.
Well, and Your Honor, I think for purposes of the questions that I have for Ms. Gray, we could do it without publishing it at this time, Judge.
All right.
Mr. I'm going to hand this back to you. So there are multiple dates on that CAD, and we've already talked about the incident date from the call. Are there any other dates in the top left-hand corner of that document?
Yes, it is.
Okay, what is that date?
That's when it was printed out.
Okay, but what specifically is the date?
March 24th, 2006.
All right, and so just to clarify, you just testified that that's the date it's actually printed, is that right?
That's correct.
Okay, but what was the date of the actual call?
January 19th, 2001.
Okay, and is there a time associated with the call?
Yes.
What is that time?
11/22/23.
Okay. And as information is entered into the CAD, are there timestamps associated with that?
There is.
Okay. And I want to ask you about a timestamp from 11/22/41. What is the information entered by the call taker at that time?
11/22/01.
I had it in my notes as 11/22/41.
Objection,
Oh, I see.
Your Honor. Objection. Counsel asks question, witness gives testimony.
All right. I'm going to overrule the objection. I think you're clarifying your question. Go ahead.
Says called in from 175, said he is across the street. Looks like 160 is on fire.
Okay. The entry at 11/32/50.
Per command, get investigator.
At 11/33/36.
Command advise victim in structure.
And then at 11:34:36.
Command advise need forensics.
Okay. And that, those times that are noted, is that AM or PM?
AM.
Okay. Judge, I don't have any other questions for Ms. Gray at this time.
All right, Mr. Cruz, cross-examination.
I have no questions for you, Ms. Gray. I just want to thank you for your service.
Mr. Yelman-Chili, can we excuse this witness?
I'd ask you to be excused, Judge.
Any objection from the defense?
No, ma'am.
You are free to go. Thank you. Ladies and gentlemen, we are going to take our lunch break right now. I'm going to give you the same instructions I've given you this entire time that we have met. Please don't discuss the case with anyone. Please don't do any independent research, of course. Don't go on the internet in any way and look up anything you may have heard today or before today. And other than that, enjoy your lunch. I'd like for you all to come back here by 1:30. We're going to start testimony again, so it's about an hour and 10 minutes. Enjoy your lunch. We'll see you all at 1:30. Thank you.
Okay. I'm gonna quieten that down. Right, let's do the catwalk again. We are going. They don't have a lot of things, Lady Di. They don't have a lot of things. That's top-notch merch right there, Nancy. Where's Nancy on Bex? I have a shirt that says that with a bitch on the end. Oh yeah, you got the nosy bitch one, yeah. Nancy boy, nosy bitch merch. So Mr. Spur, I have no idea who it was, Crystal. It's not that. I don't think it's that important. I think it was mostly the medical examiner, and that's it. Right. Let's do this then, whilst we wait.
To determine whether or not they...
Let's listen to the hearing from this morning for good old Charlie Adelson. What is it? I'll just look what it is. Live appeal. So he fights for a new trial. Charlie Adelson serving a life sentence for the 2014 murder of his former brother-in-law, Dan Markle. But his legal fight is far from over. His attorneys are now seeking a new trial, asking Florida's First District Court of Appeal to review the case. Adelson claims the trial judge committed multiple reversible errors, including refusing to grant a change of venue. Prosecutors have pushed back, arguing Adelson forfeited that claim when he accepted the jury without objection, an argument the state underscores in its response brief. So he wants a new trial. So let's listen to this bad boy. Ah, look at that love in the background. It must be love, love, love. Ba-boom. Nothing less, nothing more, nothing less, except if you are Bex. It must be love, love, love. Bam, bam. Right, here we go. I'll play this for you, bad boys. Oh, have I boosted it? Yes, I have. There you go.
They've formed an opinion about the case and whether or not they've been exposed to pretrial publicity. Of the 130 that were questioned, 54 said that they had formed an opinion regarding innocence or guilt, and 53 of those had formed the opinion that my client was guilty.
And they were excused for cause,
They all
correct?
were.
All right, so let's start a little bit about the procedure that the rules require before those interview questions are even asked. Why don't you address, the rule requires a written motion, an affidavit, and a good faith statement, correct?
Yes, Your Honor.
All right, and that didn't happen here.
No, Your Honor.
And what type of things would we have seen in an affidavit before any jurors were interviewed?
I don't know, and my response to that is, and I understand that I'm attacking the rule and it's a requirement, although there's certainly case law that says that if a motion in any context is made orally, and if there's a component within our criminal procedure rules that requires it to be written, if it would be a useless gesture for such a motion to be submitted in writing when it's been, then that's not required. And I think that, again, specifically applies to this type of case. We know the Florida Supreme Court has been very clear that change of venue claims almost always need to be considered during jury selection, that a judge is not going to grant a change of venue claim pre-trial.
Sure, but one of your arguments is that the Tallahassee community, almost 300,000 people, was so tainted by what you characterize as pervasive media that there could be no jury selected that would be impartial. And wouldn't affidavits have shown, for instance, that what types of media that the citizens of Tallahassee in this community were consuming? And you definitely see in the record the local sources, national sources. You make the argument that this isn't like the 1994 trial of Danny Rawling in 1994, where people would watch Dan Rather or Tom Brokaw, and I think that's right, but wouldn't the affidavits also have shown that maybe consumers curate their media differently? We saw in this transcript there were many consumers of media who said, I'll give some examples. They don't watch television. I turned off my propaganda box 3 years ago. I don't read the paper. That's for wrapping mullet. Very rarely do I watch the news. And so you see a lot of behavior in this typical kind of Tallahassee community that's different than 1994. Couldn't you have shown those things in an affidavit before you interviewed a single juror?
Clearly, the rule says that should have been done, and I'm not disputing that it should have been done, but I submit that it was established by the record as you just indicated. The record very clearly shows the way that the 130 jurors that we're talking about consumed their information about this case. And it's not just, contrary to what happened in 1994 or what was happening in the 90s, it's not just the print media. Clearly, the Tallahassee Democrat covered this case extensively. It's not just the local news. Clearly, the local news covered this case extensively. But unlike the 90s, now we have several jurors saying that they're getting their information from cable news networks, Court TV, shows
YouTube, Court TV, 2020, Over My Dead Body podcast, The Preston Scott Show, Tallahassee Democrat. But what you don't have in this record is how many times those exposures happened, whether they were biased or not, whether there were some broadcasts or podcasts that in fact argued that your client was innocent. So we don't have the content of that to show how that would have influenced the veneer, correct?
We do not have that from affidavits pre-trial showing the things that you just mentioned, but we do have that in the record based on the answers that the jurors gave. And again, when we are talking about a little over 40%, that's a huge number. In the Murphy case, I believe it was right around 25%. And in that case, the court said that's not enough. Here we are at 40%. So when you talk about 40%, when you talk about the judge making a finding when granting the protective order pre-trial that Tallahassee is in fact a small community, when you talk about this case has been permeating Tallahassee media sources for almost a decade at the time of this trial, when you talk about there was 3 previous prosecutions, one of which resulted in a mistrial and a subsequent trial just a year before my client's trial.
Sure, but why don't we talk about what the Florida Supreme Court says when there's pervasive media? Certainly no one would argue that there wasn't pervasive media in the Danny Rawling case, right?
Correct.
We're talking about 5 murders, college town, again, maybe a small community as you would describe it, perhaps.
Sure.
So with that, since that case, in the Ellerby case, the Armstrong case, the court has said that it's not enough to show that media was pervasive. It was, could the juror be impartial? Every single juror seated in this case said that no matter what contact, many of them had no contact with media or information, that they could be impartial. Isn't that right?
That's correct.
All right, so specifically, I'd like you to address the Armstrong case. The state raised it in the answer brief, and you did not address it in your reply brief. The Armstrong case, the Florida Supreme Court, and this is 24 years after the Manning case that you cited in your case, they said that if you don't renew your objection to the jury before the jury is impaneled, in fact, your client accepted this jury, that you have waived it and we may not reach that issue. What do we do with Armstrong?
So two responses to that, three actually. Just quickly regarding my client accepting it. I don't know that my client accepting it matters much. I think the concern is, did defense counsel renew the objection? The state made an issue out of that. And if you look at the question asked of my client at the conclusion of jury selection, the judge literally says, you have no choice but to accept because you have no strikes left.
But was
do you
there an
accept?
objection?
No,
Was there an
I
objection?
understand. But again, to that, I'm just responding to the concern. I understand the state raised it, and that's probably why you're saying it. But my client accepting the jury is irrelevant to this matter. The question is, did defense counsel renew the objection? I acknowledge that that generally is what's required for any type of jury selection claim. However, Manning is specifically a case where we know from the dissenting opinion the request to change venue was not renewed.
But I'm going to repeat, Manning was decided 24 years before Armstrong in 2003, where the Supreme Court specifically said the failure to renew is waiver of the claim.
I understand.
That's precedent that's binding on this court, is it not?
The court doesn't, we're all familiar with the principle that a court doesn't overrule itself sub silentio. The court has not specifically said Manning's no longer good law. That being said, I rely upon Manning because it was ultimately reached consistent with what I think the U.S. Supreme Court has said is an appellate court's burden to go through the record in one of these cases to determine if there's a change of venue issue. But beyond that, I will acknowledge that at the very least, to the extent that this court finds that it's not preserved because it was not renewed, then the question is it fundamental error? And I submit that based on the facts of this case, we do meet the fundamental error standard. In the Smith case just 4 years ago, the Florida Supreme Court specifically said that the failure to preserve a change of venue claim can nevertheless be reviewed under the fundamental
Well, my
error
understanding is, the reason we have this very, very unusual requirement for, a renewal of an objection is not just simply, it's not just Simon says, just, you got to do it twice or else. It's that it is possible that the defense is happy with the jury. It's generally in the challenge context when you challenge a juror and they want to see whether you renew that challenge, that you are in fact satisfied with the jury. So I don't know if you can say that it's a fundamental error issue if in fact the defense was satisfied with the issue. Now, I did believe when I saw Armstrong, it's like, wait a minute, it's not what happened in Joyner. It's not a cause challenge, it's change of venue.
Correct.
But when you read Armstrong, it's very clear. First of all, it says that a change of venue motion is premature until you actually attempt to select a jury. What
Correct.
that says to me is a change of venue is a jury selection issue.
Sure.
And what I draw from that is that, just as Judge Rowe is saying, if you in fact are able to find jurors who swear that they are untainted, then I don't know if there is in fact a change of jury issue. It very well may be that the defense thinks, okay, I found untainted jurors, I don't really have any reason to continue with a change of venue objection. So that raises two things. Number one, whether the fact that you have untainted jurors overcomes the fact that the community may have had a low level of taint. And number two, the suggestion that it's fundamental error when the whole point of the objection is that the defendant is satisfied, which I don't think a fundamental error claim can overcome.
So a couple of responses to that. Again, the Smith case is 2021, and it's specifically page 28 of the Florida Supreme Court's opinion, and they clearly went on to address the claim for the change of venue motion, despite the fact that it was not preserved, and they did so under the fundamental error standard. And so, I'll quote from the case.
But isn't there a difference between preservation and waiver?
Sure, well, yes, but so if we're going to waiver, and now if you're addressing what my client said at the conclusion of jury selection, that's no waiver on my client's part when the judge specifically told him, you have no choice.
I guess perhaps I should just read Armstrong again, because Armstrong says a motion for change of venue should be renewed at the conclusion of jury selection or be considered waived. So it is the failure to object that is the waiver in this context. I mean, do you read it any differently than I do?
If that were the case, then Smith in 2021 would be wrong. And Smith obviously is more current and specifically says that because the issue was not preserved, because it was not renewed at the conclusion of the jury selection proceeding, we review this claim for fundamental error. So I submit to you, again, this court has the ability to review the claim. Smith from the Florida Supreme Court very recently has said for at least a change of venue claim. It may be different for a peremptory challenge, the failure to grant a cause challenge, but when it comes to change of venue, the Florida Supreme Court has specifically said it can be reviewed for fundamental error. And I guess going back to Manning, and I understand the time difference, but Manning would be a great example of that. You literally have the attorney in Manning saying at the conclusion of jury selection, I believe we picked a fair and impartial jury. And I submit that there's no jurist in this state that would review the facts and reach a conclusion, unlike what the Florida Supreme Court did, that there's no way that venue could have been fair within Columbia County in that case. So that's exactly why these claims can still be reviewed for fundamental error.
Just generally speaking, you know, normally when we talk fundamental error, it's because that an error wasn't preserved below. Can
Correct.
fundamental error be affirmatively waived?
If defense counsel had said, if the question, rather than to Mr. Adelson, do you accept this jury, and let me point out, you have no choice but to accept the jury, but answer me anyways, do you accept this jury? If it had been defense counsel, you previously raised some objections. Do you now no longer renew those objections and accept this jury? If that would be the case, I would have no ability to make an argument in front of you today. That would be waiver. That's not at all what we have in this record. I think the
It
fact...
sounds to me like you're going up a 3850 avenue, but let me ask you this question. Is Armstrong's a 3850 appeal?
Correct.
The other cases we're talking about earlier were direct appeals. Is
Correct.
that distinguishable?
Perhaps. I mean, again, a lot of times when the Florida Supreme Court considers 3850s, they also consider 9.141s in the context of failure to raise issues on direct appeal, and that's also the way, in Hilton at least, that the ways these claims are being raised. But again, in a direct appeal claim, on a direct appeal, the issue is it preserved? If it's not, can it be reviewed for fundamental error? I submit that there are some things that cannot be. Generally speaking, the failure to renew a cause challenge is not something that's going to be reviewed for fundamental error. The court's been clear about that. And if there is a specific waiver on the record, we don't have that here, then no, you wouldn't be able to review it for fundamental error. Waiver trumps fundamental error. We don't have a waiver here, and I submit that fundamental error is still the standard.
But surely you're not arguing that now a trial judge has to, who's represented, a defendant's represented, now a trial judge has to look to the defendant who's represented by counsel to say, do you individually accept a jury?
I have no idea why the judge did that in this case. But
But are you promoting a bifurcated question by a trial judge to counsel and a defendant?
I think well, in the context that the judge is asking the question in this case is, it fairly could be construed as, do you have any other strikes? And that's why, and every time that question was being asked, there was a strike, because there were back strikes in this case. So ultimately, when he just asked the same question he'd been asking up until that point, the question was, do you accept this jury, i.e., do you have any other strikes? And I guess let me throw out there, you have no other strikes, so you have no choice but to accept the jury. That's why it's being said here. Again, I acknowledge it's incumbent upon defense counsel to jump in and specifically say, we renew the objection, but if that's not done, it's still reviewed for fundamental error. I see that I'm getting in my rebuttal time. I would like to make a couple other quick points about the merits.
I'm going to extend your time by 5 minutes. I'll do the same thing for the state.
Thank you. I appreciate that. I do need to address, so we have, and I've already talked about this, the almost 40, or a little more than 40%. We have the Tallahassee community. We have the different ways that social media infects jurors in a community now. But we have more than that in this case. In Patton, the U.S. Supreme Court said exactly this: adverse pretrial publicity can create such a presumption of prejudice in the community that the jurors' claims that they can be impartial should not be believed. The U.S. Supreme Court is saying that.
And they're saying that, and they probably are saying that on a record where there was a record that the media exposure was indeed adverse. And again, we can't presume that,
Let me go further with that, Your Honor. What they're saying is there could be such intense media influence in a case that we may not even believe what the jurors are saying. And if I came to you with no evidence in the record and said, that's what we have here, you would say, Mr. Rufferman, you're speculating. We have 2 instances where jurors lied directly to the trial court, asked point blank.
So are we supposed to just assess the credibility of these jurors? Is that what an appellate court is to do under this theory?
No, but what we have in this record is 2 instances where jurors were specifically asked, have you formed an opinion about guilt in this case, or have you posted anything on social media about this case? In both instances, the jurors said no. In one case, thanks to good defense counsel, good lawyering, they had a couple of posts from that juror and presented them to the trial court where that juror had said that the parents of Professor Markell should assist in killing Mr. Garcia, and then went further when my client was charged and said, surprise, surprise, Mr. Adelson is charged. But the worst one is by far the next one. Mr. T is how I refer to him, as the first initial of his last name. Mr. T stood in front of the trial court and when asked, have you formed an opinion about whether or not this defendant is guilty? He point blank told the court, no. Lo and behold, 2 jurors later, Miss M comes in and by happenstance is asked the question, has anyone been discussing this case amongst the jurors? Oh, why, yes. In fact, that gentleman that was just excused with the glasses, what's he been saying? He's been going around telling other jurors that Mr. Adelson is guilty.
And both of those jurors were excused for cause, were they not?
Yes, but statistically, if those 2, it's very hard to prove someone's lying. Usually you rely upon some luck or some good lawyering with coming up with the post. So we know that one juror reported the other juror, and that's how we know that.
I thought he's about to say that there were 2 jurors on the jury, one of which had made posts and one had been doing what he just said. The fact that they were dismissed, like, that's now a thin argument. If he just said, yeah, both were there and they both lied, then absolutely you should get a new trial, because that's disgusting of a juror to lie to get on a jury like that. That should never happen. But they were both dismissed. So I don't know.
The juror was lying.
And then being careful, defense counsel was offered the opportunity to review the tapes of the jury assembly room to see what comments were made, what are the reactions of the other jury members, and defense counsel said, no, I don't want to see it.
But here's the problem with that, and going to the second claim now. The second claim is a very specific, easy fix. We know for the second group of 50 jurors, 51 through 102, problems were happening. We know about halfway through jury selection, it's reported, number 1, that jurors have not followed the judge's direction, so much so that the judge, when he heard about this after 2 of the jurors reporting that the jurors have been talking about the case, goes out and admonishes those jurors pretty sternly, do not talk about this case. But we also know...
But the problem is the content of those communications. And they were like this, high-profile case. It's the Charlie Adelson case. It's the Dan Markell case. Which of the... And that he's guilty... but again, the trial court offered your client the opportunity, the defense counsel, go listen to the recordings in the assembly room and you can bring back some statements that would in fact taint the jury. How did these statements taint the jury?
We have 4 statements, right? So we have one where a juror said, we've been talking about it all day, is literally the quote. We have another where there's some pretty...
Talking about it, I mean content. Let's get to the content.
Talking about the case all day.
Again, but that you could have questioned those jurors to get specific information on what content tainted the jury.
Okay, that's one juror. A second juror then said that there had been a lot of talk about he's a professor at the law school and revealing a lot of the facts about the case. There was a divorce going on between the professor and the wife, but the 2 that are far the most concerning are the 2 jurors that specifically went back, a male and a female, the one with the glasses and then an older female that went back and told the other jurors he's guilty. In fact, if you look at juror C, on page 2581, you have, coincidentally, when she's asked, after she reports that she's heard that this female juror is saying that he's guilty, oh, what's your opinion? I think he's guilty too. This is influencing the entire, that set of the panel. So let me come back to why I think this was an easy fix. There was 3 groups of 50. It was clear 8 of the jurors that sat on the jury came from this middle group, 51 to 102. At the midway point, the judge admonished the jurors to no longer talk about the case again, and the judge said from this point forward, every juror, we should ask them, have you been discussing the case? Of those 8 jurors that came from the middle group, 4 preceded those 2 things. So for those 4 jurors, we have no, and I can quickly tell you the page numbers regarding those. I have the names, I apologize. I will say them. It's Brazos, 2467, it's Kraft, 2497, Milne, 2514, Hawley, 2528. Those 4 jurors were all exposed to
somebody saying, I think that the defendant is guilty.
Yes, multiple
So-
times.
Okay, so they rendered that, so you have jurors who probably shouldn't be serving and didn't serve, is my understanding.
How many other were influenced by that?
Expressing their opinion that the person was guilty. But don't we typically, we're going to strike a panel, or require the striking of a panel when facts come in that would otherwise not be admissible. Isn't that the typical standard for striking a veneer?
Strike 50 jurors, just those 50. The clerk actually
That's fine,
said,
but the reason for it isn't that somebody has rendered an opinion as to the guilt of the defendant. It's whether they've been exposed to facts about the case that would otherwise have been inadmissible.
oh, I don't agree with that, Your Honor. Jurors constantly saying, when they've been told not to talk about the case, talking about the case and saying he's guilty, and being exposed to that, when you already have all of the social media presence that's involved in this case, that's improper. And again, the fix was easy. When they weren't sure in the 3rd group of 50 whether or not they were going to finish, the clerk said, we have another group of 50 downstairs. How easy would it have been for the judge to say, wow, I mean, he was mad, you could tell. I'm frustrated. They're not following my directions. They're lying.
Couldn't we have sidestepped some of this speculation if the tape of the jury assembly room had been reviewed and then some content specifics argued?
I think it's clear that this 50 was tainted. And if you go back to the Manning case, what the Florida Supreme Court said.
Bad Daza's in the house. Hey, Bad Daza. How are you, sir? Hope you're doing well, my friend. So, what they're saying is that there were allegedly four potential jurors, 2 of which lied and said that they know nothing about the case and they hadn't formed an opinion. But because they were in a set group of 50, they were split up 50 in different rooms. That the 4 of them spoke about it and rendered to the group saying that they knew about the case and that the defendant was guilty. And what he's arguing is that would have impacted, whether directly or indirectly, all the jurors in that room, and they should have all been dismissed. Potential jurors should have been dismissed on that occasion, which, yeah, probably they should have. But it didn't happen. So, you know, the judge did, I believe, give them all a bollocking, and he reprimanded all the potential jurors at that time to be like, you cannot discuss your opinions on this case. And he did offer the defense the opportunity to look at all the videos of them all discussing stuff together, but it didn't happen apparently. So, yeah. I mean, I think it's a thin argument. I don't think it's going to have any weight on these judges, to be quite honest with you. And I agree with that judge who just said, no, possibly they should have all been diminished as a group of 50. But I mean, you can't have I personally don't believe you can have a new trial just based on that. That's too thin for me, personally. So, you need a hell of a lot more than that. But I do agree there was a cock up at the beginning. I understand the judge gave a sanction at the time, but they should have been removed. All of them should have probably been removed, just to err on the side of caution, and also to ensure that this kind of hearing never happens. But, you know, you can't overturn a jury's verdict in my opinion, based on what's being sold right now. And Badaza's here. We got commands now, Badaza.
Said that every reasonable step should be taken to preserve a defendant's trial by an impartial jury, and to this end, if there is a reasonable basis shown, the court should take action. There's, without question, a reasonable basis. We have one juror that said, living in Tallahassee, you'd have to be under a rock to know about this case. Another juror said, the impact that this had on me, when you hear about this, it sticks with you. We have so much about this case, but then when you boil it down to that middle 50, and we know that there's not one, not two, 4 different jurors that has disclosed that they've been talking about the case, and it's getting the judge frustrated. He has to re-admonish them, but he doesn't go back and question the ones that have already been questioned about whether or not they've heard discussions from other jurors, and 4 of those jurors who were never questioned ultimately sat on this jury. That's a reasonable basis for the judge to have taken the easy step. You're right, at this point I'm frustrated. They're not following my instructions. 51 through 102, they're done. Let's bring up the next 50. I will be very clear going forward. He was. And if we need to go to the 4th 50, we will. That's what should have been done, and because of that, my client didn't get a fair trial. I'll reserve my last minute for rebuttal. Thank you.
And I will extend you an additional 3 minutes, and the same for the state, so you'll have a total of 8 extra minutes.
Thank you, Your Honor.
May it please the court. My name is Charlie Lee. I work for the Attorney General's office, and I represent the state of Florida in this case. I'd like to start out with the questions that judges here have asked today. One thing I do want to clear up is the preservation issue that Mr. Adelson claims in Manning in his reply brief. He talks about that in that case, the attorney below never filed a written motion, didn't renew his objection to the jury or anything like that. Those facts come from the dissent in Manning. The 3 justices of the Florida Supreme Court who felt that Manning should not have his conviction overturned, who felt he did get a fair trial, noted that his attorney affirmatively accepted the jury. Now from Manning, we've come to Armstrong. And Armstrong is backed up by all the cases where we have Batson challenges. If someone files a Batson challenge saying they didn't have a fair jury because of the demographic makeup of their jury, if they affirmatively accept that jury, then they've affirmatively waived that objection. They have to do it once again. They cannot accept the jury like Mr. Adelson did twice to his jury and to the alternate jurors.
But isn't really, change of venue is not the same as failure to renew specific challenges to specific jurors. It is a much broader, as Mr. Offerman was talking about. It has to do with what was known by the community. It's whether the community is one that cannot hear the case. It's not necessarily about individual jurors. So why should we apply this rule that, I understand what Armstrong says, but I've also read Joyner, and I know that that's where the Supreme Court first made this rule very, very clear, and they made it in the context of challenges to particular jurors. Why should we apply it? Forget what Armstrong says. Why should we apply it?
You should apply it because it is about individual jurors. Because Mr. Adelson, he's entitled to an impartial jury. He's not entitled to an impartial community or city or world. There are people out there who are going to prejudge Mr. Adelson's case. There's people out there that will prejudge every case. In every jury selection, there will be jurors on the panel that will say that they believe the defendant's guilty just because he's sitting in the defendant's seat. That happened in Mr. Adelson's case. It'll happen in every case that's tried this week at the Leon County Courthouse. It has to do with the actual jurors. One of the things that Mr. Adelson brings up in his reply brief is structural error, and I'm going to explain why this isn't structural error, although Mr. Adelson has waived that because he didn't bring it up in his initial brief. But let's look at the 12 actual jurors that served on Mr. Adelson's jury. Adelson accepted all 12 jurors during the pre-screening phase. All 12 said that they would be fair and impartial. Mr. Adelson gives us no reason to believe them. As Judge Thomas pointed out, there's not a clear record here of why we shouldn't believe them. And Judge Rowe pointed out, because affidavits weren't filed in this case, we don't know what the pretrial publicity is. This isn't like Shepard v. Maxwell. This isn't like Irvin v. Dodd, where Mad Dog Irvin was in the press, as a serial killer in the press all the time. It's not like those cases. We don't know because Mr. Adelson didn't file a legally sufficient motion.
But he did show that of the 54 prospective jurors who had a considerable amount of media exposure, that 53 of them found that Mr. Adelson was guilty and said that they couldn't be impartial. Now, there's much of jurors might be lying about whether they had the exposure. Is it also possible that jurors were lying that they couldn't be impartial and absolutely thought he was guilty to get out of jury service? I mean, I think there's a lot of speculation going on here that we really can't get to.
Well, that's where I point to Singer, a case that Mr. Adelson relies upon. And in that case, and this is a 1959 Florida Supreme Court case, they said that the Florida Supreme Court said they had some doubt as to the impartiality of a fairly large number of the veneer men, which might be indicative of the inhabitants generally of the community. But we cannot determine error on doubt. That's the Florida Supreme Court in Singer.
So would it have been different, for instance, if Mr. Adelson had brought forward evidence that there were 100 broadcasts on the Preston Scott Show, that there were 200 pieces by WCTV, 300 articles in the Democrat, 50 podcasts and court TV programs, and that all of the speakers in those programs, or some high percentage of them, pointed to guilt for Mr. Adelson? Would that be different?
It might be different. All we have is secondhand knowledge of the jurors that were there. That's all we have. It might be different. We have, I think, the court TV host is the only one that we know expressed a negative opinion.
And even the jurors who were interviewed about their exposure to the media sources I just listed, some of them found that those sources were credible, and some of them found that they weren't credible. They called into doubt whether the person who was on one of the news programs was partial or not, right?
Correct, Your Honor. And as to Mr. Adelson's numbers, I disagree. I noted he quotes 29 jurors in his initial brief. I noted 22 that said they couldn't be fair and impartial. But even saying it's 40%, which I believe is what he's arguing today, that's a far cry from Irvin, where it was 2/3 of the jurors had extreme bias against Mr. Irvin. I mean, he was a serial killer that in the press, I believe, several states had, sheriffs had said that they were going to make sure that he died, was executed. One of the cases, Murphy, and I do agree with Mr. Adelson, there are some similarities between issue 1 and 2. And moving on to issue 2, we have to give jurors credit. Just because this young man said that Mr. Adelson was guilty, and another man may have forgotten what he posted on Facebook about Mr. Garcia, that doesn't mean that the entire jury pool was tainted. As Judge Thomas pointed out, the defense counsel was given an opportunity to go back and review video of the courtroom or the jury assembly room wherever this happened. They were moved from the jury assembly room to courtroom 3G, and the defense declined. So we don't know, there's no indication that this young man stood up on a chair and yelled this out at the jury pool in general or whispered it to someone. We don't know. As far as the gentleman with the Facebook page, we don't know exactly what he posted about Mr. Adelson other than he said something about surprise, surprise. And the defense counsel didn't establish a record. And again, going back to Singer, we're not going to reverse this case based on doubt. This isn't a case, because this is not a structural error. And neither the U.S. Supreme Court nor the Florida Supreme Court has ever held that a failure to change a venue or denial of a change of venue motion or prejudice within the community or bias amongst prospective jurors has ever resulted in structural error or per se reversible error.
Didn't the Manning court, though, suggest that a venue error is a structural error?
I don't think so, Your Honor, because they looked into, the majority in that case looked into the individual facts, case by case. When we get to Rawling, there, and McCaskill, there the courts, and that came long after Manning, they've developed a test to find out. And this is why, in this case, we had 2 voir dires. We had the pre-screening process and then the actual voir dire, which is, far more than the average defendant gets. And that's so we can suss out and we can identify prejudice amongst those jurors, because no court has ever held that, bias amongst jurors in the jury pool would result in a structural error, because that doesn't affect the framework. Now, if there was something inherently wrong with the voir dire process, perhaps. Now, no court's held that either. But in this case, there was no problem in the voir dire court. The judge here went above and beyond by having the pre-screening process, then the voir dire, where counsel will get an extra chance to challenge jurors. One of the things in this case is the defense counsel didn't ask for any extra peremptories. He didn't even use all 10 of his peremptories until the very end of the voir dire process, which is a factor in Manning. And it's why we have those factors, is because with structural errors, those are errors that are so, such as a right to an impartial judge. It's not like we can question a judge, or the right to a defendant's right to represent themselves. We can't question a defendant about why he wants to do that. Or a public trial. If there's no public trial, we don't know what happened. We can't peer in. We can't look behind the veil and see what that error might have caused. But in this case, it's perfectly clear. Mr. Adelson agreed to 58 jurors. The jurors that served on his jury, only one of them heard another juror talking. 3 of them had no prior exposure to the case. And all of these jurors, Mr. Adelson agreed to.
Well, could you address, the preservation issue aside, let's go to, can you address Mr. Ufferman's fundamental error argument?
I don't think that he can show fundamental error, because he can't show that in any other venue that Mr. Adelson would receive a fair trial. This case, in modern cases often, a fair trial, a different trial, a different result. Fundamental error requires the defendant to show that a different result, but for the lack of change of venue, that his case would have ended up differently. Well, that's not the case here. There's been no demonstration of that.
So it's not just fundamental error that he didn't get a fair jury. Wouldn't that be fundamental error in and of itself, regardless of what the outcome of the trial was?
Well, if he could show that he didn't get a fair jury, but he certainly did.
Well, that's his claim.
Well, it's his claim, but he hasn't shown any evidence of it. He hasn't shown why this particular jury, these 12 jurors, were so biased that, that the outside influence on these jurors would have changed their verdict. He's made no showing of that whatsoever. He didn't try to poll them. I mean, they polled them after the trial, but he didn't try to question the jurors or anything like that. There was a motion later, but there's no evidence in the record that these jurors were influenced. Like I said, 3 of them had never even heard about the case. So there's no evidence in the record whatsoever that his actual jury, because he has a right just to an impartial jury, that they were influenced by the media and the local, the conversations around Tallahassee influenced their verdict. There's nothing in the record.
I think his argument is that the media saturation implicitly biased the jurors, I think, is one argument. Maybe another argument is that they are lying. They were lying when they said that they could be impartial. And he's pointing to the 2 jurors who did, in fact, lie. And then again, he points to the 53 of the 54 jurors who were excused for cause because they had consumed the media and felt that they could not be impartial in this case. So that's the evidence he's pointing to. What do we do with that?
Well, Mr. Adelson is asking this court to presume prejudice there, which is something that this court could only do under a structural error argument, which he's waived, and no court has ever held that it's a structural error. This court should not presume error, and Mr. Adelson has not proven any error. He hasn't proven by not filing a legally sufficient motion with affidavits that show what the media coverage was. We had that in Foster. In Foster, the defendant there filed news clips, articles that were far more negative against Mr. Foster than anything that we heard. All we have is secondhand accounts from other jurors or prospective jurors about what the media publicity was. But assuming what they said was true, what happened in Foster was far worse, and what happened in Rawling was far more extensive. And this court, there's no reason this court should presume prejudice, and if there's no reason this court should find prejudice if Mr. Adelson hasn't proven it, and he has not.
Well, Mr. Adelson argued in the brief, or counsel argued in the brief, again, that the media environment in the Rawling case in 1994 is substantially different than it was when Mr. Adelson's case went to trial. What do we do with that?
I don't think that's necessarily true. We don't know much about Mr. the media coverage around Mr. Adelson, but in this day and age, no media is really local. And in this case, there was over the My Dead Body podcast, there was national news. People were following this all over the country and all over the world. The environment hasn't really changed. Really, the important thing is local sentiment. If it's something that shocked the community, this is as bad as Dan Markel's murder was. 30 people on the jury, prospective jurors, had never heard of the case. In a town like Tallahassee, where people are coming and going quite a bit, it's even less than, in Gainesville, sort of the same situation with Rawling, but in Foster, that murder there with the extremely negative publicity didn't warrant a change of venue. And Foster was after Rawling. So I don't know that, I understand Mr. Adelson's arguments at times have changed, but I don't think people have. It's when we do go to pick a jury, we ask jurors, in that community, can they be fair? What have they heard? Can they set these things aside? Because after all, that is the standard in McCaskill, not whether they've been exposed, but whether they can set aside that exposure.
Does it, as long as we're talking about distinguishing the Rawling case, does it matter that we have a notorious murder and we have a lot of media from it? In the Rawling case, we had a literal serial killer on the loose, killing people. I don't think anybody in Tallahassee believed that somebody was going to pay Garcia and Rivera to come up to Tallahassee and kill them. That was not an irrational belief in Gainesville when there was somebody who literally was brutally killing people day after day for a while. That has nothing to do with the media coverage. That has nothing to do with what was happening in 1994 when he was being tried. But does it have anything to do with the decision of whether to change venue when you have something well beyond the media in assessing how the community may have felt?
I agree, Your Honor. In Rawling, the Associated Press described him as the next Ted Bundy, basically. And there is that fear and that shock. And I don't want to downplay Professor Markel's death. It was shocking. It was terribly sad. But you're right. It was certainly figured out that this was a murder for hire. And by the time that Mr. Adelson went to trial, this court had already affirmed Garcia's conviction. This was a murder for hire plot. The people in the community were not at danger as they would have been with Rawling or Bundy or even Foster with these Lords of Chaos group. I agree with you, Your Honor, that when that fear stays in a community, that can certainly poison their minds. But in this case, that fear that would have been there in Rawling and Gainesville in the 90s would not apply to Mr. Adelson's case. And like I said, it's not surprising that only 22 jurors said that they could not set this out of their mind. I know
Isn't there a difference here, though? I mean, unlike the Rawling case, there's been, now 12 years of sustained media coverage. There have now been 5 convictions in this case, and at the time of the trial, there had been 3 prior to Mr. Adelson. Doesn't that make a difference?
I think it can work both ways. I think the saturation and the fact that this case has been going on for so long may dull the senses of people. They hear about it, they get disinterested the more they hear. I mean, but I think one of the factors in Rawling is the time of the publicity and the trial itself. In Mr. Adelson's case, the crime was far removed. 9 years, as one of the jurors pointed out, prospective jurors pointed out. But the The nature of the coverage matters a lot too, and the nature in relation to the time of the trial. And there's nothing in the record to indicate that there was negative publicity about Mr. Adelson around the time of his trial that would influence the jurors to reach a guilty verdict instead of an innocent, or instead of acquitting him.
And again, that's perhaps where an affidavit may have come in and to help the defense in terms of how many media stories there were within the relevant period, the content of those stories. Again, we don't have that in the record. We just have sporadic references in the record where jurors were reporting that they had seen some media at some time.
I'd argue it's why the rule exists. It's why the rule requires
as long as we're talking about
affidavits.
the rule, counsel, I noticed, Armstrong talks about how a change of venue motion is premature until there's been an actual attempt to impanel a jury. I understand what they're getting at, just on its face, but I'm having trouble understanding how that requirement it plays into the requirement that there be a written motion for change of venue. Do you try to, do you attempt to impanel a jury, and then when you can't, you say, hold on, Your Honor, give me a few minutes so I can write out a motion for change of venue because the rule requires it to be in writing? In other words, is the requirement to be in writing unrealistic given the separate requirement that a motion is premature until you attempt to impanel a jury?
No, Your Honor, the rule is not unrealistic because it requires the defendant to make the initial record that he needs to make. And that is, if the defendant files the motion before trial and has the affidavits, which he should, like some of these cases, they went around town doing polls. And in Foster, they got the news coverage and everything before the trial. So it incentivizes a defendant to go out, get the information, poll the community, make the record for their motion, file the motion ahead of time. The court's under advisement that this is an issue, which in this case it was an issue even before jury selection. The court then, the judge in this case, then wisely took the effort to have a pre-screening process and a voir dire. And so the rule is not unrealistic. Now, the Florida Supreme Court says that we have to go ahead and try to pick a jury anyway to see if we can determine whether there is a bias within the community that can't be overcome, but we have to test that. That's one of the reasons I'm arguing it cannot be a structural error, because this is something we can palpably test. And so that's why I believe it's not, the rule makes a lot of sense that it requires a pretrial motion with the affidavits. To conclude, I'll move on to issue 3 briefly. I think in this case, one of the things I want to argue about the evidentiary issues is Mr. Adelson's, when he brought his text messages to the court, he never took the opportunity to untangle them for the trial judge. And the trial judge should not have been required to do that for Mr. Adelson. And that's why I'm arguing it's not just unpreserved, it's an invited error, because when the trial judge asked Mr. Adelson, if you can get some texts for me that are relevant, that would show what you're trying to prove, he just said all of them.
But that is their argument. Their argument is all of them should have been admitted, not 1 or 2 that the judge might find relevant, but all of them. How can you waive that argument simply by refusing to cherry pick ones?
Because the only relevant arguments would have been the, if there were any relevant. I argue that even these weren't relevant. But the conversations between Meg Benoit and Donna Adelson and Wendy Adelson, he didn't separate those out and offer those to the court and say, these are the relevant text messages and this is why they're relevant. He should have done that. The judge was under no obligation to untangle those for Mr. Adelson.
And I think there was concern about the content of the message. I think you characterized the messages in your brief as racist, misogynist, and sexist. And I can imagine that had those been admitted, Mr. Efferman might be right up here arguing unfair prejudice against his client because of this bad character evidence.
Correct, Your Honor. The judge has to act as the gatekeeper of evidence in every case, and in this case, we may have very well had an ineffective assistance of counsel in the face of the record argument had the judge not asked pointed these things out to Mr. Adelson and asked him.
Is it really the judge's job to protect the defendant from himself, though? I mean, if counsel believed that the strategy included admitting these text messages that might otherwise be viewed as negative to them, isn't that really a strategic call on counsel's part?
If it's a strategic call that no reasonable attorney would take, I think a judge does have to step in. A judge will have to step in even under a 403 analysis, if something's more prejudicial than probative. In this case, those texts were certainly more prejudicial than probative. Yes, a judge should step in.
Even if it's prejudicial to the offering party?
Yes, sir.
I'm not going to allow you. I think that would harm yourself if you admitted that, so I'm not going to allow that evidence in. I don't think I've ever seen that.
I think in the interest of not vitiating the entire trial, a trial judge should do that, and because otherwise, he's letting the defendant walk himself into a mistrial, and a judge should not allow that to happen or be forced to allow that to happen. Based on those arguments, Your Honors, I would ask this court to affirm Mr. Adelson's conviction for his part in the murder of Daniel Markell.
May it please the court. I'll begin by briefly addressing Claim 3. Here's why it was so prejudicial to my client to not get in the other text messages that the state was pointing to and suggesting that they had to have been about nefarious things as opposed to routine things. The text messages that have been proffered, they clearly are routine things. This is what the prosecutor argued in closing, page 2082. Quote, but as the defense points out, these folks had independent relationships with each other that could explain those communication patterns. So without knowing the content, how could we know if they're really talking about murder or if these call flurries around key events are just coincidence? A conspiracy can be shaped like blah, 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 and she goes on. Without knowing the content, the state objected to the jury being able to see all of the content. And now they seize upon that in closing argument and say...
I'll ask you the same question I asked the state. I mean, if these messages, which were labeled as racist, misogynist, and sexist, had been entered against Mr. Adelson, wouldn't you be arguing here that the jury was prejudiced against him in terms of this bad character evidence?
Absolutely not. Number one, that would be the actual definition of invited error. Number two, my client would be... I'm sure it's not great, but he can take the label of being racist, misogynist, whatever else. He doesn't want to take the label of being murderer. And these texts would have helped him show that what the state was arguing is not true, so much so that the state seized upon it. He doesn't need protection from himself, as Judge Winokur's already indicated. He has a right to put on evidence that he thinks is relevant. Mateo says any evidence that could be in any way even in a slight way relevant to the theory of defense, a judge errs in not allowing it in. The purpose of putting these texts in is not, as the trial court was saying, oh, do they go to motive or they go to any element of the crime? No, they go to showing that these are routine communications, not what the state is asserting. And he was prevented from putting that in, and the state seized upon it in closing.
Was this, if there was error, is it not harmless? He was allowed to testify about these texts on the stand.
Wow, my client was out on an island in this case. There's no question that it was, one other witness was presented. My client's testimony. Is there anything to back up my client's credibility? This would have been something that the jury could have looked at and said, wow, Mr. Adelson saying that he didn't do this, he didn't hire these people, he's the one actually being extorted. But there's nothing that supports that other than his testimony. This would have been, wow, look at the text messages. See them for yourselves, ladies and gentlemen.
How was your client on an island? I mean, certainly he could have brought forward the mechanic he was having the conversations with and all of the other people to testify about the kind of communications they had with your client.
You all know very well that I think defense counsel was ineffective and had a conflict of interest. I'll raise that at another date should I need to.
But it's clear that your client was not on an island, that there could have been evidence presented that would have corroborated what was in the text messages.
I agree, and the judge prevented it.
Right.
That's the whole reason for Claim 3.
Counsel, I want to go back to something that we talked about at your initial argument about what needs to be shown to strike the entire panel. Now, I did look and I saw that this wasn't cited in any of the briefs, but I'm going to say it anyway. It's Morris, Florida Supreme Court from 2017, and the quote is, "For the statement of one veneer member to taint the panel, the veneer member must mention facts that would not otherwise be presented to the jury." So is that the correct standard to be used in striking an entire
I think
panel?
that's one aspect of it, and I acknowledge that's not met in this case. Clearly, the facts that were discussed did come out during the trial. I think the bigger issue is the expression of guilt. So I think the case that's closest on point is Brower, cited by the state. And Brower, the comment that was being made by a particular juror was they should just hang him. And this is what the 4th DCA went on to say. This is on page 1027 of the opinion. The offending members of the veneer were facing a 3-week murder trial and were enduring a tedious and lengthy jury selection process. They certainly used poor taste and worse judgment. However, there is nothing in the record to indicate that the offensive remarks were offered or taken seriously. The 4th DCA is finding that the comment, he should just hang himself, was literally a joke, not an expression of the defendant's guilt. That's not at all what we have in this case. I see them into over my rebuttal time. I would ask this court to reverse, and I would end with this. If there was ever a case for a change of venue, these facts are that case. Thank
Counsel,
you.
my colleague has a question,
Oh, of
so
course.
I'm going to extend your time for her to ask it and you to answer it.
Thank you.
And appropriate, your last sentence said on the facts of this case, and that's what bothers me, and I would like a response from you. The fundamental error argument. In this case, on this record, we're arguing speculation. If you're arguing fundamental error, and you're asserting speculation of prejudice by the jury, in practical application, you're lowering a fundamental error standard below even abuse of discretion to me. So, on this record, your argument on fundamental error to me, I guess, help me understand what more than speculation is backing up your fundamental error argument.
Yes, Your Honor, and it would be, and I know they've been mentioned, but I will go and I have them written down right here. 40% of the jurors had formed, of the 130, belief that my client was guilty. Only one had not, or thought that my client was innocent. 3 prior cases, as has been discussed, and one of those cases was 2 trials, one of which occurred a year before. 10 years, almost a decade, this case has been going on in this, as the judge said, small community. 2 jurors lied. So it's not just speculation. If I was suggesting that, based on this, we can suspect that some jurors are not willing to tell the truth and really tell the court that they've already formed an opinion. We know 2 jurors lied. One of those, well, both of them lied and specifically had an opinion about the case. And ultimately, the jurors directly violated the court's order and talked about the case even though the court specifically said don't do it. When you consider all of those factors in their totality, we establish fundamental error in this case. Thank you.
Thank you, counsel. Thank you both. This court is adjourned.
All rise.
That is what I've just posted. This is just comes through as Commonwealth v. Aidan Timothy Kearney, interim order, motion to disqualify. After the hearing on January 30, 2026, the court makes the following interim order. The court will defer on any ruling regarding papers number 110 and 107 until March 13th, 2026. No later than March 6th, 2026. Special Prosecutor Cosgrove will inform the court in writing if he intends to have an assistant special prosecutor available at trial in the event that Ms. Gadani, whatever her name is called to testify at trial. In the event that Special Prosecutor Cosgrove intends to have an assistant special prosecutor available at trial for the purpose of cross-examining Ms. Gaetani. Such assistant special prosecutor must file their notice of appearance with the court no later than November 23rd, 2026. Well, considering that the trial, I believe, is December 1st, they will leave that till the very last minute, I suspect. And Aidan's words were that as well. It's on Twitter, so yeah. So there's that. That's what's going on in that world. Right, let me make this smaller. Let's see if they're back here. No, that's not what we want. What we really want. We wanna. If you wanna be my lover, you have got to give. Taking is too easy. That's the way it is. Right. Let's press play on this and let's refresh it in a second to get it back into play. So this is supposed to be back in 4 minutes, but we know by now that this court never really starts on time. So we shall see. With regards to Adelson, I do not believe that he should get a second trial. But that's why I always bang on about how important it is, to make sure that the trial is run properly in the moment. Because you don't run into things like this then. Do you know what I mean? So, where people can appeal and do all sorts of things. So, it sucks, No, 2 jurors did not lie, Crystal. No, none of the jurors on there lied. None of the jurors in the trial lied. There were 4 potential jurors that lied, but none of them were selected. So that's why, there's no one. So the however many it was, 2 or whatever it was, that were on the jury, they were part of the 50 group that these 4 were in, but it's not to say that they were influenced whatsoever with anything. So that's just to clarify, there were no jurors on the panel that lied that we are aware of. They were just potential jurors, so yeah. Yeah. I mean, look, I don't discriminate. People can hate whoever they want. People. I support Aidan with his rights of a fair trial. I disagree that he has done anything wrong. So, anyway, moving back to this trial for a second. How many times is the defense attorney going to piss off the judge this time? That is going to be interesting. So, I don't know. I think the defense attorney could lose it for himself. Potentially, probably. Because Dave keeps saying that he's the best attorney in Georgia, but that's come from a chat in Law and Crime somewhere. That's not like a proven thing. So I don't know. I don't know how far is he going to take this to annoy the judge, but also in turn potentially annoy the jury. I don't know. I do actually think he's a good attorney overall, but what I've seen so far, but he just has to be so careful. I understand he's doing a lot of this for theatrics as well, so that if it does go, if his client is found guilty, that he can say, well, the judge, I just totally disagree with the judge and her decisions. I had to walk on eggshells, blah, 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 blah. But I think we all are looking forward, hopefully, to seeing Chris. If he's not called up as a, as a state attorney, then he should be as a defense attorney. witness, not attorney. I just can't see how they do not. Is it? Yes, do not call him. He is. I mean, there's more question marks over him than even the defendant. You know, I just think there's a lot of question marks over Chris, the ex-boyfriend. There's a lot of things there that I question. And as I haven't properly seen his hands, but you all say he was a mess. His hands were a mess afterwards, so which is not very good for him. But even though he says he's a plumber, but I mean we all know plumbers have soft hands. So right, what else is there? It is 8:30. Sorry, 8:30. 6:30 here. I'm having turkey and stuffing sandwiches for dinner. That's my dinner. I've not eaten yet today except for this coffee which I spilled all over, which I've just stained some stuff with. Happy days. Bollocks. What else we got here? So we know that Mexi and Lady Di are at the she shed somewhere. They're both out there, busy, entertaining themselves. Dave is in chat annoying everybody. Bad Daza had a late start today, which is unlike Bad Daza. He's always, but to be fair, he's also one of those that goes in too many streams. You know, I scrapped the wax for me. So hubby came to the she shed and scrapped the wax for me. What are you doing to your intimate life, Lady Di? That's down to you. That's down to you. You know, if you wax down there or not, that's totally down to you. You know, but I'm glad he helps you as well. I am very clumsy. Not stained on. You have aged the paperwork. I know. I wish there's a paper though. It's actually like a nice tabletop. I've already stained it before. I ruined it. It cost like £600, and I've already ruined it. Unfortunately, it's like a TV cabinet, and I've ruined it. But I ruined it last year because I'm clumsy. Oh, right, come on, Judge. Get back on time for once. For once in your life, get back in time. So Dave is also here on time every morning because Dave likes this judge. She's within his age range, so that's why Dave is always horny in chat. So just remind you, we have got some commands in the chat now. So if you do want to use some of them, I think hello. Sorry, no, it's the exclamation mark hello, exclamation mark donate, exclamation mark hack, exclamation mark Dave, exclamation mark Rose, exclamation mark hug, exclamation mark lurk, and I think there's a few others as well. I'm still waiting for those tacos and tequilas. How Dave is, you know, come on Dave. It was great on carpet, wax. Right, come on. Because I need to go and make my sandwich. I will be honest with you though, I'm not into this trial yet. You know, I'm maybe because I've missed some stuff. I'm not into it, personally. You know, so I'm not sure. Oh, let's do a poll. Should we do a poll? Not that kind of poll, Lady Di. An actual poll. Start a poll. Okay, poll started. Hang on, lady. Hang on there in hack. Let me do this then. Let me do it like this. These are the commands. So it's, you see, exclamation mark, uptime, exclamation mark, lurk, exclamation mark, hug, exclamation mark, hello, exclamation mark, welcome, exclamation mark, tip, exclamation mark, street, exclamation mark, stop, exclamation mark, rose, exclamation mark, lahak, exclamation mark, hack, exclamation mark, donate, exclamation mark, Dave. Those are so far. There will be more. There's going to be more. There will be more. I've not had breakfast, lunch, or dinner yet, Dave. I'm on a eat one meal a day. There you go. Hippie chick got the street one. There you go. So those are some of the commands. I'll do more. I'll do more. Tip. Tip. Everyone likes a bit of tip now and again, don't they? Just a tip. So the tip one is not the best one. The donate one is always the best one, people. Buy me a coffee. That's the best one. Lots of you have used lurk already because you're lurking. You're lurking. Beep, 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 beep. No, you won't. You'll never confuse the bot. So the bot, just to clarify, the bot is only there for some of these things, just to help. Thank you, Mexi. Mexi sent a screenshot. This is just to help the mods, because obviously the mods got other stuff on, they're working and stuff like that. So when people ask for links for Buy Me Coffee, they only need to put in that thingy exclamation mark and then donate, and then it takes them there. And if they want to say hello, they can do exclamation mark hello and stuff like that. So that's why. Anyway, let's take that off. Bum ba 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 bum bum. Hey girls. Bum ba ba bum bum. Okay. Taco Tuesdays, Aaron's Taco. Everyone remember Aaron's Taco? Where's Aaron's Taco gone? Oh, here he is. Here's Aaron's Taco. I love eating Aaron's Taco. Look at your message. Look at your messages, Sarah P. But also, they're not for like. There to help you out, Sarah P, more than anything. It's more to help you guys out. You carry on as you are, Sarah P. You're doing a wonderful job, so you can carry on as you are. With they're perfect. I forgot to do it today, but I can still put them at the top. It's not doing this trial. You're right. Sorry, I should not be eating Aaron's Taco during this trial. So it's more for the people in the chat to use than anything else once they get into it. So, yeah. We'll get into it, and I'd take some... yes, I appreciate all the help that people can give Sarah P as well. That would be wonderful. No, you carry on as you are. You do a wonderful job, but I can still pin them in the mornings at the top, and then people could just, like the roses for Dave because he loves to give roses out. So that's why it's named Rose. We don't have a public one, Dave. No, not like you think of. No, I just have a small one for the mods, just to keep everyone in one group. It's mainly for them to keep me in track, David. The Streamlabs is number 1. I know. Sarah P is number 3 and number 2. Oh, she's number 2 now. We have a Facebook group, David, which I believe you're a member of, Dave. That's where people can discuss things. It's a very inactive Discord group I have, Dave. It's more about Facebook and stuff, which I need to use more of. No one posts in Discord whatsoever, Dave. So, but Dave is a member of all the bitchy things. You're a member of the Core TV Discord, the Law and Crime one or something, Dave, aren't you? You've got all your Discord sorted. Oh, you don't have this. I thought you did. Oh, you got Twitter. Sorry, X. You've got. Sorry, X. You've got. Oh, come on. This court needs to get better. This court needs to be better than there is because. Because they're late starting in the morning, late now. Riff-raff this good daddy. There you go. There you go, Dave. I don't like this kind of lateness. It's like, come on. Because I should I play something else? Should I not? Do you know what I mean? I'm also getting grouchy. I've not eaten. And all that. Oh. I mean, come on, Judge. Judge is also Dave's girlfriend. Or wannabe. He does love her. Boo, 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 boo. Right, what's the poll saying? I haven't even looked at the poll yet. Hang on. What's the poll saying? Where is the poll? Are you enjoying this trial? 50% say yes. 8% say no. Too early to say 42%. So there you go. Beep, 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 beep. Beep, 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 beep. Beep, beep, beep. Yeah, hang on, let me check the other one, the other hearing to see if that works. The 15-year-old from North Carolina. No, not that one. Where's it gone? I did have it here. Why is it gone? Maybe if I go back. Here we go. Teen killing spree sentence. Oh, it's on lunch break, that's why. They are on a lunch break as well. My page needs to be reloaded. Okay, I'll reload it. Fine. I'll boost it a little bit for people. And then boost that there, Right, what about get out? I don't want the chat. Then we got the sentencing one is still ongoing. They're just on lunch now. I think it's going to take a few days to do the North Carolina one. So maybe I'll watch it during verdict watch or something for this trial. Okay, that's there and that's there. I just noticed there. Fine. I keep losing my place here, but it's fine. Oh. I just don't like the fact that if you tell me you're going to be there and starting back up at a certain time, and you're now 16 minutes late. This morning she was late as well. I lose respect for this judge already. I just wanted to start on time. If you tell us you want to start at this time, start. Stop wasting time. Defense attorney and the judge. Stop wasting us at times. Lady, I can chat now maybe, but what the hell is he rambling about me? I'm just whinging. Do you know what? I'm hungry. So if you want to piss me off, people, now's the time because I'm hungry. So I'll tell you what I think. I am hungry. I need to pull the weeds in my flower bed too. I need to pull the weeds in. Oh, I won't say it, it's rude. Okay, we're live on that one now. Fine, perfect. I can't turn my mic up. My mic is at maximum. My mic is 100% maximum. That there is no louder. It's literally the loudest you'll get. Just to prove it. Oh shit. So this is my mic. It's at 100%. Oh, here we go.
Yes, sir. I believe I was.
Okay.
You motherfuckers, so they've been back. It's only now this fucking cameraman, piece of shit.
And did you receive any information regarding an incident at 160 Fawn Drive?
Yes, sir. I did. I was contacted by the division secretary that my services were requested at 160 Fawn Drive,
And when you say your services, what particular services would those have been at the time?
to process the crime scene for the collection and preservation of evidence.
And so what did you do when you received that information?
I went to the scene and made contact with the officers and detectives that were already on scene, as well as a few of the firefighters, and discussed the situation that we had and began the process, after the arrival of a GBI agent to assist, began the process of processing the crime scene for evidence.
And I want to pause for just a second and talk about something kind of separate from the crime scene itself. Do you recall what the weather was like on that day?
It was kind of cool and rainy. We'd have sections of heavy rain to mostly light rain, but I believe it's in the 50s, mid to low 50s, up to as much as 60 degrees.
Okay. And so when you arrived on scene, well, let me ask you this question first. Is there a typical process that you go through when you're about to prepare to process a crime scene?
Usually the first thing I'll do, I'll take video if it's necessary. We didn't do it on all crime scenes, but on the major ones we did. And then I would do photographing of the scene, and before anything was moved or disturbed, we would try to document the scene through photographs and video.
All right. And so I'm going to hand you what's been marked as State's Exhibit 36 after I show it to defense counsel. Your Honor, may I have permission to approach the witness and move freely through the well of the court?
Granted.
Thank you. I'm going to hand you what's been marked as State's Exhibit 36. Would you take a moment to take a look at that and tell me if you recognize what it is?
I do.
How do you recognize it?
It was presented to me by your office as a copy of the crime scene video downloaded to a flash drive.
Have you had a chance to review it?
Yes, sir, I have.
And does it, after having reviewed it, does it fairly and accurately depict the video that you created on January 19th of 2001 of the scene at 160 Fawn Drive?
Yes, sir, it does.
All right. Judge, I'd move to tender your State's 36 and publish it to the jury.
Any objection?
No, ma'am.
It is admitted.
Mr. Leadall, while I'm getting this set up, 160 Fawn Drive, what county is that located in?
It's in Athens, Clark County. Is that better? Just put it in there 2 seconds.
Your Honor, I'm ready to publish State's 36 at this time.
Lawyer left on, I'm assuming that that's what needs to happen. There we go. Yep. Okay. Ladies and gentlemen, are you not getting it on your screens in front of you? Okay. There are some people that are, can you raise your hand who is? Who's getting it on their screen? Just a few people. Okay, front row it looks like, not the back row? Okay, hang on just a moment. Mr. Dickey, do you think you could help us? Yes. Thank you so much. Thank you for letting me know. Let's see if we can get that working. Everybody has it on their monitor now? Excellent. Very good. Thank you, sir. You may proceed.
And, Your Honor, just for the record, I've started the video back over at the beginning. And so I'm publishing State's 36 from the beginning. Thanks. apologize. I was about to mislabel it as 36 number 2. So I'm going to hand you State's Exhibit 37. Please review it and let me know when you have an opportunity to do so.
Yes, sir.
Do you recognize State's 37?
Yes, sir, I do.
And what do you recognize that to be?
It's an aerial photograph of the development at Fawn Drive and adjacent streets, including all the residences there.
All right. And are you familiar with that area of Athens during that time period?
A little bit, yes.
Yes, sir. Do you believe that is a fair and accurate depiction of that area during the relevant time period?
Yes, sir, I do.
Judge, I move to tender State's 37 at this time and publish it to the jury.
Any objection, Mr. Cruz?
No, ma'am.
It is admitted.
Your Honor, for the record, hand Mr. Cruz State's 38, 39, 40. May I publish this using the Elmo, Judge?
You may. All right, thank you. All right, counsel, we're going to take a 5-minute recess. And so, jury, please go into the jury room. Don't discuss the case. We'll be with you shortly. Thank you. Y'all may be seated. Counsel, just a jury member needed to take a break. Please be seated. Mr. Yalomachilli, you have the floor.
Thank you, Your Honor. I'm going to start calling you Lieutenant Leadall. Every time I say Mr. Leadall, it just feels weird to me. So I'm just going to refer to you as Lieutenant Leadall from now on. Sir, you have State's Exhibit 37, which has been admitted into evidence up on the screen there. Your Honor, would you enable the ability for Lieutenant Leadall to draw on the screen? Thank you. And Lieutenant Leadall, looking at that image, can you draw a circle around where 160 Fawn Drive is located?
Yes, sir.
All right. And so looking at that image, it seems to me at least, well, let me just ask you a question. Is there anything different about the roof at 160 Fawn Drive from the other roofs in the area?
Yes, sir. It's covered with a tarp.
Okay. And could you point out where Cooper Road is in relation to 160 Fawn Drive if you just draw a line across the roadway?
Yes, sir. This would be Cooper Road here.
Okay. I'm going to hand you now State's Exhibits 38, 39, and 40. Same thing as before. Take a moment to look at those and let me know if you recognize what they are.
Yes, sir. I do recognize them.
And starting with State's Exhibit 38, what do you recognize that to be?
That is a diagram of the floor plan of the residence at 160 Fawn Drive.
Who created that diagram?
I did.
All right. And is it a fair and accurate depiction of the diagram that you created?
Yes, sir, it is.
I move to tender State's 38 at this time.
Any objection, Mr. Cruz?
Hearsay to the last two exhibits.
Any response to the objection? Oh, wait, you mean of 39 and 40?
Correct.
Okay,
Those are the
let's-
ones with the titles on them.
Okay, we'll get to those in a second. How about 38? What is your opinion on that?
I don't recall 38 had. May I ask you 38, Your Honor, just to ensure I don't.
All right, of course.
No objection to 38.
Right, it is admitted.
State's Exhibit 39, what is that?
That is a diagram of the bedroom.
Hang on a second, sir. I'm sorry. Yes, sir?
39 and 40 were the two that I had the objection.
Okay, so we'll get to that in a minute. I'll let Mr. Yalomachilli lay a foundation if he can, and then if he tenders it, you can object and we'll hear it.
Yes, ma'am.
Go ahead, sir.
Thank you, Your Honor. State's Exhibit 39, what is that?
It's a diagram of the bedroom where Miss Baker was located.
And who created that diagram?
I did.
And does it appear to be a fair and accurate depiction of the diagram that you created?
Yes, sir, it does.
And Judge, I move to tender 39 at this time.
Okay, Mr. Cruz.
I would object to the hearsay in the document.
Okay, and tell me what you mean by that objection, and then Mr. Yalomachilli, you can refer to it.
Sure, just the descriptions.
Okay.
If I remember correctly, may I see it? Yeah, just the descriptions, that's all.
Mr. Yalomachilli, any response?
Judge, I think that the descriptions suggest that this is a demonstrative aid and it was created by Lieutenant Leadall to depict the bedroom that he was in. It's not hearsay, it's his statements as a testifying witness about what each of these things in this document are.
I'm going to overrule the objection and admit it over objection.
39 and 40, Your Honor.
We haven't gotten to 40 yet.
Yes, ma'am.
State's Exhibit 40, Lieutenant Leadall, what is that?
That is also a diagram of the bedroom where Miss Baker was found, and it includes measurements to the location from reference points to certain areas on the body, as well as other pieces of evidence in the room.
And when you say measurements, who is making those measurements?
I did.
Okay. And does that appear to be a fair and accurate depiction of the diagram with measurements that you created?
Yes, sir, it does.
Judge, I move to tender 40.
Any objection, Mr. Cruz?
Yes, ma'am, just hearsay to the descriptions.
All right, anything further, Mr. Yalomachilli?
Same response as 39, Judge.
I'm going to overrule the objection and admit it over objection.
And may I publish 38, 39, and 40 to the jury?
You may.
Thank you, Judge. So, Lieutenant Liedall, starting with, oh, froze up on me. Okay, there we go. Starting with State's Exhibit 38. I would like you to start at the bottom of that diagram, and would you please just describe for the jury the layout of the residence at 160 Fawn Drive?
The layout, starting at the bottom, is the entrance into the front of the residence. And as you enter into the living room area, you'll locate two bedrooms to your left as you walk in, and one bedroom to your right, as well as the living room area. It also depicts the restrooms and the closets related to each bedroom. And then as you go farther into the diagram, you'll enter the dining area, and it's a floor plan of the kitchen area, the laundry room, and also shows a third bedroom and a rear entrance or exit, however you look at it, to the residence. Also located when you walk in the front door to the right is a bedroom, just off the living room, the bedroom, and it has its own bathroom.
As it relates to the video that we just saw, obviously depicted in that video was Miss Baker's body. Which bedroom is it that was located in?
She was located in bedroom number 3 in the upper left-hand corner of that diagram.
All right, thank you. Now going forward to State's Exhibit 39. I'm going to point down, obviously there is a human-shaped drawing here. What is that?
That depicts the location of Miss Baker.
All right. And then there is an item that appears to be to the left as I look down of her head. What is that?
That would be a knife that was found on the floor beside the body.
And then moving up towards the top of the document, what is the next arrow pointing towards and identifying?
That is the printer cable and power transformer that went from the printer to the body of Miss Baker, and the cord itself was wrapped around her neck.
And then as we move up, directly up from there, what is that arrow and what is it depicting?
That's showing the footboard of the bed, that it was broken away from the frame of the bed. And then if you continue a little bit farther up there, you'll see the printer where that cable was run to.
And then I'm going to go to State's Exhibit 40. What are we seeing here?
That's the same diagram. The only difference is I've added measurements from various reference points to certain items on the diagram, such as to the location of the body and of the bed, so I could put it back, the scene back together if needed on the measurements.
You mentioned taking a video, and you mentioned also taking still photos. I'm going to hand you. After I show them to Mr. Cruz, what I'm going to label as States 41, 42, 43, and 44. 41 through 44. Take a look at those. Let me know when you've had a chance to review them, and then we'll start talking.
I viewed them, yes.
Starting with States 41, do you recognize that image?
I do.
What is it?
It's a photograph taken of the entrance to 160 Fawn Drive.
And does that appear to be a fair and accurate depiction of the entrance?
Yes, sir, it does.
And I tender States 41, Judge.
Any objection, Mr. Cruz?
No, ma'am.
It is admitted.
States 42, do you mind telling me what that is?
That is also a photograph of the front entrance to 160 Fawn Drive, just taken from a different angle.
Does it appear to be a fair and accurate depiction?
It does.
Move to tender 42, Judge.
Any objection, Mr. Cruz?
No, ma'am.
It is admitted.
And then as to States Exhibit 43, what is that?
That's a photograph of the damage to the front door that was made upon entry.
All right, does this appear to be a fair and accurate depiction?
It does.
Move to tender 43, Judge.
Any objection, Mr. Cruz?
No, ma'am.
It is admitted.
And 44, what is that?
44 is a photograph of the interior towards the right as you walk in to the 160 Fawn Drive. It shows the living room area.
Thank you. Does that appear to be a fair and accurate depiction?
It does.
Move to tender 44, Your Honor.
Any objection, Mr. Cruz?
No, ma'am.
It is admitted.
And Your Honor, I've handed Mr. Cruz a number of other exhibits from the state for him to review. And I would just ask court to be allowed to publish States 41 through 44 for the jury at this time using the element.
Granted.
So States Exhibit 41 being published now. Those hoses or tubes down at the bottom of the doorway there, Lieutenant Leadall, what are those?
Those are the hoses that the fire department used to extinguish the fire.
Now, going to States Exhibit 42. I think you already stated that this is the entryway from a different angle.
Yes, sir.
States Exhibit 43, do you mind restating what that is?
That's a photograph of the lock and the handle on the front door, showing the damage from the exterior side of the door.
And States Exhibit 44, what is this again?
That's as you enter in the front door. It's a view of the living room to the right all the way to the rear exit of the residence.
Let me see. A little more light might be helpful. Lieutenant Leadall, there on the coffee table, what are we seeing?
You see some books, and you also have some, appears to be dust and soot, and possibly some fiberglass insulation on the table.
Okay. And so when you made entry into the residence and you were walking through, can you describe for the jury the condition of the residence outside of Miss Baker's room, but the remainder of the residence as you walk through it?
It was kept very well. However, it did have a lot of sooting and dusty damage as a result of the fire and the debris from the fire, as well as some water damage, and also showing in this case insulation and some drywall from where the fire department had to open holes into the ceiling and pull some of the sheetrock down to vent up into the roof.
And so I'm going to skip around a little bit as Mr. Cruz reviews the other photographs that we're going to be admitting. What is trace evidence?
Trace evidence is small pieces of evidence or minute pieces of evidence such as hair, fingerprints, fibers, any very small pieces of evidence, even parts of bullet fragments, anything that's minute.
Can environmental factors at a crime scene impact the ability to collect trace evidence?
Oh, yes, absolutely.
Okay, and how so?
Well, like, for example, when you're dealing with fingerprints and you introduce water to an area, that can help wash down fingerprints, or it affects the ability to recover fingerprints, because we typically use a powder to try to recover prints, and the water itself could cause damage to it and prevent you from recovering it. Also, you've got issues where you have, like in this case, the fiberglass insulation, blown insulation falling down. It would make it extremely difficult to recover hairs and fibers and things on the underneath that insulation. And it'd be almost virtually impossible to go through every little piece of fiber insulation to try to determine if there was any trace evidence attached to that. And also you've got temperature can affect, heat and humidity can affect the ability to recover fingerprints, and it also does damage to other items and makes it extremely difficult to recover trace evidence.
Did you end up processing this scene for trace evidence?
Yes, sir, we did.
Were environmental factors, I'm going to use the word factor twice, but was the environment a factor in trace evidence processing in this case?
Very much so, yes.
Okay. What is a known sample?
A known sample is a sample that you get from a known source, such as an individual, or, for example, if you were comparing paints, getting a known reference sample of the paint that you're to compare with the paint that you're finding, or something to compare with the item that you're collecting at the scene.
Is it important to collect known samples from people who have been at a scene as part of their normal life?
Yes.
Okay. And why is that important?
You can use it for process of elimination, where you can, if you've got known samples of the people that live there, for example, you can use that to compare to the items that you collected at that scene to determine if it belongs to them or if it belongs to an outsider who may not typically have access to that residence or that location. So you would want the known samples to do those comparisons to eliminate some of the evidence that or trace evidence that you've recovered, to see what you're left with and to compare it as a possible unknown.
Would it be expected or normal to find trace evidence from people who had been at a scene as part of their normal life?
Oh, yes, absolutely.
Okay. I'm going to hand you now State's Exhibits 45 through 62. And instead of asking you one at a time, I'm just going to let you go through all of them. Just let me know when you've had a chance to do so. Judge, while Lieutenant Leal is doing that, I'm going to hand Mr. Cruz State's Exhibits 63 through 69.
Okay.
these exhibits 45 through 62 that I handed you?
They're photographs of the interior of the residence at 160 Fawn Drive, of the various rooms, as well as the bedroom area where Miss Baker was found.
And do they all appear to be fair and accurate depictions of various parts of that residence on January 19th of 2001?
They do.
Judge, I move that tender 45 through 62 at this time and publish them to the jury.
Any objection, Mr. Cruz? They are admitted. And your permission is granted.
Thank you, Judge. All right, I'm going to start with State's Exhibit 45. I've just put it up on the Elmo. Can you describe for the jury what's depicted in 45?
Yes, sir. That's as you enter the front door of the residence, that is to your right, and it shows the doorway leading to what I've labeled as bedroom number 1 on the diagram.
Thank you. And just for orientation purposes, I'll briefly put back up on the Elmo State's Exhibit 38. You said bedroom 1, is that correct?
Yes, sir, that is.
All right. Then State's Exhibit 46, what are we looking at there?
That's a photograph showing taken from the front door area going directly back to the rear of the residence. To your left would be the entrances to bedroom number 2 and bedroom number 3 where Miss Baker was located.
And I am going to show you 47 now. Is that just a slightly different angle of what's depicted in 46?
Yes, sir, it is.
And 48, can you tell the jury what that is?
Yes, sir, that's a photograph from the doorway entrance to bedroom number 2, which would, as you walk in the front door, that would be immediately to your left.
Okay. And I think the jury has seen the diagram. I won't do the reorientation again. Can we go to State's 49? What is that?
That is also a photograph of bedroom number 2 showing as you walk in the door of the bedroom, it'd be immediately to your right, and it goes back to the bathroom for that bedroom.
State's Exhibit 50, what are we looking at here?
That's a photograph showing the kitchen area and the rear exit or entrance to 160 Fawn Drive.
Okay. And in particular, I'm pointing down at the picture to the bottom here. What is that at the bottom of the picture?
That is soot and water on the floor of the residence from the fire, as well as the firefighters and other personnel walking on the floor, disturbing that soot pattern. So it just kind of mixed everything up.
Would that be something you would consider an environmental factor?
Yes, sir.
State's Exhibit 51, what are we looking at here?
That is a photograph of the entrance to bedroom number 3, which is Miss Baker's bedroom, and immediately to your left is a shot of the doorway going into the bathroom there that enters into that living room that is also shared through Miss Baker's room.
Sir. State's Exhibit 52 here, what are we looking at?
That's a photograph from the doorway as you enter into bedroom number 3 or Miss Baker's room, showing the wall immediately to your right as you enter.
Okay. And I'm going to point down here. What is my finger pointing at there?
That is the computer printer.
There are going to be some difficult pictures. Obviously, we've all seen the video. I'm putting up State's Exhibit 53 at this point. What are we looking at in 53?
That's a photograph showing the position of Miss Baker as she laid on the floor of the bedroom.
Okay. Right here is, what is that?
That is a strap that belongs to either a purse or an overnight bag or something that's immediately below the left hand of Miss Baker.
And it's difficult to see, but I'm going to point here, and then Judge, if I could circulate this picture to the jury. What is that around her neck?
That is the printer cable, the power cable that leads from the transformer of the printer and is wrapped around the neck of Miss Baker.
Judge, if I could, just because it is difficult. State's Exhibit 54, what are we looking at there?
That is also a photograph of the printer that's on the floor, and also you'll see the edge of the footboard of the bed on the left side of that photograph.
And so for orientation purposes, I'm putting State's Exhibit 39 back up. So as you come in the doorway to the bedroom from the hallway, which way would you turn to see the printer that was just depicted in State's Exhibit 54?
You would turn to your right.
All right. State's Exhibit 55, what are we seeing here?
That's a photograph taken from the doorway going straight back to the rear of the room. The door that you see there is the door to the closet. And to your right would be the headboard of the bed, as well as, I believe, a picture frame that's hanging there.
And here, right here at the front of the picture, what would that be?
That's part of the sheetrock ceiling that was pulled down.
State's Exhibit 56, what are we seeing there?
That is also taken from the doorway as you enter the bedroom, and it goes like to a 45-degree angle to the back corner of the room, showing the area where the fire burned through the ceiling into the roof.
And State's Exhibit 57, is that just panning up a little higher?
Yes, sir, that's correct.
Okay. And so here, is that, what are we seeing there?
That's the trees out from the distance. It's a shot. It burned through the ceiling, and it's a shot showing the sky.
State's 58, I'm going to point to the middle of the image there. What is that?
That's a wall clock.
Okay. Did you have an opportunity to observe that wall clock yourself outside of having taken a picture of it?
Yes, sir, I did.
Okay. Was it functioning when you observed it?
No, it was not.
All right. And were the hour hand and the minute hand stopped in any particular location?
They were stopped at 9:32.
State's Exhibit 59, here in the middle here, what is this?
That is the bed spring of the bed that belongs to Miss Baker, and the yellow item that goes across the bed is a fire hose.
Okay. And then State's Exhibit 60, which bedroom is that in?
That is also bedroom number 3, which is Miss Baker's bed.
And then 61, what is that depicting?
Again, that's also a photograph of the entire bed in bedroom number 3, and a little bit of the portion of the bottom shows a portion of Miss Baker's arm.
And which arm, right or left, would that be of Miss Baker's?
It would be her right arm.
Okay. State's Exhibit 62, what are we looking at here?
That's a photograph showing the public, and I'm going to use the word public entrance to the restroom or the bathroom that conjoins with Miss Baker's room.
All right, sir, I'm going to hand you what's been marked as State's Exhibits 63 through 69. If you would, please take a look at those and let me know when you've had a chance to review them. In your honor, I'm handing Mr. Cruz States 70 through 76 at this time.
I'm done.
What are
Those are photographs of various locations inside the residence as you walk into the front door, showing bedroom number 1, which would be immediately to your right as you walk in the front door. In the interior of the room, also a photograph of the kitchen and the stove area and cabinet area to the right and the rear door. And another photograph showing the laundry entrance to the laundry room and the kitchen table. Another photograph of showing the stove, actually 2 of them showing the stove in the kitchen area, and the last one is a photograph showing the kitchen window taken from the exterior of the residence.
Judge, I would, are these fair and accurate depictions?
Yes, sir, they are.
Judge, I move to tender States 63 through 69 at this time.
Any objection, Mr. Cruz?
No, ma'am.
They are admitted.
I move to publish them to the jury.
Granted.
All right, State 63, which bedroom would this have been?
That's bedroom, what I've labeled as bedroom number 1 on the diagram.
Okay.
That's immediately to your right as you walk in the front door of the residence.
And then States Exhibit 64, what are we looking at there?
That is a photograph also of bedroom number 1 showing the entrance to the bathroom that's attached to that room.
States Exhibit 55, we've moved to a different part of the house. Where are we?
That I'm standing kind of at the edge of the living room, dining room, showing a photograph of the kitchen area and the rear exit of the residence.
And States Exhibit 66, what is that depicting?
That's a photograph of the kitchen table area and the entrance to the laundry area of the residence.
And then States Exhibit 67, what are we looking at here?
That is a photograph of the stove in the kitchen.
Can you see anything around the eyes of the stove?
Yes, sir. It's on the front left corner, you can see some charred remains of something on around the eye and along the edge of the eye. It would be the eye on the, I'm sorry, it'd be the eye on the front left corner.
So as you face the stove, the front left corner?
Yes, sir.
Okay. State 68, what are we seeing here?
That is a closer shot of the eyes of the stove and also including that front left eye, showing the items that were there.
All right. And then States Exhibit 69, what is this item?
That's a photograph of the rear, taken from the exterior of the building of the window leading to the kitchen of the residence.
In particular, at the top and on the left side, is there anything about that screen that stuck out to you?
Yes, sir.
And what was that?
The screen appeared to be bent downward along the top and then inward on the side as if someone was put in there to pull it down and away out of the frame.
As you began to process and investigate the scene, or I guess didn't begin, but as you are processing and investigating the scene on January 19th of 2001, was that something that piqued y'all's interest?
Yes, sir.
All right. And so what, if anything, did you do to investigate that further?
Well, that item was collected. It was taken out of the frame, and it was collected to be fingerprinted or processed later because it was wet. It also, we used it to kind of look at how that frame itself was bent and broken.
Okay. Was there any testing done on other, well, that's the wrong question. The testing on this particular screen that was taken, did that yield anything of evidentiary significance?
No, it did not.
As it relates to other screens.
You have an objection, Mr. Cruz?
I would just object to leading. I try not to make that objection too many times, but I just asked them.
All right. I'm going to sustain that objection. Don't lead your witness.
Yes, Judge. Would you like me to re-ask the questions?
Yes, please.
Thank you. Lieutenant Leadall, was the screen collected?
Yes, sir, it was.
Was it processed?
Yes, sir, it was.
What, if any, results were yielded?
There was no identifiable prints or anything found on the screen.
As it relates to the other screens at the home, was anything done to test those screens?
Yes, sir. I myself and another investigator attempted to remove the screen from the exterior side to see how it would pull out. And during that testing, we could not remove the screen without fracturing the frame of the screen somewhere because we had to bend it so far to remove it from that window from the exterior side of the building.
And so how did the screens that y'all tested out removing them compare to the screen that we just depicted in State's Exhibit 69?
They were identical screens made of the same type of material, which I believe was aluminum, and they were approximately the same size from each one of them.
And so after you tested prying them out, did that do anything to those screens?
Yes, it broke them and bent them.
Okay. And how did those breaks and bends compare with the screen that's that we depicted in State's Exhibit 69?
Very similar.
Okay. And I'm going to hand you State's Exhibits 70 through 76, which have already been shown to Mr. Cruz. Once you get done reviewing them, let me know.
Sir, I'm done.
And just kind of collectively, not individually, what are these?
Those are photographs of various items. The screen itself is, or the rear window, and photographs of Miss Baker and the area around her body, as well as the entrance to the bathroom, I believe.
Are they fair and accurate depictions from January 19th of 2001?
Yes, sir, they are.
Judge, I moved to tender States 70 through 76 and asked to publish those to the jury.
Any objection, Mr. Cruz?
No, ma'am.
They are admitted, and yes, you may publish.
State 70, what is that?
That's a photograph of the upper torso of Miss Baker as she was found. It also includes a photograph of the straps that was found on the bag that matched the bag to the left, her left, as she's laying there. And you see portion of the transformer that belonged to the printer there.
State's Exhibit 71.
That's a closer photograph of the cord that went from the transformer to around the neck of Miss Baker.
State 72.
That is a closer shot or another angle of the cord as it's around the neck of Miss Baker.
And State's Exhibit 73, what are we seeing here?
That's a photograph of the broken screen from the window as it enters into the kitchen of the rear of the residence.
And State's Exhibit 74.
That's another photograph of that same screen, but that's showing, as you're facing the screen, showing the left-hand edge of that frame of that screen.
And State's Exhibit 75.
That's a photograph of the window leading into the kitchen, showing the entire screen as it was found.
And this is jumping around a little bit, I'm sorry, but State 76, what are we looking at here?
That's a photograph of the entrance to the bathroom. I call it the public bathroom from the main room, and also the one that's shared by Miss Baker's bedroom.
And when you say public bathroom, I'm just going to put the diagram of the floor plan layout up again. You've testified that bedroom 3 is Miss Baker's bedroom, is that right?
That's correct.
The bathroom in bedroom 3, how many doors does it have?
That has 2 doors. Okay. One that leads from the living room into the bathroom, and then the other one leads, the only way to enter through that one is through the bedroom.
Okay. And so the other 2 bathrooms in the home, how do they differ from the bathroom in bedroom 3?
The only way you can enter those bathrooms is by going inside their bedrooms.
And, Your Honor, I'm going to hand Mr. Cruz State's Exhibits 77, 87. All right, so, I'm sorry, I haven't shown these to you. State's Exhibits 77 through 87, Lieutenant Lee Hall, I'm going to hand those to you now. Sir, haven't had a chance to review these. Do you recognize what they are?
Yes, sir, I do.
Okay. And I don't need you to necessarily describe each of them right now, but kind of in general, where are they pictures from?
Those are photos that are taken inside the bedroom of Miss Baker, showing some of the items of evidence that we collected.
And did they appear to be fair and accurate depictions?
Yes, sir, they do.
Judge, I move to tender 77 through 87 and publish them to the jury.
Any objection, Mr. Cruz?
No, ma'am.
They are admitted. And you may publish.
Thank you, Judge. State's Exhibit 77, what is that?
That's a photograph of the knife that was found near the head of Miss Baker.
Okay. And State's Exhibit 78, what is that?
That's also another photograph of the knife.
Okay. And let me ask you a question real quick. Was the blade on this knife longer than 3 inches?
Yes, sir.
Okay. State's Exhibit 79, what are we looking at here?
That's the photograph of the knife as it was found on the floor adjacent to Miss Baker.
Okay, and so immediately to the left of the knife handle, we see something. What is this here?
That is the right arm of Miss Baker.
Okay, I just want to ask you a question real quick. We see in 79 the knife handle right there, and then we see in 78 knife handle right here. Those appear in the photographs to be 2 different colors. Is there an explanation for that?
That's just the way the light reflected off of it as I was taking the photograph. When I got the photograph, I was holding the knife. It was closer to the camera in the flash, and I was getting actual true color. When it was down onto the ground, it was getting lesser light, and it was just showing a different shade of it.
Okay. When you're taking pictures in an environment, can some of the surrounding colors or the colors in the environment affect the flash?
Yes, sir.
Yes. All right, I'm going to sustain that objection. You may rephrase, Mr. Yalamanchili.
Are there differences in how does a flash affect photographs?
It can affect photographs in different ways by the amount of reflection onto the item that you're taking a photograph of, and then you have items, for example, this where it's a lot of dark backgrounds. It doesn't reflect the light like it should, or as well as if there wasn't anything dark there, and it will change the colors and the hues a little bit when you take the photograph and you print the photographs out, and you get a different color to it, different tints.
And I'm going to put up State's Exhibit 80 at this time. What are we seeing here?
That's a photograph of Miss Baker, and to the left of the photograph, you see the area of the printer cable that's run across and over towards her.
At any point while you were on scene processing the scene, was Miss Baker's body moved?
Yes.
Okay. Who moved it?
Myself and Agent Terry Cooper.
Why did y'all move it?
To take her out to a cleaner area and put her on some clean sheets that we had purchased to check for trace evidence, and to also try to recover fingerprints and have more room to work besides in the room where she was found.
What area did y'all move her to?
To the living room.
Okay. So I'm going to show you now State's Exhibit 81. When y'all, what am I seeing in 81?
You're seeing the head area of Miss Baker and the power cord that's wrapped around the neck.
Had you done anything to the power cord prior to moving her?
Yes, sir. I cut the power cord from the transformer so we could leave the power cord around the neck of Miss Baker for the forensic pathologist to view.
Okay. State's Exhibit 82, what is that?
That is the right hand of Miss Baker.
Okay. State's Exhibit 83, what are we seeing here?
That's a photograph of the left hand of Miss Baker.
Was there anything of significance to you as a forensics detective about her left hand depicted in State's 83?
Yes, there was some wounds, defensive type wounds to the hand.
Okay. And then State's Exhibit 84, what are we seeing here?
That is the leg of Miss Baker. I believe it was the right leg of Miss Baker.
Okay. And in particular, what are we seeing in this area here?
That appeared to be a blood transfer pattern that was on the leg, kind of in the shape of a hand, made by someone touching that leg.
Did you make any effort to try and process that area of her body?
Yes, sir, we did.
What did you do?
We tried several methods of trying to recover that to see if there was any fingerprint ridge detail in it. We used a chemical called TMB, and I apologize, I don't know what that TMB stands for, but it's a reagent that reacts with blood, similar to like phenolphthalein or luminol that's used to detect blood. We also applied Polaroid film to that spot in hopes that the TMB and the blood would transfer the pattern to the Polaroid film and have a chemical reaction. And then we also dusted that film with magnetic fingerprint powder, as well as processed that straight on the skin with fingerprint powder to try to recover fingerprints.
Were you successful?
No, sir.
Okay. We talked about environmental factors earlier. How would the environmental factors at this scene affect, if at all, your ability to process for fingerprints?
Well, fingerprints on the body is very difficult to recover. I've only done it once or twice in my life, and that was doing it during testing on myself. It's never worked out on the scene, but it is possible. In this case, we did not have any luck because you also have environmental factors such as the water from the fire, the heat from the fire. The heat made the skin almost feel dry out to like it was leather. Fingerprints are usually left behind by oils and dirts and stuff from the fingers when you touch a surface. In this case, the heat dries that up, and also it absorbs those chemicals and that water and things into the skin because of the heat. You have the fire department putting the fire out. The fact that the water's there can wash off any of the oils or trace evidence or things on the skin. But it's extremely difficult to recover fingerprints from a body, but it's not impossible.
I'm going to show you State's Exhibit 85, ask you if you recognize that.
Yes, sir, I do.
What do you recognize that as?
That is showing some of the heat damage to the side of Miss Baker.
And then State's 86, what are we seeing here?
That is the right knee and upper thigh of Miss Baker that was burned.
Did y'all process any other surfaces inside of the residence?
Yes, sir, we did. We processed the doors and the window areas looking for fingerprints.
Was there anything of significance that you noted in your processing of the doors and window areas?
We found what appeared to be white marks on the front door near the peephole, as if somebody had taken a cloth of some sort and wiped the area down. We found other areas where you had mostly water damage and things as far as fingerprinting, which fingerprint powder and water, the powder is consistent with baby powder. So when it gets wet, it clumps up and it's completely ineffective in trying to recover fingerprints, so it made it difficult. But we saw areas where it appeared to have been wiped down at some point in time before we added the powders.
Okay. Were you able to recover any prints in your processing of the scene?
We recovered one print that appeared to be a palm print on one of the doors, the interior doors, but it turned out it was unidentifiable.
And I'm putting up what's been marked as State's Exhibit 87. And can you tell us what we're looking at here?
That is a fingerprint that was found on the door. I'd have to look at my report to tell you exactly which door it was. But it was one of the doors inside the residence, I think one of the bedroom doors, if I recall correctly. Yeah, bedroom number 2, which would have been the first door on your left as you walked into the residence from the outside.
You made reference to a print being unidentifiable just a moment ago. Are you referring to this print or a different one?
To this print.
Okay. And I think, I'm sorry, earlier we talked about the APHIS system at the Athens Clarke County Police Department. What involvement, again, did you have with that?
Well, I was the project manager that started the program when we first got it, but then I was the APHIS operator for 7 or 8 years before I was promoted and moved on up, and I had other people trained to do it, and I took more of a supervisory responsibility.
And could you remind the jury what APHIS stands for?
The Automated Fingerprint Identification System.
I want to back up now. We talked about the processing of surfaces for fingerprints. Let's back up to processing Ms. Baker's body in the living room on the white sheets for trace evidence.
Sure.
Were you able to find any trace evidence on Ms. Baker's person?
Yes, sir, we did.
Okay. When we're using the terminology trace evidence, does hair fall in that category?
Yes, sir, it does.
Okay. I'm going to show Mr. Cruz what's been marked as State's Exhibits 88, 89, and 90.
Thank you.
And, Your Honor, if it's acceptable to the court, I was going to hand Lieutenant Leadall States 88, 89, and 90, and then I was going to ask him to open it. I have a pocket knife with me. Is it okay if I hand him that to do that?
It is fine.
All right. Thank you, Your Honor.
It's all right.
First, I'll let you review 88, 89, and 90. And then I'm going to hand you this pocket knife. You mind opening those up? And then before I ask you any other questions about it, I'll take it back to defense counsel for his review. Sir? And Your Honor, Lieutenant Leadall has opened states 88, 89, and 90. I'm handing those to Mr. Cruz. Sir, I'm going to hand you 88, 89, and 90. And if you could, reach inside the envelope marked states 88 and let me know what is inside of there.
It's a sealed envelope with my handwriting on it, depicting hair recovered from the torso of the victim.
Okay. Does that appear, based on labeling, to be the hair you collected from the torso of the victim?
Based on the labeling, yes, that's correct. My seals are still intact, and my initials are over the seals.
And Judge, I move to tender states 88 at this time.
Any objection?
Yes, ma'am.
Go ahead.
Object on the basis of authentication. I spoke to the state. He said that on cross-examination, I could go through the process of authenticating what's in the envelope. So I would ask at this time not to admit the items into evidence, but on cross, I will open it up and authenticate it with the witness, and if the court finds it appropriate, I'll admit it at that time. That's fine.
Thank you, Mr. Cruz. Mr. Yelmichilli, any response to the statement by defense counsel?
It's been appropriately authenticated to be admitted, Your Honor.
I'm going to admit it over objection, but certainly, Mr. Cruz, you can do any of those things that you'd like to on cross-examination.
Yes, ma'am.
All right, you may continue.
States Exhibit 89, same thing.
That is an envelope, again, that has my initials over the seals. That was sealed in my handwriting, depicting the hair that was recovered from the buttocks area of Miss Baker.
And does that appear to be the sample that you collected and sealed in your processing of the crime scene?
Yes, sir, it does.
And Judge, I move to tender 89 at this time.
Any objection, Mr. Cruz?
Just an objection mentioned.
All right, thank you. I'm going to overrule the objection and admit it over objection.
And then States Exhibit 90, same thing.
That is also an envelope that has my initials over the evidence seal that contains the hair that was recovered from the left hand of Miss Baker.
And does that appear to be in substantially the same shape as when you collected it and sealed it inside that evidence?
Yes, sir.
Judge, I move to tender 90.
Any objection, Mr. Cruz?
Only the prior objection mentioned.
All right, thank you. I'm going to admit it over objection, but you certainly can cross-examine when it is defense counsel's time.
Were those the three areas of Miss Baker from which you recovered some type of hair?
Yes.
Okay. And as part of your forensic processing, do you test or identify hair?
No.
Okay. And I'm sorry, Judge, if we could have just a moment. And I'm going to show Mr. Cruz what's been marked as State's Exhibits 91 and 92. So first I'm going to hand you State's Exhibit 91 and ask you to recognize that.
I do.
How are you able to recognize it?
From the markings on the bag, which depicts what's in it.
What is it?
It's the electrical cord of ligature that was taken from around the neck of Miss Baker.
And Judge, I moved to tender State's 91 at this time.
Any objection, counsel? It is admitted.
Trade, I'll hand you State's 92. What is that?
That is a sealed bag that's containing the residue that was recovered from around the eye of the stove in the kitchen.
And how do you recognize it?
It's marked on the bag as what it is, and the identification from the police department with our case number.
Your Honor, I've moved to tender State's 92 at this time.
Any objection?
No, ma'am.
It is admitted.
I'm going to hand Mr. Cruz State's Exhibit 93 at this time.
It's not 93.
This is 93.
Thank you.
That's right. That's 94, 3, and you're on 94.
So I'm going to hand you State's Exhibit 93 at this time. Do you recognize what that is?
It's a box labeled containing the knobs from the kitchen stove from Miss Baker's residence.
Okay. And let me ask you a question about those knobs on the kitchen stove. Where were those knobs when you saw them?
They were attached to the stove in its proper positions, the post that they slide onto.
Okay. And I'm not going to ask you to say anything that anybody said to you, but was it your understanding that they had been that way when firefighters entered the residence?
Yes.
Okay. As far as attached or not attached to the stove?
Both.
Okay. And I don't think we actually labeled this, Judge. I'm sorry. Okay. And does this, well, you've already identified it, sorry. Judge, I moved to tender State's 93 at this time.
Any objection, Mr. Cruz?
No, ma'am.
It's admitted.
Sir, I'm going to hand you State's Exhibit 94 at this time. Do you recognize what that is?
Yes, sir, I do.
And And what is it?
It's the box containing the knife that was recovered near Miss Baker.
And I'm going to move to tender 94 at this time, Judge.
Any objections, Cruz?
No, ma'am.
It's admitted.
Sir, I'll hand you 95. Ask you if you recognize that item.
Yes, sir, I do.
How do you recognize it?
It's got my name on the bag. Is entering it into the evidence room.
Okay. And what is it?
I'm sorry.
What is it?
It contains the wood butcher block holder for the knives that was found on the countertop next to the stove.
And Judge, I move to tender states 95 at this time.
Any objection? It is admitted.
Sir, when you were processing the scene and collecting this evidence, do you recall the brand or manufacturer of the knife block?
If I recall correctly, I believe it was Farberware.
Okay. And do you recall the brand or manufacturer of the knife that was found in Miss Baker's bedroom?
I believe that was also Farberware.
Okay. And Mr. Cruz, did I think you said it's 96? Okay. I'm handing Mr. Cruz states 96. Lieutenant Leadoff, I'm going to hand you now states 96. Do you recognize that item?
I do.
And what do you recognize it as?
It's a bag that's containing the power transformer to the printer, which I cut that portion off that was around the neck of Miss Baker, and this is the remaining portion of it.
Judge, I move to tender states 96 at this point.
Any objection? Admitted.
After you finished processing Miss Baker's body for trace evidence, are you aware of what was done with her body?
Yes, she was placed into a disaster bag and she was transported to the GBI crime lab for an autopsy.
Your Honor, if I could have just a moment to confer with Mr. Bolton.
All right, go ahead.
Lieutenant Leadall, as you were processing the crime scene and also Miss Baker's body, were there any odors of significance?
Yes.
And what was that?
I distinctly remember the smell of the shampoo that emitted from her hair. I don't know the brand name or anything like that, but I can smell it to this day.
Judge, I don't have any other questions for Lieutenant Leadall.
All right, thank you. I think before we, Mr. Cruz, we do cross-examination, we're going to take a break.
I agree.
All right, thank you. So, ladies and gentlemen, we're going to take a break for a little less than 15 minutes. If you'll go into the jury room, there are, of course, snacks there. The restroom, please don't discuss the case. We will be with you at 3:45. Thank you.
produce these.
Oh, for fuck's sake, muted again. I was just showing you the Karen Reid thing. That hearing's on. I said I'm not showing it because I'd rather scratch my eyes out. I know, I don't understand the mute button. I don't get it. Am I still mute? No, it's fine. Fuck off. Oh, for fuck's sakes. How can you say there's no sound? There is sound. There is sound. There is sound now. You're just behind. Hello? Oh, my other laptop's going. I've got two laptops. My other laptop is... I need to mute it. Hang on. Okay. Here we are. We're back. We're back. Oh, right. Okay, I'm with you. I know what you mean now. Right, hang on then. Let me show you that. If I can find it again. Because some people are obviously obsessed. Oh, hang on. There you go. Hang on, let me show you this. Grant's showing it. Grant Smith Ellis is showing it. That's hang on. That is, let me move myself. So that is the whole panel for the Karen Reid hearing. So there you go. That's why. As I say, I'm not covering it. I do not want to cover it. Not my cup of tea. I'd rather cover criminal cases. So, there you go. I showed it to you. Will you watch the Karen Reid hearing? No, I've no interest, Robin. No interest whatsoever in it. Right. I only wanted to show you quickly, people, what it was. So, anyway. Right. Yeah, I'm still going to need to get used to this, what do you call it? This thing. Because I get muted and I got my thing here. So I am muted and the picture as well on screen. Those are two things that I need to get better at. Disregard last comment. We're watching Karen. Oh yeah, no, I answered it. Yeah. No, well, go follow Grant. Grant's a good laugh. I like Grant. Grant's probably the best one to watch it with, or Law and Crime Trials. If you don't want commentary, go and watch it with Law and Crime Trials. But yeah, Grant. I met Grant out in Boston, and he is actually. We had a really good conversation. When I was out there, I don't agree with everything he said and did, but he's actually all right. And he's actually studied in England, in Bath, for several months as well. So, okay. Jugs is back in. I know, sorry, Jugs. Hey, Bad Dazza, you weren't here yesterday. Jugs Jr. joined. Bad Dazza. Jugs Jr. So, Jen's... Oh, I think I still got it here. Here it is. This is Jersey Jen's daughter, Jessica Jugs Jr. There she is, Jessica Dillon. So, there she is. I just redid that again. So, yeah. You weren't here when we had a good laugh. We had to rename her something because of you, Bad Dazza. So, right, is this still live? No, it was not live, so that makes... Let me refresh this. Okay. That is done now. Happy days. I hope you're all enjoying. Oh, yeah, there you go. KD came up with the answer. Just Jugs 2.0. Just Jugs 2.0. That's the name. KD, I forgot KD. I forgot. Credit to KD. Credit to Baddaza for Just Jugs. And credit to KD for Just Jugs 2.0. Dave, you had to take it there, Dave. No, we do not go there. Not with Jen, our beautiful just Jen. It does not matter. We all do this in a bit of a laugh. You had to take it there, Dave. Absolute. Dave, so this judge, this is your type, yeah, Dave? This is your type, Dave. Oh, Marilyn's fine. Just Jugs is fine. I didn't want to insult your daughter, Jugs. Hang on. I know. She did. Fair play to Jersey Jen. You don't like the judge. I thought she's your age. She's a little bit younger for you, I know, but I thought you might like her, Dave. I'm struggling with this. I know Cross might be a little bit better, but I'm struggling with it, which is fine. But I'll just chill out on the couch. Just Jugs 2.0 had a lucky escape yesterday. Yes, she subscribed to the channel. My daughter could take it. There you go. Happy days. That you might regret saying that with Bad Dazza and Dave in the chat, but yes, I'm glad. I just want to make sure she was okay with it before Dave. Obviously, Dave is only saying that in jest, but still, I want to still be respectful to your daughter, Jugs. So, my daughter's friends call me Dirty Dave. Dirty Dave. Oh shit, it's paused again. Right, I need to stop doing that. Okay. Yeah, pretty spot on, as Katie says. Pretty spot on. Your daughter's friends know you too well, Dave. They are spot on with all of that. She would be rolling. Ah, happy days. I'm glad, Jersey Jen. I'm glad. How old is she, Jen? How old's your daughter? And how many children do you have? We had Sherry Berry earlier on. She's got 4 children. Of various ages. Sarah P has got about 20 children. She's been pushing them out bi-yearly. She's she pops one out. She's like, let's get back on it. 9 months later, she pops another one out. Let's get back on it. She's like a machine, Sarah P is. Give the girl one day without raunchy comments to her. Yes. We need to break them in slowly. You can't go straight in and be like, Sarah P's like, oh, hell no. I want action every night of the week. No babas for me. People always think, oh, we can. Just Jen's having a bad day. All the way, and the rest of the week will be gravy. Don't talk about gravy. Last time we spoke about gravy, it was white gravy. People seem to think that I give lovely Sarah P a bit too much abuse. But what they don't realise is she wants more abuse. She's always like, go harder on me. I love the abuse. So, that's why I do it. You have 2 kids. Daughter will be 41 and son will be 39. I had them at 2022. They 420 of this year, so I will be 44. So my sister's 41. You're a bad work day, Jen. Not good. Next question. Is your son and daughter, are they married? Have you got grandchildren? I'm sure, I think you do have grandchildren. I just always get confused. Do you know what? People were saying hello to me the other night in the chat, and I didn't know who they were, because these name changes, I don't know who anybody is anymore. You lot talking fudge packing. Well, it was funny yesterday because they were talking about anal sex and oral and all these things. We were like, well, Bad Daz is not here, and this is his dream right now, and he's not here. We'll keep on rolling. No grants. Oh, okay. Okay. Or did you just put a chat up and delete it or something because he's gone? I thought you just said no grants. Grants for grandchildren. You keep on rolling. Keep on diving. Oh, yeah. Son's engaged, daughter going through divorce. Oh, no, I'm sorry to hear about your daughter. So that means she's single, but does control yourself. So I'm sorry she's divorced, Jersey Jen. But that is Bad Daz's made. That's made Bad Daz's day. That has. You're making up for it today. Who's that, Katie? Oh, Bad Dazza. Yeah. Don't worry about it. Don't worry, Jersey Jen. You're fine. Don't worry, my darling. I knew what you meant, though. I knew what you meant. Congratulations to your son on the engagement. And sorry to your daughter. But if they're divorcing, hopefully she's happy to be divorced. Just don't let her wild in this chat with Bad Dazza here. Bad Dazza's 47, so, you know, if she likes the older man, she's got a 47-year-old in the chat. I suppose, and a 43/44-year-old. And they got Dave, who's 74 as well, so... Marky, I saw Marky Cunningham is going to be 40 before long, and he better be nice. Yes, everyone better be nice to Jersey Jen's daughter. She needs to have a feel of the place first, and then you can show you're nice, and then, you know, unleash afterwards. Oh, does anyone know how long this trial's going to last? That's a good question. Oh, excuse me. Never had any complaints, but Daz, where's Lady Di? Is she still waxing herself or something? I don't know where Lady Di's gone. It's quiet without Erin Hack, isn't it? Until next year, this I honestly will not be covering it that long. I won't lie to you. This trial hasn't grasped my imagination, so I'm happy to stream it, but I'm not really going to be sat here watching it too much because I just can't. You know, it's not grasping. Fuck, you know. That's Sarah P's fault. Sorry, Robin. Sorry. Oshka. No, I haven't paused it. I won't watch it for that long, so I'm good with that. That's fine. That's fine. Yeah, I mean, look, I'll keep watching it for you people, obviously, but yeah, so far I'm not into this. I don't even know what's going on. Openings caught my imagination, but then it seemed to like it's just too much bullshit in between, so sorry. I'm yawning, the old man is snoring. Ba 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 ba. What are we doing? What are we doing? You know, when you get in a world where you just talk shit to yourself, that's the world I'm in right now. That's how I feel about it. I'm just looking forward to Sunday. To the Super Bowl. It's hard to follow when there's 20 minutes of silence during a testimony and they go on a 45-minute break. I know. I didn't even realise that I had it on. Oh, here we go. Right. I think Dave, you would with this judge. I don't think I'd say no, Dave.
All right, Mr. Cruz, Mr. Yelmichilli, Mr. Bolden, you all ready? All right. You can bring the jury in. Thank you.
There's something sexy about her, Dave. She's smartly dressed.
We have a box for you. We left it downstairs, Miss Satterfield.
Oh, they talk about boxes. They must have heard Lady Di talk about her she box and Mexi as well.
Okay. Y'all may be seated. That. All right. You may let them in. I think they want to come in. All right, ladies and gentlemen, you may be seated. Mr. Cruz, cross-examination.
Yes, ma'am. Good afternoon, Lieutenant Lidow.
Good afternoon, sir.
I would like to follow up with you on some things that the state discussed with you. I'd like to show you State's Exhibit 37. Your Honor, is it okay if I approach the witness?
Yes.
Thank you, Your Honor.
Yes, sir.
And you have continuing freedom to walk around the courtroom. You don't have to ask.
Now, we've established that you recognize that photo as an aerial view of the Deer Park community. Is that correct?
Yes, sir, that's correct.
Okay. And I would like to also show you what's marked as Defense Exhibit 12, 13, 14, and 15. And let the record reflect I may have skipped 9, 10, and 11. These are pre-marked. Let the record reflect that I'm showing the state said exhibits.
Mr. Creed. Thank you.
Let the record reflect that I'm showing the witness said exhibits. And Lieutenant Liddell, take your time, look at those photographs. Once you've had opportunity to look at those photographs, just please look up. You recognize Defense Exhibit 12 through 15, if I have my numbering correct, as aerial views of the Deer Park community. Is that correct?
Yes, sir, they are.
Okay, and they're aerial views from different angles. Is that correct?
Yes, that's correct.
Are those photographs fair and accurate depictions of Deer Park and the surrounding area as you know it?
Yes, sir, they are.
Okay, thank you. Have those photographs been altered in any way to your knowledge?
They don't appear to be, no.
Yes, sir. Your Honor, I would move to admit Defense Exhibit 12 through 15 into evidence.
Any objection?
No objection, Judge.
They are admitted.
I'd also like to show you State's Exhibit 47. We've established that you recognize State's Exhibit 47. Is it okay if I approach you, sir?
Yes, sir.
We have established that you recognize that photograph. Is that correct?
That's correct.
I'd like to show you court's indulgence, Your Honor. I'd like to show you what has been marked as Defense Exhibit 9. Let the record reflect that I am showing the State what has been marked as Defense Exhibit 9.
No objection, Your Honor.
May I approach you?
Go ahead. It's fine.
Yeah, I won't be startled.
So I handed you the State's Exhibit and I handed you Defense Exhibit 9. Would you agree that Defense Exhibit 9 is a close-up of the window depicted in State's Exhibit, I believe 27, if I'm not mistaken? I may have that number wrong.
47.
47, please forgive me.
Yes, sir. You're correct.
Okay. And do you recognize that photo?
Yes, sir. It's the photograph showing the window adjacent to the rear entrance or exit, however you want to look at, to the apartment.
Yes, sir. Has that, to your knowledge, or would you have any reason to disagree that that photo has not been altered in any way?
I would agree.
Your Honor, I would move to admit Defense Exhibit 9 into evidence.
Any objection?
No objection, Judge.
Admitted.
Yes, ma'am. And I would ask for permission to publish Defense Exhibit 9 and State's Exhibit 47 to the jury. Thank you. I'd like to show you what is being marked as Defense Exhibit 10. Let the record reflect that I am showing the state what has been marked as Defense Exhibit 10.
Absolutely. Hey.
Lieutenant Leadall, do you recognize Defense Exhibit 10?
I do.
Okay, and you recognize Defense Exhibit 10 as the back door that's depicted in State's Exhibit 47, is that correct?
Yes, sir, it is.
And it's just a closer up view of said door, is that right?
That's correct.
Okay. Would you have any reason to disagree that that photo has not been altered in any way?
It doesn't appear to be altered that I'm aware of.
Yes, sir. Is it a fair and accurate depiction of the back door as you remember it to be?
Yes, sir.
Thank you. Your Honor, I would move to admit Defense Exhibit 10 into evidence and publish same to the jury.
Any objection?
No objection, Judge.
It is admitted and published.
Course indulgence, Your Honor. I'd like to show you what's been marked as State's Exhibit 71.
All right.
Now, in regards to State's Exhibit 71, I believe we saw a prior photo of material from the ceiling that was on top of Ms. Baker and on top of that item there. Is that correct?
Yes, sir.
Okay. And just to make the record clear, the item that I'm speaking of is the power transformer. Where the power transformer is located, once that debris was moved, is that the place that you found the power transformer located?
Yes.
Okay. Your Honor, I would ask for permission to publish State's Exhibit 27 to members of the jury.
That was already admitted, correct?
It was.
Granted.
Thank you. And we've already established that on January 19th, 2001, you went to Ms. Baker's home and you had opportunity to view her body, correct? Do you agree?
Yes, sir.
In regards to the evidence located on and around Ms. Baker's body, there were hairs collected from Ms. Baker's left hand. Is that correct?
Yes, sir.
There were hairs collected from Ms. Baker's body. Is that right?
That's correct.
There was also a hair collected from Ms. Baker's buttocks. Is that right?
That's correct.
And I'm going to get you another pair of gloves.
No, I'm good.
Give me 1 second. Court's indulgence. All right, I'd like to show you what's been previously admitted as State's Exhibit 89, which contains a envelope enclosed, documented as item number 8, hair from buttock. Do you recognize that?
Yes.
I'm going to hand you a pair of scissors. I would like for you to open item number 8 that was within State's Exhibit 89. And I provided you a paper towel for the hair.
Okay. There is no hair in it.
Can you repeat that?
There is no hair inside it.
Thank you.
I'm going to place this back in the envelope where I cut it open.
I'd like to show you what's previously been admitted as State's Exhibit 88. Inside State's Exhibit 88, there's there's an envelope marked number 9, hair from torso area of victim. Are you okay with opening this for me, sir?
Yes, sir.
Fucking mute. So do they know about that in advance then? About the missing stuff? Let's see about this one.
There's no hair inside here.
Can you repeat that for the jury, please?
There's no hair inside here.
So what the fuck? What are we doing? I don't get this. So deliberately there's no way. So they knew that. What are we doing? Oh, fuck. Anyway, welcome, Jessica, to the chat. Just don't pay attention to Bad Daza or to Dave and you'll be fine. You'll be fine. Right. Oh, for fuck's sakes. I've just done this again now. Moved something I should have moved. Right. This is right. What are we doing? What are we doing? Sherry, shh. We're trying to be nice to, we're trying to lure Jessica in and then we'll unleash the the boom. Right. What a piece of shit this thing is.
Can I take a break for a second? Bathroom break, if it's okay.
Yes, you can. Ladies and gentlemen, I'm going to ask you to go into the jury room for a couple of moments. Please don't discuss the case.
Like, what are we doing? They just came back from break. They literally just come back from break. Marky, you behave, Marky. You're all right, Marky.
You may go ahead, Ms. Cruz. Sure.
Like, we literally just started. And he wants another piss. I mean, his bladder must be tiny if he needs to piss after like 10 minutes. Right, what are we doing, chat? What are we doing? This is a missing here. Yes, I think so. Mark, to be fair, Marky is always nice, Jersey Jen. I don't feel like I can call you by your real name, Jen. Not with Jessica here. I get more shy now. Don't want to scare her away, do you know what I mean? Hey, Dave. Boston Dave, Labourers Union, Blue Collar Dave, yes. Just had one. What the fuck? What are we doing? Like, unless he's... Well, I was going to say unless he ejaculated because of no evidence. And he was like, oh my God, this is awesome for us. This is like Liar Liar. The attorney probably goes and kicks his own ass in the bathroom. Yeah, that's a funny one, that is. That is a funny scene. Right. Jen, does Jess know the Just Jug story? Just how much did you preface her coming into chat? Yeah. So, Jessica, do you know your mother's called Just Jugs? And she's called Marilyn, and she's called Jersey Jen, and she's called some other stuff as well. Are you waiting? I just didn't want to say anything because I wasn't sure how innocent Jess was. So yeah, so Marilyn Love JJ's Jersey Jen, aka Marilyn, aka Just Jugs, and now Jess, you were known as Just Jugs 2.0 because you were named that by Katie. So welcome to Just Jugs 2.0. Terrible storytelling. Well, I didn't know. And it came from Bad Dazza. He named your mother Just Jugs, and it's stuck. 38 double D. Dave, behave. Oh my days. I know. I'm just joking. Right. Am I close? Jessica's gone. She's like, fuck this chat, mother. I'm gone. Who's this Bill guy, by the way? Who's this Bill guy you're apparently dating? And all your friends are psychos. But you do have to be weird to be in this chat, to be fair. Am I close? The state said in their opening, I think that one of the hairs belonged to the defendant. I don't remember anymore. Jessica, to be here, you have to have a sense of humour and you have to be a weirdo. So, if you're anything like your mother, you have a good sense of humour and you must be off your tits, weird as fuck. So, welcome. Horse money breaks. I know, lovely, I know. Do you know what, Lee? I don't know. I'll be honest with you, I've switched off a little bit, so I couldn't tell you, my darling. I can't think that far back. It's one poob on the butt, Dave says. There you go. Anything to do with the butt, Dave remembers. Anything to do with that, Dave is all over it. So everybody, just so one pubic hair, okay? Yeah, rock your body. Yeah, everybody, rock your body right. You're right, lovely. I agree with you. What is normal anyway? You're right. You cannot be normal in this place. The rest of the hairs were her boyfriend's, absolutely. You are right, Dave. Again, Dave's on it, people. If you got any questions about the pubic hairs, the butts, and all that, Dave's your man. One of the tours for two, but both had no hairs in the envelopes. Do they say the pube was his? Ooh. Right, are they back? No, they're not. No such thing as normal. No, not here anyway. Sherry Berry, she's not normal. She's here as well. Shout out to Sherry Berry's mother-in-law as well, and husband, especially your mother-in-law. Oh, sugar, I shouldn't be swearing in case the mother-in-law is watching. If you are watching, mother-in-law, Sherry Berry's mother-in-law, I apologise now in advance for my potty mouth.
Please be seated. Mr. Chris, you have the floor.
Thank you, Your Honor. Lieutenant Ledow, did you collect hairs and put them in those envelopes?
Yes,
Okay, so at one point in time, there would have been hair in those envelopes. Is that correct?
that's correct.
Thank you, sir. All right. I'd like to show you what's been previously admitted as State's Exhibit 90, which is hair from left hand of victim. And inside State's Exhibit 90 is a white envelope marked number 10 with a description of hair from left hand of victim. May I approach? Can you open this for me? While Lieutenant Ledow is looking at that exhibit, I would like to mark empty envelope number 8, which is the envelope that was supposed to contain the hair from Ms. Baker's buttocks, as defense exhibit 11. Which I'll separate from State's, I think 27. Sorry, which I separated from State's 89.
Are you asking it to be readmitted, or are you just putting a defense number on the already admitted exhibit? You want it on the envelope?
Correct.
Okay, and it's number 11. All right. So, any objection, Mr. Yeoman-Chili?
I don't have an objection. I think the original larger envelope and its contents have already been admitted. However, I don't have any objection to
All right.
labeling the interior envelope.
I will admit it in that manner.
Yes, ma'am. Also, the envelope that was in State's Exhibit 88, which is the empty envelope containing, well, that would have contained hair from the torso of the victim. I am admitting this as defense exhibit 16, Your Honor.
All right, Mr. Yeoman-Chili, any response?
Just the same response, Your Honor.
All right, I will admit it. Okay, it has been, the whole package has been admitted as State's exhibit, but I will admit it as defense 16 in this manner, without objection.
Lieutenant Ledow, can you tell me the number of hairs that were in State's Exhibit 90?
From this, none. There was 0 in here.
There are no hairs in State's Exhibit 90?
That's correct.
Did you put hairs in the envelope when you sealed it up?
Yes.
Your Honor, I would like to mark as Defense Exhibit 17 the empty envelope that would have contained the hair from the left hand of Miss Tara Baker.
Any objection, Mr. Yellowman-Shilley?
No objection, Judge.
All right, I will admit it in the same manner as before without objection.
In regards to your observation of Miss Baker's home, is it fair to say that you determined that Miss Baker's front door was deadbolt locked before it was opened by firefighters?
It appears that way, yes.
You would agree that there were multiple bedrooms in Miss Baker's home, correct?
That's correct.
And they belonged to Miss Baker's roommates, Miss Ashley, at the time, Miss Ashley Peavy, now Mrs. Ashley Peavy Hall, and at the time, Miss Valerie Lowe, now Dr. Valerie, at the time, Miss Valerie Lang, now Dr. Valerie Lowe. Is that correct?
That's correct.
Based on your observations, none of the drawers in Miss Lang's room appeared to be disturbed.
That's correct.
Based on your observations, none of the drawers in Miss Peavy's room appeared to be disturbed.
That's correct.
Would you agree that Miss Lang and Miss Peavy had jury boxes, computers, and other accessories in plain view within the home?
That's correct. There was.
And, of course, I'm sure we agree on this, none of those items were taken from the home.
That's correct.
You also had the opportunity to walk through the living room and the common area of the homes. Is that correct?
I did, yes.
Would you agree with the statement that nothing was that nothing appeared to be stolen from the living room or common area of the home?
I can't say that with any certainty since I don't live there and don't know what is actually there, but there were items still present.
Do you recall writing a report dated January 21st, 2001?
I do.
You have a copy of that report up there with you?
I do, yes.
Okay. Can you turn to page 3 of 11?
Okay.
Can you read the fourth sentence? And the first sentence ends in burglaries. So the first sentence you'll see is commonly removed in burglaries. Can you read the third sentence from that period?
Some items have been moved after the fire, indicated from markings on the floor.
Read the sentence before that one.
The living room and common area of the residence contain furniture and a television/VCR.
And can you read the next sentence?
Nothing appeared to be disturbed prior to the fire.
Thank you. So it's fair to say that nothing appeared to be disturbed in the living room and common area.
That's correct.
Now, you also then had opportunity, and I believe I provided you with an exhibit, the state provided you with an exhibit as well, but we can agree that you had an opportunity to examine the window in the kitchen area, right?
Yes, sir, I did.
Now, you would agree that the blinds were down on both the window on the door as well as the window in the dining area?
Yes, sir, they were.
Thank you. And I believe you discussed this with the state, but during your examination of the home, you learned that several items had wipe marks. Is that right?
The door area, the front door near the peephole, and other areas, white marks probably from just general cleaning throughout the course of that door being there. I can't say when the white marks occurred, but there were marks there that were picked up when I put fingerprint powder to those surfaces.
So is it fair to say that we don't know if the white marks happened after Ms. Baker's murder, nor do we know if the white marks happened before Ms. Baker's murder?
That would be correct, yes.
And those white marks were present on the stove. Would you agree with that?
I don't recall if there was any on the stove.
Sure. Can you turn to page 9 of 11 of your January 21st, 2001 report, please? And if you will go to the second paragraph, in the fourth sentence from the bottom, that starts with "in processing the front door." Can you read that, please?
In processing the front door, stove, and window sill, markings similar to one wipes the surface with a rag were found. The markings on the front of the door were consistent with a person looking out the peephole and placing left hand on the door. The white mark where the left hand would have been as well as along the door edge. White marks were also found on the window sill in the dining area.
Thank you. Now, when Ms. Baker was found, you would agree that she was completely naked.
That's correct.
There were no clothes around her that were notated in your report. Is that right?
That's correct.
And a towel was not found near her body.
That's correct.
Your Honor, I don't have any more questions for Lieutenant Leadall. Thank you so much for your service. Those are my questions.
Thank you.
Any redirect, Mr. Yellowman-Chili?
Briefly, Judge, Lieutenant Leadall, as it relates to the hairs you collected, did you package those hairs?
I did.
Did you send them to the GBI?
Yes, sir, I did.
Okay. And that would have been for some kind of analysis or testing possibilities. Is that right?
That's correct.
Okay. Do you have any idea what the GBI did with them once they received them?
I do not.
Okay. Does not have any other questions for Lieutenant Leadall? Thank you.
Any requests, Mr. Cruz?
No, ma'am, but I do have a motion.
All right. All right.
Or we could approach, if you don't want to send the jury out, we could approach it.
All right. Okay, that's fine. I mean, I may do that anyway, but you come on up, that's fine. Yes, sir. All right, ladies and gentlemen, I am going to send you into the jury room for just a few moments. Don't discuss the case. Be with you shortly. Thank you. You all may be seated. Thank you. All right, Mr. Cruz, your motion. Go ahead, sir.
I would just like to renew my motion in regards to, and I'll say motion to limine, to admission of testimony that the oral swab B is a vaginal swab. The additional information that I'm providing to the court is consistent with our position of that swabbing and the markings of that swabbing and what Dr. Falzone testified to in regards to the procedure as well as the supervision of making sure items are properly marked and properly identified. As the court saw, we just had, I believe it's 3 envelopes. One was supposed to contain, it was marked to contain, hair from Ms. Baker's hand, and we heard testimony from the Honorable Lieutenant Leadall that he collected it, he put it in the envelope. It is now missing. We also had a hair that was identified that was on Ms. Baker's butt that the Honorable Lieutenant Leadall stated that he put in the envelope. It is now missing. And we also heard about the hair, you also heard testimony about the hair that was on Ms. Baker's chest that the Honorable Lieutenant Leadall secured, packaged up. It is now missing. I would ask the Honorable Court to consider that in regards to our argument regarding the oral swabs. And 23 years later, the state is going to attempt to introduce testimony that these oral swabbings are now vaginal swabs. Thank you for hearing me out, Your Honor.
Thank you. Mr. Bolden, Mr. Yelman-Chile, any response?
Yes, Your Honor. I think Mr. Cruz is confusing the admissibility of the evidence versus I guess the significance of it. It's hard to really understand. I would point out that we had the motion, motion in limine, whatever he characterized it as, when Dr. Falzon was on the stand. But then when I actually moved to tender the exhibit, there was no objection. So there's no contemporaneous objection to the admission of the evidence. I think, again...
Hang on. Mr. Cruz, it's your motion. I'll let you respond when he's finished.
Yes, ma'am.
Respectfully to Mr. Cruz, I think he's misunderstanding the fact that there will be additional testimony about not only the items that Lieutenant Leadoll just entered into evidence, but also those that Dr. Falzon entered. You can't have one witness testify about everything as it relates to the piece of evidence. That's why you tender it and then have them testify. So I don't know what the grounds are that he's asking to move to exclude the exhibit relative to oral swabs A, but they're admitted into evidence, Your Honor.
When I learned about the swabbings today, this is a motion that I brought up as this issue came to my attention. If the Honorable Court is willing, if we come in tomorrow and provide the Honorable Court with cases, and just to clear up Mr. Bowden's, if I misstated anything, so when it comes to chain of custody, the state has to establish an appropriate chain of custody before evidence is admitted. If not, if there's an issue with the chain of custody, and I provide the Honorable Honorable Court with a case or cases regarding this issue, that evidence is to be excluded. We have a chain of custody log. And one of the biggest issues with the chain of custody log is the same way those items were packaged here today. They're the same way on the chain of custody log. And I said, well, maybe because it was improperly marked, they just put it in this way. But actually seeing the packages ourselves, and I should have opened it. I didn't even think about opening it to see if something's actually in the box. I would just ask the Honorable Court to allow us to have a hearing. I'll present the case law. Pursuant to chain of custody, I'll be able to present the chain of custody report to the Honorable Court. And the Honorable Court has already heard the testimony from Lieutenant Leadoll about what he collected and what's missing. And I think it would be appropriate, if the Honorable Court finds that it is appropriate, to allow us to present that issue to you in regards to suppression of any future testimony that is now attempting to relabel swabs that have been documented as oral for 23 years to now say they are vaginal swabs.
Thank you.
Thank you, Your Honor.
All right, so I'm going to deny your motions, Mr. Cruz, and this is the reason for them. You are asking the court to kind of venture into the purview of the jury. There has, first of all, I agree with the state that the evidence you are complaining about with the doctor expert we had this morning was admitted into evidence. The issues that you're referring to right now with regard to any evidence that has been admitted with this witness goes to the weight of that evidence. And the argument you're making about about chain of custody is an argument that you are entitled to make to the jury if you choose to do that. But what you're arguing is the weight of the evidence. And so I'm going to deny your motion, Mr. Cruz.
Yes, ma'am.
All right. Thank you.
One question for you, Your Honor.
Yes.
May I follow up with a couple of questions for Lieutenant Leadoll, separate from our motion, but once the jury comes back out?
So hang on just a second. I'm trying to remember where we were before I sent the jury out. Did you finish your redirect?
Yes, Your Honor.
Okay.
I asked a single question,
Okay.
single question, but three questions, I think.
Right. And I have not yet asked you if you had any recross. Is that correct?
He indicated he did not have recross and thanked Lieutenant Leadoll for his service.
Okay, that's correct. All right, I'm going to deny your motion, Mr. Cruz. Can you bring the jury out, please? I do remember that now.
She is frustrating as a judge. I'll be honest, I don't like her. But also, I think the defense is not really I don't know.
The Honorable Court will allow, if we have an opportunity to call Lieutenant Leadoff back, we would just ask if he would prefer that we allow him to do it via WebEx.
I can add to that, Your Honor.
Okay.
I have no objection to returning back. I would just need enough notice because I live 30 minutes away. And I'm also possibly testifying sometime next week in DeKalb County in a state court case, and I don't know the exact date. So other than that, I'm free and able to come at any time.
Thank you, sir. So the answer to your question, Mr. Cruz, is yes and yes. So Lieutenant Liddell, you are still on call. You are still under subpoena. And I'll let you work it out with your witness if you need to ask the court for permission for a video testimony. I've already told you that you can do that. And so I'll leave that to you to just let the court know whether that's necessary. Other than that, you are free to go, sir.
Thank you, Your Honor.
Okay, Your Honor. May I step out to obtain
Yes.
information?
Yes.
Thank you.
Next witness. You may.
I was muted again. This is the only thing with Streamlabs that I keep muting myself. And I forget that I'm still muted.
That promise. So do you have any problems with that when he's coming back? Is that any issue? Okay. I think we'll do.
Oh, they slowed down. We could just about hear it and then... Who's the other... Who's the other guy with the defense? Because he's not done anything yet. Attorney Cruz and who's the other one?
Ladies and gentlemen, we are going to call a next witness, but I'm going to break today at 5 o'clock. So we're going to get through as much as we can with this next witness, and then I'm going to send you home. So I just wanted you to kind of know the plan. All right, Mr. Yalamanchili, you may call your next witness.
State calls Brian Grove.
Could you get Brian Grove, please?
Brian Grove.
Sir, if you would, please raise your right hand and take an oath. Do you swear or affirm the testimony you'll give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
If you could, please have a seat and state and spell your name for the record.
Brian Grove, Grove.
And Mr. Grove, where are you currently employed?
I'm a fire protection engineer with the Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF.
And how long have you been working for the ATF?
About 26 years.
All right. And if you give me just a moment, my computer's not exactly cooperating with me.
And I.
Dave, I won't lie to you. Why the hell did you let us play this stream? I blame you for this trial.
And if you could, please describe your work experience with the ATF.
I'm a fire protection engineer, so my job is to help ATF certified fire investigators with the science part of their investigations.
What's the, well, you already talked about the role of a fire protection engineer at ATF. What is the field of fire dynamics?
So fire dynamics is the science of fire, kind of the physics of fire, how fires start, how they spread, how buildings interact with fire, how people interact with fire. Anything really dealing with the physics or the science of fire.
And how does your expertise assist fire investigators?
So fire investigators are asked to figure out where a fire started, and then if they can do that, how a fire started. So we get involved with those processes, as well as timeline and some other things.
And so if we could, starting with your undergraduate degree, do you mind going through your educational background?
Sure. I have an undergrad degree, Bachelor's of Science in Fire Protection Engineering from the University of Maryland, as well as a Master of Science, also in the same field from the University of Maryland.
And besides those degrees, do you have any licenses or certifications?
I do.
And what are those?
I'm a registered professional engineer in the state of California.
And what's required to obtain that designation as a registered professional engineer?
So typically you need a 4-year degree from an accredited university, as well as 2 years of work experience under another registered professional engineer. And then you also have to sit for an 8.
Have you ever been a part of any kind of presentations or written any publications?
Yes.
Okay. And approximately how many presentations and publications have you been a part of?
Publications, probably about 10. Presentations, hundreds.
Have you done any teaching in the field?
Yes.
All right. And what topics have you taught on, and approximately how many times have you taught?
So we teach state and local fire investigators, as well as our fire investigators. Those are generally who we teach. Also attorneys sometimes, just on the sort of the science of fire.
And how many cases approximately have you worked involving fire dynamics?
I've been with ATF for about 26 years, say 20 cases a year, so over 500.
And have you previously testified as an expert witness?
I have.
And in what field have you been qualified as an expert previously?
As a fire protection engineer.
And approximately how many times have you testified as an expert as a fire protection engineer?
Over 20.
Okay. Judge, at this point, I don't know if Mr. Cruz would like to voir dire the witness at all.
All right, Mr. Cruz, if you'd like to, you may go ahead.
No questions.
All right, thank you. Mr. Yelmicheli, go ahead.
Judge, I would move to admit Mr. Grove as an expert in fire protection engineering.
Mr. Cruz, any objection?
No, ma'am.
All right, thank you. This witness is an expert in the area of fire protection engineering.
And, Your Honor, would you like me to continue, or?
We have 15 minutes. I'm going to ask you to actually continue. I think it's, we talked about stopping now, but it's only 4:45, so we have 15 minutes.
Okay,
Thank you,
and I
sir.
have
Thank
some
you.
more questions before
right.
we reach that point.
Yes, sir.
How did you get involved in this case?
Special Agent Will Perdue reached out to me and told me about the case.
All right. And
sent me some photos of the scene, a couple of reports, a diagram, and then we talked about ways that maybe we could help with the timeline of the fire, as well as there was an issue of some burn material around the stove and whether or not it'd be possible to ignite textile materials on a stove.
Okay. What is the fire triangle?
So the fire triangle is a way for fire investigators or scientists to organize their thoughts in terms of what do you need to have a flame or fire. And there's three legs of a triangle. One would be fuel in its vapor or gas phase, so this would be solid, but we're talking about like a gas phase. Another would be an oxidizer, which is typically oxygen and air, so we need air to have fire. And then lastly would be heat. Initially that heat might come from a lighter, and then at some point a fire supplies its own heat and you have a self-sustaining reaction.
Okay. What is a fuel-limited fire?
So a fuel-limited fire would be a fire that's limited only by the amount of fuel that can be vaporized. So if you think of a campfire outside, that's a fuel-limited fire.
Okay. And what is a ventilation-limited fire?
So a ventilation-limited fire, at some point, if you take that campfire, let's say a couch, maybe you burn the couch outside, it's a fuel-limited fire. You bring that couch inside, and it gets large enough and it's burned for long enough time that it consumes the oxygen in the room, and then ventilation becomes the dominant factor in the size of the fire.
Well, and that kind of dovetails perfectly with my next question. What is a ventilation-limited fire?
So a ventilation-limited fire, the size of the fire is dictated by how much fresh air you can get to the fire. All fires start out fuel limited in a room, and then at some point they typically transition, and they'll go out unless you open a door or a window fails or something like that to allow fresh air into the space.
Okay. And if you could, would you describe the term heat release rate?
So heat release rate is a term that we use.
I'm sorry, your objection is to foundation?
Yes, ma'am.
And can you elaborate on that objection?
Prior to his questions, the witness has not made any testimony about any of these terms that he has mentioned.
All right, thank you. Any response, Mr. Yellowman-Chili?
I'm not sure exactly how to respond to that, Your Honor. I'm not sure that Mr. Grove could have just, without my having asked a question, started explaining these topics, but it's certainly a foundation based on his knowledge, training, and experience has been laid for him to describe these topics, since he's an expert that's taught extensively in the field of fire dynamics and engineering.
Okay, I'm going to overrule the objection. You may continue.
Okay. Could you please describe the term heat release rate?
Heat release rate is the power of a fire, the intensity of a fire. Really, we're looking at its size. So if you think of like a 60-watt light bulb or a 100-watt light bulb, that's the power of that light bulb. We're interested in the same units for fire, but rather than dealing in watts, we're dealing in thousands of watts, kilowatts, or megawatts, millions of watts.
Okay. Is part of your preparation for testimony after your work on this case, did you create a PowerPoint in order to facilitate a discussion of the
Overruled. You may continue.
Did you create a PowerPoint in order to facilitate your testimony as a demonstrative aid?
I did.
Okay. All right.
Your Honor, before admission of the PowerPoint, can I have opportunity to review same?
Yes.
Or publication, forgive me, before it's published to the jury.
Well, can I see both counsel at the bench real quick? Thank you.
She is she is nothing. She has no control over this trial.
Okay. Okay. Why don't we do that? All right, thank you. All right, ladies and gentlemen, we have decided this is actually a good stopping point, even though I was trying to make use of every single minute before 5 o'clock. I'm going to release you all to go home and come back tomorrow morning at 9 o'clock as scheduled. I want to tell you a few things. Obviously, the same instructions apply. I'm going to continue repeating those. It's important. Please don't discuss the case, of course, with anyone. Please don't do any research or go to any of the locations that you may have heard about. Don't go on the internet, of course, and do any independent research or study about anything you may have heard in court. I do want to talk a little bit about comings and goings of the courthouse. We haven't really talked about that. I really appreciate everybody wearing your juror badge. So certainly it is very important that when you get out of your car to come into the courthouse that you're wearing that. It's very important that everyone in the courthouse knows that you are a juror in a case and that no one can talk to you about the case. So it's very important to keep wearing those. Thank you very much. When you come in the morning for your 9 o'clock hour, please come directly to this courtroom, and we're going to have you go into the jury room. As there are snacks in there and drinks, and Mr. Terrell makes great coffee, and so there'll be coffee in there for you. But please come straight to the courtroom. every day that you leave, you're going to be escorted on the elevator by a deputy. And so as soon as I release all of you, if you'll go out into the hallway, there will be a deputy there waiting to escort you to the elevator. Deputy will ride down with you, and then you can go to your cars. And that's kind of the process we're going to use. Does anybody have any questions or anything they need to tell the court before we go? Very good. Thank you for your service today. I'm going to release all of you. See you tomorrow morning at 9 o'clock. Thank you.
We'll see if they come back. We'll see if they come back on record. It doesn't even seem like they share any of these documents and videos and stuff. Let's have a look to see. Are you going to come back on? I'm going to give you 30 seconds because that's normally how long I last. I struggle to do it now because in order to do it I have to make that less and do it that way and then do it, and you got a top banner and stuff, so right, I don't think they're coming back, otherwise they would have been back by now. Oh, hang on. This sidebar, this little screen.
Everybody going? Everyone may be seated. Thank you.
Here we go.
Just going to wait for that door to shut. Thank you very much. All right. Counsel, we've discussed at the bench. You're sharing whatever demonstrative aid that you have. I appreciate your willingness to go ahead and do that with Mr. Cruz, so you all may take whatever time you need to do that. Is there anything else we need to take up before tomorrow?
Yes, ma'am.
Go ahead.
We have a little bit of time after court. Since these exhibits are admitted into evidence, can me and Attorney Hill and the state, if they would like, open them to see if what they're labeled as is actually inside of those packages?
Tell me exactly what you're referring to, Mr. Cruz.
So may I, Your Honor?
Sure.
The items here, the state's exhibits, I know this is here, but for the smaller items, typically.
Well, Judge, I'm sorry to interrupt, but is it okay if Mr. Grove leaves?
Yes. Sorry. Sure. Yeah. We will see you tomorrow. You're still under subpoena. Thank you, sir.
Thank you.
All right, go ahead, Mr. Cruz. I'm sorry. Oh, okay. No, that's fine. I mean, that's absolutely.
So these items here, I'm just asking if we could just take time, since court is concluded today, just to open them up and see what's in them. Typically, we do it at closing. Typically, during closing, whatever exhibits are admitted, we'll open them. But in case I have any motions, Your Honor, is it okay if I spend time looking at these exhibits today, just opening them and making sure what they're labeled as and what they're identified as is actually in the package?
Mr. Yalnchel, do you care to respond to that request?
Yes, I think it would be inappropriate to open anything that's been admitted into evidence without the jury present here as part of the proceedings or with the witness at the time that the evidence is tendered.
I mean, I think that's the law, Mr. Cruz. You can't do that outside the presence of the jury. I don't know. I guess one of the things I wanted to ask you, Mr. Yalnchel, these have been admitted into evidence, but are you, well, I'll just say it this way also. One of the reasons for the law to be the way it is the state is entitled, since they have the burden and they've admitted those items, to open, if they choose, those items with another witness. I have no idea whether the state is, planning on doing that or not, but that's one of the reasons for the rule. So I would say no to your question. All right. Anything else, Mr. Cruz?
No, ma'am. I'll
Okay.
just look at the
All right. Mr. Yalnchel, Ms. Bolden, anything else we need to take up before I release everybody?
No, Your Honor.
All right, very good. I will see you all tomorrow morning at 9 o'clock. And Mr. Cruz, Ms. Welch is going to come on up, and I'll have her speak with you about a place for you to store all your items.
Thank you.
All right, thank you. Court is adjourned.
This is a shit show. Like, this is all a shit show. I just don't understand this case. How, in some ways, how, if they've all been submitted, then how the fuck do we know what's in them? Yeah, anyway. It is what it is. You see, 8-hour stream, people. I'm done. I'm spent today. It's been a long day. I don't really know what's in this. I mean, I don't get it. The fact that you can submit evidence and there's no evidence, that's shoddy as anything. And obviously it's good for the defense, I suppose, but wow. Okay. Anyway, I blame Dave for all this, watching this bullshit. Enjoy yourselves, people, and we'll see you tomorrow. We're just going to end it there. It's 8 hours. I am tired. It's been a long day, and it's been a frustrating day, if I'm being honest. So we'll see most of you tomorrow. Have a great evening. Whatever you decide to do, behave yourselves. Or if you can't behave, try and be sensible. And enjoy yourself. Be careful out there.